We're on the record in case number 2021-00386, electronic tariff filing of Columbia Gas of Kentucky Incorporated to extend its small volume gas transportation service. My name is Kent Chandler. I'm Chair of the Public Service Commission. Joining me today is Vice Chair Angie Hatton and Commissioner Mary Pat Regan. I would ask, since everyone is appearing in person today, that if you have cell phones, that you please silence them or turn them off. The hearing today is for the purpose of taking evidence in this matter. Before we get started in earnest, I'll take an entry of appearance of counsel for the applicant, Columbia Gas.
Allison Honaker, Honaker Law Office. And then with me, I have Judy Cooper from Columbia.
And for joint interveners, Constellation New Energy and Interstate Gas Supply.
Good morning, Mr. Chairman. Matt Malone for IGS and Constellation, and we've got various general counsel, and then also Jim Crest as a witness. So,
Okay. Thank you, Mr. Malone. You'll be the only attorney, though, presenting witnesses and conducting cross-examination, is that right?
No,
Mr. Deckard will as well?
no,
Okay.
just me, Your Honor, on behalf of
Just
that.
you? Okay, all right. And Ms. Honaker, you'll be the only?
Yes.
And for Zoom Energy Kentucky?
Yes, good morning, Mr. Chairman, Madam Commissioners. Dennis Howard II with Howard Law. Previously was Greg Dutton. I have filed a notice of substitution of counsel that is in the record. I have with me today Brian Green and Victoria Howe, she's also doing it in VJ. I will be yielding the floor to Victoria, and at that point in time, that's all that I can state. Thank you.
Okay. Thank you, Mr. Howard. We took note of the notice of your entry and Mr. Dutton's withdrawal. And for commission staff?
Tino Frederick for commission staff.
Thank you. So I had an opportunity to review the notice, the proof of publication that was filed in this case, along with the motion for deviation. I'll say at the outset that we'll continue with the hearing today in light of, I guess, in spite of the concerns with notice, and the commission will enter a formal order on that motion. I guess I just would note one of the items, I guess one of the items that I guess is of concern in particular to me, Ms. Honaker, and I know you're not the factual witness for this, but that the majority of newspapers in Kentucky are once-a-week newspapers. I'm going to guess, based on my experience at the state, that Letcher, Clay, Carter, Bath, Johnson, Lee, Lewis, Nicholas, Owsley, and Robertson County probably have those once-a-week newspapers. But the request was not sent to the Press Association until July the 14th, when the regulation requires that notice be provided at least 7 days ahead of the hearing. Even if those newspapers received the information on July the 14th, there would be no way they could run it on July the 14th. If they missed it on the 14th, then it would be impossible for them to run, or even on the 15th, frankly, impossible to run prior to 7 days. Is my math?
No, your math's correct.
Okay. All right, thank you, Ms. Honaker. All right, so we'll rule on that motion separately. Are there any other, other than the motion for deviation, are there any other motions or petitions that we need to take up prior to starting the hearing today?
I don't think so, Your Honor.
Okay. All right. At this point, we will move to provide an opportunity for public comment. Pursuant to the information that was included in Columbia's proof of publication of notice, the notice in the newspapers that did run timely indicated that instructions on how to participate or how to provide public comments remotely would be on our website starting yesterday. They were, our website was timely updated to provide those instructions as of about 15 minutes ago, no one had signed up or indicated their interest in providing public comments virtually. So I'll provide an opportunity for anybody in the room who's not associated with the case, that if they would like to provide public comments, now is the time to do so. All right. Seeing that there's not a rush to the microphone, I would note for anybody that watches this either live or prior to the submission of the case, that public comments can be provided at any time while the case record is open. You can provide public comments one of three ways, either through the Public Service Commission website, psc.ky.gov, through email, by emailing psc.comment@ky.gov, or by written comment mailed to the Public Service Commission at 211 Sower, Sower, Boulevard, Frankfort, Kentucky 40602. We ask that in any public comment that you provide, that you provide your name, your address, and the case number, which in this matter is 2021-00386. All right, given that there's no one interested in providing public comments, we'll start with a presentation of evidence. As noted in the, I don't know what we'll call it, the, maybe it's the commission's most recent order, but the order setting forth a process that will be, that will go through, I guess this was entered 2 weeks ago. The order noted that we expected a presentation by Columbia through direct examination, or I don't know that we said it that way, but that's the expectation, through direct examination. And that we indicated that all parties to the case will have an opportunity to present direct testimony concerning their position in this matter, and that we expected everyone who had sponsored schedules, testimony, or responses today to request to be present at this hearing. So I just want to check at the outset, Ms. Honaker, that you're prepared to both do the presentation of the information contained in that July 10th order and to do some direct examination of any of the witnesses as to the applicant's position in the case.
Yes.
Okay.
And for the presentation, we've already spoke with IT. We're gonna have to go into confidential session when we start going through the choice and the non-choice customer bills, because what will be shown is actual customer bills. They're older, they're not current bills, but they will have their personal information on there when she gets into the VPN and does that.
That'll be fine, and you know, of course, we'll just request at the time when you would like to go into public confidential session. I would ask, do you know ahead of time whether everyone with the interveners has signed a non-disclosure confidentiality agreement with the company, where you are content with them staying in the room for the presentation of that customer information?
I believe at least the people who were participating in the hearing the last time did. Mr. Howard probably has not, but we can have him sign one after, if that's okay.
Well, so you're gonna do that initially, like,
Right.
almost at the outset, right?
We're gonna do it at the end of hers, just to kind of go into the confidential session at the end of her direct testimony, if that's okay.
Okay.
The first section, she will be able to show just the actual website, to show where they would go for the tools to find the information, but then when we have to go in to show actual bills, that's when we'll have to do in the confidential
That'll be
session.
fine. So my preference is for us just to go off the record just for a moment so that you can check check with your records and Mr. Howard, anybody else you think you need to discuss the NDA or the confidentiality agreement with, and then we'll come back right back and I'll let you call your first witness.
All right.
Okay. So we'll just be taking a short recess until call of the chair. We're back on? I've been called worse. We're back on the record in case number 2021-00386. Ms. Honaker, would you like to call your first witness?
We call Judy Cooper.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please have a seat. State your name and address for the record.
My name is Judy Cooper. My address is 2001 Mercer Road, Lexington, Kentucky, 40511.
Ms. Honaker, you may ask.
And what is your title with Columbia Gas of Kentucky?
My title is Director of Regulatory Affairs.
And how long have you been with Columbia Gas?
25 years this month.
Did you cause responses today to request direct testimony and rebuttal testimony to be filed in the proceeding?
Yes,
And is it your desire and intent to incorporate those into the record of this proceeding?
yes,
Okay. And you're aware we're here on the Customer Choice Program, correct?
yes,
Could you give us a little bit of background on the Choice Program?
yes. So the Customer Choice Program is unique in Kentucky. It is a program that, I'll go back a little while to explain how it even came into being. And that was prior to 1987. All gas sold to all classes of customers by a local distribution company, which is what Columbia Gas of Kentucky is, as opposed to an interstate pipeline. We're a local distribution company. And I'm sorry if I'm going way too far back. If you'd like me to bypass any of this, just let me know. But prior to 1987, everything was a bundled service. The natural gas wellhead prices were regulated, meaning there were caps on production gas, and the Federal Energy Regulatory Commission regulated both the interstate transportation and sale of natural gas. In 1987, FERC issued Order 436, and, natural gas wellhead prices were deregulated starting, I think, in 1982 or thereabouts. Anyway, that had happened, and then FERC said all interstate pipelines should become common carriers. And so the sale of the commodity natural gas itself and the transportation through the interstate pipeline system were separated. And at that time, large volume customers were beginning to be allowed to purchase natural gas from someone other than their local distribution company. And the Kentucky Commission opened an investigation, which was administrative case number 297, and through that case determined that the 5 large LDCs in Kentucky should offer transportation to large volume customers, and it was left to each LDC to determine the tariff requirements, the volumetric requirements, unique to their own operating system and customers, and those were established by tariff. And that was done, sometime after 1987 and before the mid-90s probably. In the mid-90s, the commission opened an administrative proceeding that was administrative case number 346, that's right, and to look into retail competition that was then available for these large volume customers. And for Columbia, those large volume customers were primarily industrial class customers. And the commission opened an investigation and a stakeholder group to determine if that sort of ability to purchase from someone other than the LDC should perhaps be expanded to customers other than large industrial customers. And through that stakeholder involvement, the commission issued an order outlining the provisions where an LDC could on its own consider offering a retail competition program for customer choice for customers other than large volume industrial customers. There were several recommendations in that administrative case involving how an LDC that wished to consider offering a voluntary program of that nature should bring that to the commission, that a collaborative group of stakeholders should be involved in developing the program. And it was through that process that Columbia in 1999 engaged with a number of stakeholders, the Office of the Attorney General, the Lexington Fayette Urban County Government, the Community Action Council, a marketer that was of course not involved in Kentucky at that time, but was a marketer. And we sought the input of all of these parties and created our customer choice program. Brought it to the commission as a voluntary tariff. One of the tenets, a couple of the tenets, very basic, were that there should be no cost subsidization of the choice program by non-participants. So all of the cost were to be borne by the choice participants or choice marketers in our program. Another of the tenets was that there had to be an opportunity for customers to choose, but there was no guarantee of savings. And that has been, those things have remained constant throughout. The original program was a 5-year pilot. It didn't quite make it through 5 years. In 2004, the program was near terminated, but was with the input again of multiple parties, it was revised a bit. And that program that really went into effect, I guess, about 2005, has been continued with minor changes and multiple reauthorizations upon Columbia's request to continue the program voluntarily. And it is voluntary on behalf of customers too, because we still provide bundled, so the sales and transportation service together. We still offer that service. We're still in the merchant function, meaning we still buy and provide gas to our customers at no profit to us or through our gas cost adjustments. But we also offer this customer choice program. And so now it has come to, the last reauthorization was through March of 2022, and this is the case that is continuing around Columbia's application in that request to continue.
And can you tell us what the original position was, what your application was for in this case when you filed it?
Yes. Our original application was to continue the program as it has been in place for a number of years, since basically 2005, basically. Continue as is for an extension of 3 years was our original ask in our application.
Okay. And was that going to terminate in 2025? Was that what
Yes,
that
March
was for?
31, 2025.
Okay. And then at some point in the case, as it moved forward, you filed some rebuttal testimony. And in that rebuttal testimony, did you say that Columbia would, be okay with a 7-year extension as what was described by one of the intervener witnesses?
Yes, we did agree to that.
And has that
Rebuttal.
stance changed?
Yes.
Can you tell me what the position is now?
Our position now is that we are back to our original application, a request to extend the program until March 31, 2025.
And since this case has been going, do you have any updated numbers regarding like the amount of savings or losses, not savings, that have occurred during the choice program?
Yes, so, and I think a lot of this is in the record already, but since the program, the commission has required, and we have submitted an annual report each year that provides certain data about the program's past history. Since we began this case, we submitted our 2023 annual report in June of this year. The cumulative savings in that report, and I don't have the actual number in front of me, but I believe the annual report is part of the another data response, is a negative $74 million.
And with your original filing in this matter, did you file a customer survey that was done?
Yes, so we actually filed that in a separate docket pursuant to the commission's order, but they were consolidated, so it is now all part of this case.
Okay. And do you recall that there being some questions on there regarding whether or not if a customer learned they were not saving money, would they revert back to Columbia?
Yes, those questions were part of a survey, and that was the second survey that we've done that the commission originally ordered. The first and the second survey told us the questions to ask, and then, yes, so most of the questions, there were some additional questions in the second survey, which was the one that was incorporated in this case.
Okay. And were the majority of those answers that they would be likely to revert back to Columbia if they knew they were not saving money with the choice, if they were participating?
Yes, yes.
I'm sure you don't know the percentages off the top of
I
your head.
don't know
but-
the
okay.
percentages off the top of my head.
And at the first hearing in this matter, do you remember some questions regarding Columbia's efforts in promoting the customer choice program and placement of information on your website?
Vaguely.
And do you remember any questions regarding how much it may cost to move some things around on your website?
Yes, kind of, yes.
Okay.
Probably
Do,
didn't know
do
the
you
answers.
know, I guess I'll just go here, do you know if Columbia actually made some changes to the website and moved that information around since the last hearing?
I do know that we made some changes in November of last year following the September hearing to make customer choice more visible and easier to find on the website. That's what I recall.
Right. And you stated that you filed an annual report in June of '23.
Yes.
Do you know if in that annual report, did customer participation go up or down since your last report?
I did take a look at that. I think it declined somewhat.
But not a significant amount of decline?
No. I think current participation is roughly 13,500 customers, somewhere thereabouts. Yeah.
And do you know if there's more or less marketers participating since the last annual report was filed?
Since the last annual report was filed, well, in 2022 to 2023, so the last annual report, let me say from the 2022 annual report to the 2023 annual report, yes, there was a net decrease of 2 marketers. And, yeah,
Since the 2023 report was filed in June, have you been told that another marketer may be exiting?
yes, that's what I was going to say. Yes, we have been informed just this past Friday that there is another marketer, who is going to exit September 1st of this year.
And so you told us that the current position for Columbia is to revert back to the original ask to extend it to 2025. Can you tell us what the future plans are right now for the choice
Right
program?
now, future plans are that we would come in with an application to terminate the program sometime before, probably a year before March 31 of 2025, so say end of March 2024, an application to terminate the program to provide for an orderly winding down of the program and possible other avenues for customers.
And when you're talking of possible avenues for customers, would that include residential customers or no?
Probably not.
Okay. And do you recall the order that was issued a couple of weeks ago where the commission asked that we be ready to kind of give a presentation on some items?
Yes.
I'm gonna start with like 1B and C because 1A is the one we're gonna have to kind of go into confidential session.
Okay.
So, in 1B, you were asked to show the tools and information on Columbia's website available to customers interested in the Choice program. Could you kind of show us where you would go to on Columbia's website?
Okay. Yes, so this website, can y'all see that? I can see it up here on the screen. Okay. I'm not a technology person. You're fixing to get confirmation of that. This is what the website looks like without having to sign in with any kind of user ID and password. So just open to the general public. So there's a couple of different ways. One, and this is not my computers. This little button rare, the little search, you can type in, well, you should be able, if you're steady enough, to type in customer choice. And is this responsive to the commission's request? This is what you wanted to see, how to do this? Okay, just making sure. Okay, so here, this will show you search results for customer choice, and then you could click on any of these items. So there's a customer choice tab. It also comes up under billing programs. On the home screen, there's what they call a carousel that revolves. And this was the addition that was made, Mr. Chairman, back in November, that we added this piece on the carousel. And then regulatory information, new start, stop is new customers where they can go to find out or about service, so it comes up there. Understanding your bill. And then delivery service is what is the traditional transportation service, so large volume customers. You can also click here on bills and payments, and then under billing programs, there's customer choice. And this will take you, as I clicked on it, to some more information about how to make your choice, and explains a little bit about it. And there is a notice on here, tell me if you want me to go faster or slower, about about a marketer that recently left the program. Here's how to enroll. I think that's part of what was asked in the data request.
Yes.
How to find your current charges. So there's an explanation here that tells the customer how to look and where to look on their bill to see their their current cost of gas, supply. And down here's a little calculator where a customer, that's considering choice can calculate what their price comparison would be. It is preloaded with Columbia's gas cost adjustment, which does change quarterly. They can look on their bill and see how many MCF they use, or use this slider here. It kind of looks like a Ziploc bag slider to me, but it goes back and forth. And then down here are the list of current participating suppliers. These are live links, so you could click on any one of those.
Can I ask real quick?
Yes,
Mr. Cooper, just to, if you could scroll up just for a second,
okay.
practical purposes. I assume you're in charge of the gas bill in your home?
I pay the bill, yes.
Yeah. So, and I only ask because, you know, we do what we do, but it's not like necessarily the people in our lives know what we do or have an appreciation for this. Okay. Do other people that you don't work with have an appreciation, you think, for how many MCF, first off, know what MCF are, right? But have an appreciation for how many MCF they use in a month?
Well, I think that really varies by customer, because some customers don't know whether they have natural gas or not.
Right.
They don't, and I know this from personal experience. So do they know what an MCF is? If they looked, if they look at their bill and they can see their meter and it will tell them what their usage or their consumption is, and it's measured in MCF. And we can see that when we go into the confidential part and actually look at some customer bills, because the meter information is on that, on that bill, so I can point that out.
Yeah.
But in general, if you went out on the street out here and asked people what is an MCF, I mean, if you found two people that knew, that'd probably be a lot. If you found two people that knew what a kilowatt hour was, or a KV, that'd probably be a lot too. I mean, they probably know what a gallon of water is, but,
Yeah, and people don't know what a PEC is either, but.
yeah.
So, I only ask from the perspective of, in a minute, when you log in, can you directly port, or use some other word, directly input, or have the program input, when you're signed in, your average usage into that second category? Or
Well,
into
you can
that-
do that right here.
No, I know you can manually do it if you know the number, but what I'm saying is.
Oh, does it automatically transfer?
That's right.
No.
Okay. Then second, I get that you were about to talk about the live links, but I think we can fast forward maybe just for a second, that if I click on one of those live links, I won't pick on Mr. Malone, but a Constellation live link, hit the link, go to their site, go through, find the 6-month lock, whatever program that you want to enter into, the contract you want to enter into.
Yes.
Then you would need to, in order to compare, you would need to come back, manually type in that amount into this calculator, then either log in and go look at your past bills, or go get a past bill, come back, and then manually enter your MCF amount, and that is how you would compare between what your all's prevailing current price is and the alternative. Or instead of clicking through the Constellation, you could alternatively go to the PSC website where they're all listed, and then manually come back and type in each one of those. Is that right?
Yes, and I was gonna show you how that link to the PSC website works, but it sounds like you may already know.
Well, that's just the table on our
It is,
website
it
that
is.
has the current information, the
Yes,
current
it has-
GCA.
The current, yes, and the offers of the marketers that are a snapshot in time. So we report those the first of each month to the commission, and that's how that information then gets to the commission's website that shows the prices to compare, along with Columbia's gas cost.
Real quick, I'm sorry. Real quick, you all Columbia Gas operates in Kentucky, Pennsylvania,
Yes,
Ohio,
yes,
Indiana.
that's NIPSCO.
NIPSCO. They have a
It's
gas
different.
affiliate?
There
in-
is a gas affiliate,
Okay,
yeah.
Virginia,
Virginia, uh-huh. One more.
Maryland?
Yes,
and
that's
then
right.
used to Massachusetts.
Used to,
Used
yeah.
to. So, how many of those have choice? How many of those are unbundled retail service?
Well,
Ohio,
Pardon me?
Ohio,
Yes.
Pennsylvania. Is Virginia? Do you know whether Virginia?
Yes, yeah, well, so by tariff, Virginia is like Kentucky.
Okay.
Ohio is, a totally unbundled state, but not by law, by commission order.
Okay.
Pennsylvania, I think, is by law. And when I say unbundled at this time, I'm speaking about for including residential customers, not just non-residential customers.
That the commodity is separate from the delivery service.
Yes, yes.
Maryland?
Maryland had a customer choice program, but it terminated. It was terminated.
Okay. By
Can't
commission
tell you
order?
the year.
By order or by law?
By order.
Massachusetts was
I
competitive.
don't even know. I don't
Okay.
know.
Do you know in those other states whether you have to go through this back and forth manual input to determine the comparison?
I don't really know. But I know our websites are
Aligned?
pardon me?
Aligned?
Aligned, yes. They tried to keep them consistent. So,
So I'd like to ask, as a post-hearing data request, whether your old websites in other jurisdictions have something like this. I know, of course, and we can ask in a post-hearing data request as well. I know, of course, like Ohio and Pennsylvania both have websites that are run by the commission that actually, I think, well, I know for a fact Ohio's, for electric, for instance, compares it on the website. So if that's the case, if you all have just depended in those other states on the commission's website, that's a fine answer too. But I guess I was curious what you all do here versus what you all do everywhere else, whether there's incremental, whether there's just an incremental little bit of work to make it apply to Kentucky, or whether it would be a one-off situation to do something less manual for that comparison tool.
yeah, I don't know the answer to that. But you raise a good point when you said the Ohio electric site, the commission runs that price comparison. And I believe Pennsylvania has electric competition as well. That makes, there's not electric competition in Kentucky, and there's no other natural gas utility that offers unbundled service to all of its customers, as we do on a voluntary basis. And that makes a big difference, I think, in the ability to provide customer outreach and awareness.
Yeah, I've got a couple of questions for you about your rebuttal testimony on that subject, so
Okay.
we'll hold off.
Okay.
In the interim, Vice Chair, did you have a question?
Yeah, I was just gonna ask if you have online bill payment, do you still have to go find that and import the units of measurement, or if it's interactive if you're doing online bill pay?
If you're doing online bill payment, now that I do, so I can speak from personal experience. But I'm not trying to look at the calculator to do a price comparison. So this calculator is specific for comparing pricing information. When we go into the confidential section, that's how you have to go. You have to have a user ID and a password and log in, and then your account will come up and you can pay your bill. If you can have paperless billing or not, either way, you can still go online and pay your bill. You can have it automatically drafted out of your account each month. But to do that, you don't have to input anything other than the amount that you want to pay, and
But to
check the
compare and see if you're saving money, the way we were just talking about doing that.
Yes, to compare.
You'd still need to get that off your bill and then
Yes.
enter the number, but you could click on it instead of going to find a number.
Yes, you could, yes, but if you were in paying your bill, when you go in to pay your bill, you can, there's a place where you can click to view your bill. So if you click to view your bill, that would show the MCF and your consumption there. You could pull it out off of that. You wouldn't have to go find the mail and find your bill. Does that help?
Uh-huh.
Okay.
Go ahead.
And then can you,
Okay.
I think there was one more place that you needed to show, if you want to go back to the main page there, click the
Okay.
Columbia Gas of Kentucky logo, it should take you back so you can show the carousel that you were talking about.
Oh, yes, that is what I was wanted to show. Here's the carousel right here, this, and this carousel changes periodically. But there is a customer choice link here that takes you to the same information that we were just looking at.
Can I ask about the start, stop, move? Just what,
Yes.
just to save a
Uh-huh.
question for later?
Okay.
There was testimony on that in this case, start, stop, move, with relation to the choice program. Do you remember that? Well, let me ask you this way. Are you under the impression that when a customer, let's just make up a hypothetical here. Customer moves from West Shore in Lexington to Hamburg. They're gonna have gas service, they have gas service at their current residence, and they are gonna have service when they move out to Hamburg, gas service. If they are a choice customer in downtown, right? In order to move to Hamburg, they have to disconnect, they have to tell you that they're moving, they have to do that process. And then they have to effectively unenroll and end their choice service in downtown. And then they have to subsequently wait to enroll during the next monthly enrollment period with a new choice marketer once they've moved and created service with Columbia in Hamburg. Is that right?
I believe that is currently how it works. I don't think it's always been that way, but that is my understanding that right now, that is the requirement.
Okay, and some of this stuff goes back to like, a lot of my questions, like behavioral, sort of, I guess, sociology sort of perspective on things. So I know you're not an expert on it, but you would agree that the comparison, the process to have to manually compare a second ago creates a lot of friction. There's a lot of back and forth that a person would have to go to find the information, get the information, and then come and compare. Would you agree?
Well, I mean, a lot is kind of in the eye of the beholder. You do have to get the information. If you want to be an active consumer, then you do have to do some research. And part of that is, I don't think it's that hard to find your consumption when because this is online, so you're gonna be online, but I don't think it's that hard, but again,
Let me
it's
ask
a
you this way.
perception and an opinion.
Based on your experience as a consumer, the more steps involved make it less likely a person follows through with an action. Would you agree?
Probably so.
All
I
else
mean, it
being-
depends on it depends on the individual's perception and their opinion though. So what I think and how I look at my choices for my gas or my phone bill and how active I want to be in that, or my mortgage or my insurance or any of those things, how often I want to review those and am willing to invest my time to do that is probably different from how often that you or your spouse is interested.
And I wasn't asking relative to each other. I'm asking
Yeah.
relative to the addition, the counterfactual of adding another step. If I told you, you go through 12 steps and you save $1,000. For every step that I add to save that $1,000, the likelihood that you're gonna wanna go through all those steps is going to be less and less with each step. Is that a fair assumption? I mean, maybe there are a couple of people out there that really just enjoy the additional work, but as a general consumer of a monopoly utility service, is it not your experience that for every additional effort a person has to take, they're less likely to finish the task or to see it through?
I'll say as a general statement, the less work involved for anyone, the more likely it is that they will accomplish whatever it is they want to do, because who doesn't like
And
something for free?
the other side of the coin is you're more likely to have people accomplish a task the easier that you make it.
Probably.
Okay, so you've got all the additional efforts, many, few, whatever you want to describe it, but the efforts that you have to go through just to compare up front, okay? And then the other efforts that we discussed where if you move from one place in Lexington to another place in Lexington, you have to not just go through the utility and do a start-stop in terms of delivery service, but you have to unenroll, take gas service from you, and then wait until the following time to sign up. You have to shop again, wait again for the new enrollment period, and then enroll with a new marketing program. Is that right?
No, I think if I think that you're able to call your selected marketer and advise them of your transfer of service, and then they will take that step to unenroll you and re-enroll you, but they can do that on the same date. So you don't have to return to Columbia's sales service.
You're saying you think that you can immediately take service at the new address using the marketer's gas and not Columbia's?
If the marketer submits the unenrollment and then the re-enrollment, I agree it is a two-step process.
Okay.
But those two things may be submitted on the same date for the same enrollment period. And it's timing involved, but it's not an absolute that you have to return to Columbia Sales Service.
Okay. Ms. Honaker?
All right, and so I think you've shown us all the places on the just general website where you can find choice, is that correct? You can do it from the search menu, you can do it from the bills and payments, and you can do it from the carousel that goes through.
Yes.
Okay. And then item 1C, and I think we've talked a little bit about this already, but it asked for you to take them to where a customer would go to access choice marketer pricing, how they would calculate example bills to compare to your rates. Do you want to kind of walk us through that, how to get to the commission's website from your all's website, those types of things?
Sure. So I clicked on, again, this customer choice. I went through it through bills and payments, and I clicked on customer choice. And here in the how to enroll, it says our suppliers are listed below, but here's the link to the PSC's website. And if you go,
You have to wait. It's fine.
Oh,
It's
sorry.
delayed. No, you're fine. You go to where you need to go, but it's, there's a delay in it.
should I try again?
I would explain where you're going and then just go to it so that you can see it once you get there.
Okay.
It's not moving.
So I clicked on the link that said, compare offers to the Kentucky, and it's Kentucky Public Service Commission, and it's blue, so you click on it and it just goes there. It looks like this.
Yeah, so let's take a second, and ask our IT folks to come out. The issue is I think you're sharing a very specific browser page, and it's opened up a new link, and that's maybe not necessarily the page that you're sharing, so hold
Okay.
on one second.
Can you go back to the share and see if it's in the list where you can drop it down?
There it is. Make it yours.
I to share, this is not confidential. I want to share this.
Okay, so if you go back to go. Share.
From here,
Yeah. And then it should be that.
that one right there.
Yeah. There.
Okay, thank you. Okay, so if you click on that link, it immediately goes to this page on the commission's website. You can get to this page on the commission's website in other ways as well. If you just go to the psc.ky.com and click on For Consumers, you can get to it that way. But once on this page, then you click on Approved Marketers and Rates, and this is where the information that Columbia submits at the beginning of each month appears on the commission's website. So here are the participating marketers and the offers that were available at the first of the month. Again, it's a snapshot, so a picture in time, and these may change at any time. The marketers are not regulated, so they can change their offer hourly, daily, weekly. It's solely up to them, but we report at the beginning of each month based on looking at the offers that are available. And then there's also links here, so you can click and go to each of these marketers. I will say that the website does have a couple here that it says no offers. They are actually no longer participants. They just haven't come down off of the website yet. And those are Volunteer Energy Services and Kentucky United Energy. So those two should be removed. And the others that say they don't have an offer just didn't have an offer available at the time that we checked for this month. And these are July, what we reported 1st of July.
And then if you're able to go back and share your screen again and go, I think you've shown the calculator, but I'm not sure if you wanted to walk through what you have to do to calculate that, or are you?
My understanding is you just move the Ziploc sealer and you input what you think the alternative price is, right?
Yes.
Yeah, and I know she discussed that when she went through, but I just wanted to make sure you didn't want her to do some sort of a calculation. So I think that does everything that was requested in 1B and C of the order. So I think now we're gonna have to move to go into confidential session so that we can go through the steps for 1A for the customers.
Candace, will you move us on to confidential session?
May I approach? I'm gonna remove one computer and let her
You may.
do her other.
Chairman.
Ms. Honaker?
Nothing further.
No more
Witnesses
direct
available for
examination?
cross.
Mr. Malone, any cross-examination of Ms. Cooper?
Sure, Your Honor. Ms. Cooper, thanks for being here today. I wanted to kind of walk through a few things. As I reviewed your testimony from September, the last time we were here for the hearing, I wanted to ask you a few things. You started off today by talking a little bit about that, for example, the annual report, that in the aggregate, there was an emphasis that there was a negative $74 million aggregate number. Do you recall during the previous hearing also pointing out that you didn't know about any one individual? Do you-
Yes.
Yeah. So-
Yes, still a true statement.
Okay.
Yes.
So in other words, it's, Columbia may have presented an aggregate number, but you don't know about a separate individual that may have hopped in and out of the market, or may have only been there for 12 months, may have only been there for 6 months.
Absolutely.
Okay.
Yes,
And you also don't know about, I believe you said, any individual marketers and their product versus Columbia's variable rate.
I don't know, what's the question?
I'll move on.
Okay.
Okay. In looking at, I didn't ask any questions about the billing on the confidential portion, but I wanted to just kind of talk a little bit about the rates. Is it fair to say that Columbia's rate doesn't include any green attributes and it's only fixed for 3 months?
Yes, that is correct.
Right. And you don't know about IGS or Constellation with respect to any carbon credit purchases or any of that sort of thing with their products, correct?
That's correct. I do not know what
Okay.
they're purchasing.
So you don't know if there's any attributes associated with, for example, IGS or Constellation's product that may be more appreciated by a customer versus the product offered by Columbia?
No, I don't know.
Okay. In looking at the market overall, one thing that stood out to me before, do you remember what you said in the last hearing about customers and their view of choice in the choice program?
I don't remember my exact words, but I probably should have watched the video. But who likes to watch themselves on screen?
I understand. I'll help you out.
Okay.
I believe you said, I think it is the American way. People want to have a choice whether you use it or not. Do you agree? You may have said that.
I believe I did say that, yes.
Okay. Is that your opinion today?
I still think that it is the American way. People like to have a choice whether they use it or not.
Okay.
Doesn't always mean, though, that as an LDC who is responsible for determining if it's going to offer this voluntary program or not in the midst of other activities that are the obligations of a natural gas distribution utility, that the participation having declined, the savings, although this was not and still is not ever a program about guaranteeing savings. It was about an offer of savings, but still being the only LDC in Kentucky that has offered such a program, there being no other interest, it does, when you step back and take a look, cause you to reevaluate things.
All right, you packed a lot in that statement, so I'm gonna kind of unpack
Okay.
that a little step at a time here. You said, and I've heard this twice now, I'm curious, you have referred to this as a voluntary program on the part of Columbia. You agree that this is a tariff, correct?
Yes, it's a tariff that we offered voluntarily.
Okay. But once a tariff goes into place, then it's treated almost as a law, correct?
It has an expiration date on it.
Okay, so that's the portion that you're referring to as a voluntary, that there would be a termination based on expiration of the program, given the pilot nature of the program. Is that what you're saying?
The tariff as it has been originally offered and in subsequent revisions has an expiration date. Currently, the tariff expired March 31, 2022. The commission's order said that we may continue to offer until further order of the commission. And until this case is final, we won't know the ultimate outcome of the continuation.
Another statement that you made that I want to follow up on is there was a mention of declining participation in the program. Do you agree that there have been periods of time with this program where the participation rate, or participation numbers, I should say, have exceeded 20,000?
Yes, that has happened.
And right now, as I understand it, based on your testimony, you indicated that it's approximately 13,000.
Yes.
Okay. Do you agree that there are, I should say, do you see this as a potential issue from a marketer standpoint, looking at the marketers, that given the limited periods of time that this program gets extended? In other words, when you all come in and say, we want to extend it for 3 years versus 5 or 7, do you agree that the longer period of time would be helpful from a marketer's perspective in offering products for longer periods of time that may be beneficial to the consumers?
I don't know that. I have heard the marketer testimony to that effect, but I don't know the marketer's business plans.
I don't want to ask, obviously, anything that you have spoken to council about, but I also, just for clarity's sake and trying to get to where we need to get, what has changed over the course of the last 20 years that has led to the impetus for Columbia suggesting they want to terminate the program now?
What has changed, I think, is a holistic view, looking now at where we are, that we're still, after 20 years, the only energy provider that offers a choice program to all customers. And I think it just indicates to me that we've tried it in Kentucky. Kentucky's just not there. As other states, there was even in, I think, 2010, the General Assembly passed a joint resolution to look at retail unbundling of natural gas. I don't know if it included electricity or not. The commission prepared and directed the commission to prepare a report, which the commission did and submitted, I think, January of 2011. That's been more than 10 years ago, and still no one else has made an effort to follow our lead. So it seems like maybe it's time. It just seems like we initially asked for 3 years. In my modified rebuttal, was it rebuttal testimony? Yeah. We said 7. The commission, in modifying the settlement, something that we'd been having angst about, I guess, for some time, just made us say, it's just time. We need to move away. And we plan to not do that in a hasty form. That's why we would ask for a period until March of 2025, and we'll file our plans for how we intend and would like to see the program wind down and what other offerings might be available to non-residential customers.
Yeah, but I just want to be clear, Ms. Cooper, what was the impetus for that holistic review that occurred in the 3-week period between when the commission entered its order in this case and the withdrawal of notice, or the notice of withdrawal?
So the holistic review didn't occur just within 3 weeks. Looking back at the program and where we had entered into a settlement, which is now, not part of this, that we step away from that, is my understanding. We don't talk about that any longer. But looking at what is requested by the interveners is a whole lot more, and it requires probably cost that the record says some of the marketers are not interested in paying for, and something that we'd been kind of lukewarm about. It just became a decision that it's time we do something different. And Columbia offered transportation to non-residential customers that weren't large industrial customers prior to the Choice program. So it's not that we don't intend to provide alternate services, but that's all to be determined in the matter for a future case where we would ask to wind down the program and provide those replacements.
I still don't think I have an appreciation for why the holistic review when you had entered into the settlement. You all started a holistic review of whether you wanted to continue the program during the time that you had agreed to a settlement that would have continued the program for something like 7 years?
It was a 7-year, yes.
Why?
As I said, it's something that we have been lukewarm about. But the survey results, you can look at survey results from the 2 surveys that the commission has directed us to perform with our customers. And while the first survey said that larger number of customers would like to have the choice, even if they knew that they weren't saving, and the second survey, that number had decreased. It does provide some mixed messages within the survey that can be interpreted differently. And when we go back and take a look at the savings, and again, it's not been about savings all the time, or none of the time, but as we look at the affordability of customer bills and things to come, and that aggregate number, and as Mr. Malone said, individual customers may have saved, but in aggregate, customers have paid $74 million more than what they would have paid if they had been on Columbia's gas cost. And that
All of that was true when you proposed to extend the program for another, 5 years, 4 years?
we proposed to extend it for 3 years.
3 years. All of that was true when you proposed it 3 years. I still don't think I have from your response what precipitated the holistic review.
When I
What's
say
the shoe that
holistic,
dropped?
when I say holistic review, I may not have used an accurate description, but looking back in the program and where we were and where Columbia sees the horizon going forward, which I don't know what that is exactly, but I know that there are costs that are coming from the mega rule and impacts to customer bills that we need to be cognizant of? And should we still be offering a program for particularly residential customers?
Was this directed at Kentucky? Let me ask this. Who made this decision?
Columbia Gas of Kentucky.
Well, I know, but who personally made the decision?
I was a part of that decision. I wasn't the sole person, but.
And there was nobody from NiSource that directed this review or that indicated their interest in you all getting rid of the program?
No, it was a Kentucky decision. Of course, it was then shared with NiSource.
Okay. And so you're saying that, and this is a term I don't like to use, but I know the industry does, there's a concern about customer headroom, that there would be an unaffordability issue with the things that you all feel like you have to do on the infrastructure side that you can't afford for customers' bills to be higher for other reasons?
Well, we don't use the term headroom, but a concern about customer bills, certainly,
Okay.
is how I would describe it.
All right. Mr. Malone?
Thank you, Aaron. So, just to follow up on a couple of questions that the chairman asked you. So did the holistic review, as you referred to it, did it happen before September 29th or after September 29th, being the 2022 when the hearing was?
The discussions occurred after September 29th.
Because I seem to recall that the commission's order was largely consistent with the settlement agreement, but there was also a requirement of cost tracking that was added. What about the cost tracking caused consternation with Columbia?
The commission requires us to track a lot of costs. The way that we track our cost has not been that to the level of detail of customer choice being a particular activity that we track individual costs for, but we track a lot of costs for a lot of different reasons. So that was certainly not, that was one of the changes that was made, but the other changes that were made were additional rules and procedures that were going to be required about stakeholder meetings. We were not opposed to stakeholder meetings, but the commission required, formalized that a lot more. And the other activities, requirements, if you will, that changes to the program that were suggested, I think those were maybe more detailed in the testimony of Mr. Cavella. Sorry, I hope I said that right. A lot of those things that it looked like the commission was interested in those, or at least interested in pursuing those, and taking those changes with the costs that we know are coming from the mega rule, as I said, and just ordinary inflation that we're all experiencing. It just made us sit back and think, we've been lukewarm on this for some time, and maybe we just need to walk away, which is why I don't know if I can say this since we're off, but we filed a motion to make an orderly plan that was denied. So now our position is that we want to go back to our original application in this case, continue it for until March 31, 2025, and just on the record, to say that Columbia will be planning its application for an orderly wind down of this program and looking for alternatives that would not include residential customers.
So I just want to be clear about your response, because I don't know that it's consistent with the order. So I'm looking at the order here, the commission's discussion and findings laid out settlement modifications. That's what you were referring to, is that right?
Yes,
The first was the frequency of the work group meetings. Is that right?
there were a number of things in there about work group meetings.
Yeah, but the first, I'm reading by the title,
Okay.
frequency of work group meetings.
Okay,
That clarifies that it would be twice a year. I think that was the intent, but the word biannual was used in your testimony on the stand, was that was intended on meeting twice a year, not every other year. Do you remember that?
yes,
Great.
yeah, twice
The
a year.
second was the notice of the meetings. The notice was going to be 7 days. The commission required it to be 2 weeks, 14 days. Is that what you remember?
Yes,
Okay. Then the last is agenda. So the commission said it's of great concern to the commission that every stakeholder have an opportunity to bring issues forward for discussion at the meetings, regardless of the items on the agenda for a particular meeting. And required specifically, that the commission encourages the work group to provide an opportunity at each meeting for participants to introduce issues of concerns, whether or not such issues appear on the agenda. This practice may bring important topics forward in the work group, I'm paraphrasing here, but, and permit the participants to consider the need for gathering additional information. So that's you remember that?
I read the order, yes.
Okay. And then meeting minutes, you remember that? And it just says that you should file the meeting minutes into the post-hearing correspondence in this case?
Yes,
Okay. And then the anticipated filing in 2029, do you remember that?
yes,
And so, all that says is that the commission finds that on or before September 30, 2029, Columbia, Kentucky shall file an application with the commission regarding the choice program and not merely an electronic tariff filing. Do you remember that?
yes.
So what was all the other stuff, the modifications that you were saying on the stand a second ago, located in the commission's order?
Those are modifications.
No, I go, but then
Okay.
you went on to talk about intervenor testimony and that the commission adopted intervenor testimony in furtherance of,
No, I was just, you read, no, I didn't, I'm sorry, I maybe I misstated that. The testimony, looking at holistically, I don't like to use that word, I'm not gonna say that word. Looking at the full picture of where choice is, what looks to be on the horizon by virtue of reading the testimony of the proposals from the interveners, things that they're interested in looking for, that cost money, participation's declining, the cost that could come to bear, if all of those things were even doable, and I don't even know if they're doable. But it just looked like a unreasonable use of, or at least a pull and a tug on resources that seemed questionable in the eyes of Columbia Gas of Kentucky.
that's a fine position for you to take, but that wasn't your response earlier to the question for Mr. Malone. You referenced, I heard 3 different things. The first was the tracking of the cost, which you said, we track all kinds of costs, that's fine, right? I'm paraphrasing
That-
here. The second was the formalization of the work group process. Do you remember that? And
That
those
was
are those-
also, those two things were both in the commission's order, yes.
That's right, and I
Okay.
just walked that, but then you started talking about a third thing that happened in the order, which you felt like the commission was effectively adopting the position of interveners and modifying the settlement. But that's not what
No,
the
that's
commission
not
did,
what
right?
no, I did not intend to say that, to make that assumption, no. That the commission did not adopt any of those things in its order. But those things were all in the testimony and all things that I presume would come up in these subsequent stakeholder meetings
Those were gonna
Doesn't
happen in
make
your
it
all
more.
settlement that you proposed to the commission and that you filed testimony supporting. Right?
Probably. Yes, I would,
So
I would expect so.
I guess, here's what I'm confused on, Miss Cooper. The commission, I'll use your word, formalized that work group meeting, where it required some documentation as to what actually had at the meeting, right? And this is my characterization. Clarified your testimony about the frequency of the meeting. I find that hard to believe that that's a settlement modification, but that's fine. So that you provide greater notice of when you're gonna have the meeting, if for no other reason than we were gonna make sure commission staff was able to attend. That there be agenda, so there's some record of what was discussed. You're in control of the agenda, so making sure that other members of the work group are able to talk about things that they're interested in, instead of you all dictating the conversation. And then a formalized meeting minutes that are provided to the commission so we actually know what happened, that we have some record of it. So those are effectively it, right? So I guess why, let me read it this, let me ask this question this way, Ms. Cooper. With that appreciation and the fact that everything you just said was applicable to the settlement that you all were supporting, putting those, I don't know, 2 or 3 guardrails on how the work group would occur could make some, and then your subsequent withdrawal from the settlement would make one possibly think that you all intended on the work group of effectively, how do I say this? That you all didn't intend anything to come out of the work group. Why wouldn't I think that? Given your statement a minute ago that specifically, you thought that with these additions, that the work group might be cumbersome and require additional efforts that, maybe resources that the company didn't previously intend on allocating to the work group. Why wouldn't I think that?
Again, I think it's a matter of perspective. I think there was something else, and I don't have any of this in front of me, so I'm going off of memory. There were provisions about voting by the work group, and I don't recall those specifics. I don't know right now if that was a modification or not, off the top of my head. But the work group and Columbia's willingness to engage in stakeholder discussions was never intended to be with a presumption that nothing would come of it. Now, the expectation of how much might come of it could differ, because Columbia will be looking at it from a cost perspective, a customer's perspective, a capability perspective in terms of what we might or might not be able to do. And it seemed that the intent was to maybe more, it seemed that there, and again, this wasn't stated, this is a perception. So a lot of things about this program are perception and opinion. So this will fall into that category. But the ability of Columbia to exercise what heretofore has been its obligation to administer the program to the best for its customers and its company resources seemed to like that might be diluted by the actions of the requirements for, not that that was the intent. Again, I'm not saying it, the order said that, but it seemed like there was more administrative burden being placed, or it, not burden, the control that Columbia has over the program and its, which is Columbia's obligation through its tariff, and that's how the commission oversees this program, is through Columbia's tariff, because Columbia is the regulated entity and the marketers are not regulated. But it seemed, I'm searching for the word I want to use here, the stakeholder group could, by potentially be in a position of trying to force Columbia into a position that it might not find in the best interest of its customers or the management of the program, or to be, quite honestly, cost-effective.
How so? Can you give me an example of what would give that implication?
It was our reading of the changes in the order combined with the testimony that had been presented and which we had agreed to in settlement to consider, but it seemed that more weight was being given to or greater likelihood to cause some of those things to, and I don't, specifically, there were a number of things, and so specifically, it wasn't any one thing.
Okay.
It was a perception.
Okay.
I'm gonna
You-
go back.
You keep saying
to
perception, and, okay.
Yeah.
I have the order in front of me. Just gonna go by section. Frequency of the meetings. Can we agree that that has nothing to do with what you're discussing right now?
Yes,
That gave no new indication of anything. Would you agree?
correct.
That was your testimony that the intent was twice a year.
The intent was twice a year.
All right, so take it out of here. Notice of the meetings. The order says 7 calendar days is insufficient time for participants to arrange attendance, even virtually, at a meeting. 2 weeks' notice in advance of a meeting will help foster attendance, which is vital to building a successful working group. Further, the commission finds that commission staff shall receive 2 weeks' notice of GCWG meetings and be provided the option of virtual attendance. So I just ask you directly, did that modification in your mind give you the indication of what you were referring to earlier?
It's not one modification that stands alone. It's all of
I'm
the
asking, does this
modifications in
contribute to that? The question is, did this contribute to that mindset that you're in? 14-day notice versus 7-day notice.
Just the fact that, I think it's more the fact that the commission is stipulating 14-day notice versus 7-day notice. What if the parties have agreed to meet at some time and then all of a sudden something happens and it needs to be shifted? It just seems like it's a very deep down in the weeds kind of requirement that to us was indicative of maybe more to come. Again,
Okay, that's great.
perception. Maybe the order doesn't say that.
Go ahead. Has the commission dictated what questions you all should ask in the survey that you do?
Yes,
Doesn't that seem like a real deep down in the weeds type of participation?
yes, but
Okay.
that was what the commission ordered.
Well, okay, so then the agendas. So the issue of the agendas. Quote, however, the commission does not wish for an established agenda to be used as a tool to limit discussion. Therefore, the commission finds that any item proposed as an agenda item for a particular meeting, but not included on the agenda for that meeting, shall be included on the agenda for the following meeting unless the proposal is withdrawn. Is that the provision is that one of the provisions that you're discussing when you say you've resulted in this change of mindset for the perspective of the proposal?
Again, it's not one individual thing. It's not even just the changes in the meeting requirements, but what if you wanted to go ahead and discuss it and everybody was there and agreed to it? Why would you have to wait till another meeting?
Well, this doesn't say that. It says that, it specifically
that's
says
what
the
I
commission
said.
does not wish for an established agenda to be used as a tool to limit discussion.
And, go ahead, you read more?
Yeah, and that therefore the commission finds that any item proposed as an agenda item, again, going to the earlier part, this is on the set agenda that was sent out before the meeting. The commission finds that any item proposed as an agenda item for a particular meeting, but not included on the agenda for that meeting, shall be included on the agenda for the following meeting unless the proposal is withdrawn.
So then you're going back to the first part, and by what you've just read, the first part, that it would not be precluded.
Well, the order goes on. It says, given the possible length of time between meetings, which at this point are unscheduled, the commission encourages the GCWG to provide an opportunity at each meeting for participants to introduce issues of concern, whether or not such issues appear on the agenda.
And that would have been Columbia's practice no matter what.
But it wasn't formalized as such, right?
Right, I mean, that's right.
So
It's
does
not-
all this come down to control, that you all want to dictate this program and not a commission order dictate this program?
The commission, whatever we do is subject to the commission's control. We can't offer any kind of a program without the commission's authority to offer a program. Now, the ability to control the agenda and when we send out an invitation to say, can you meet? Is this a convenient date for most of the members, or is it not? Because then trying to find a date when most people can attend, we're not going to schedule a meeting on a date that nobody can attend, but scheduling is a headache for many things. It's problematic, and so, yeah, we can. I think it's the control, not over the program itself. And again, it's not one thing, but the perception that all of those little requirements played into, this is just becoming more than, it made us question. We've been lukewarm about it, and now maybe it's time to say, okay, let's go back and look at where this came through, how it arose, and where it stands today, and maybe it's time to do something different.
So 7 days, being tied from a commission approval for 7 days was fine. Is that right?
Being taught, was that,
Well, so you saw it, explicit commission approval of this entire situation, right? That entire work group situation that committed you all to provide 7 days notice of a meeting. That was fine, right?
that was a provision of a settlement.
That's a fact, but I'm asking you, the company's perspective is that you all were fine with the 7 days notice, right? That's why you you provided testimony in support of that stipulation that included that provision.
Okay, yes.
I guess, I don't understand this, Ms. Cooper. So, we've got this situation here where you proposed a working group with all of these fairly specific provisions, right?
That was an agreement in settlement.
That's a fact.
Let me
That's
see
not
if
an
I-
answer to the question that I asked. I don't understand why it's difficult to answer the question I asked. You proposed this outline of this working group that had 7 days' notice, right?
Did that Columbia proposed, or as part of settlement? That was
I
the
don't-
proposal coming
Ms.
out of
Ms. Cooper, you're
settlement.
splitting hairs that don't exist. You submitted testimony in support of a settlement agreement. That, at that point, was your new proposal. Now, you've withdrawn from it, that's fine. But you proposed it as a witness, right?
Yes.
And it
I support
included
the
7
settlement.
days' notice ahead of a meeting, right?
I believe it did, yes.
So I don't, explain to me the issue between the commission explicitly approving, which is what you requested, a working group with 7 days' notice, and that was fine, but that you feel it was burdensome for a 14-day notice.
I think it's all in the days maybe are not the point here. It's the perception that Columbia had of the commission's modifications and taking a look at the mega rule that has come out, and I don't want to keep harping on that because everybody keeps harping on that, I know. But, and looking at cost moving ahead and thinking about where we are, where we've been, where we've come, the trajectory that we could see, it didn't seem like, and in fact, we didn't think the commission, really was that supportive of the choice program. So, we thought, okay, now's the time to fish or cut bait, and
I'm sorry, Ms. Cooper, I want to clarify, I'll turn it back to Mr. Malone here in a second. The commission approved your settlement, continuing the choice program until 2029, and your perspective, or inside the company's perspective, was that the commission was not supportive of continuation of the program. Is that?
no,
your-
not from that order, not at all. No, I'm not recognizing that order, but thinking about the cost to customers and the fact that we still maintain these annual reports that continue to publish a savings that is now, as Mr. Malone asked me, up to $74 million, that we've gotten to that point that maybe it's time for us to do something better.
All right, Mr. Malone, how many more questions do you have?
Well, I could go for whatever, if you want to take a break.
Well, we don't want you to
from
go
lunch.
for whatever. Only three of us, and sometimes Ms. Frederick are the only ones allowed to go forever.
Yeah.
I assume you have more than one or two questions. Is what I'm
Sure.
asking. Yeah. So let's take a short recess for lunch. We'll come back at 1 o'clock. We'll take a 49-minute recess for lunch, and we'll come back and let you finish your cross-examination.
Thank you.
record in case number 2021-00386. Ms. Cooper, you're still under oath. Mr. Malone, would you continue your cross-examination?
Yes, sir. I'm Cooper. Not to beat a dead horse, but when I was going back through my notes, I reviewed the video from September 29th when we had the prior hearing. And there was a conversation of questions that you had with the chairman, and I had in my notes that, at that point, there was a discussion, and I don't want to put words in anyone's mouth, but it appeared there was some skepticism about the working group, and I believe you made the comment that there was no need for a working group, but it may be helpful. So I guess where I'm going with this is similar to what the chairman's questions for you were. Can you describe, what changed? And are you saying that there's nothing specific, but it was more just the multiple, can you identify specific concerns you have with it?
Specific concerns I have
With the working group
about the working group?
and the way it's been structured by the commission?
I go back to, it's not one thing, it's an overall perception of, and if you look at the order, it does say, I don't have I might have the order here, I don't know. But it's the overall impact of modifications to something that was a negotiated settlement, which I know we're not talking about that anymore, but in conjunction with, as I have said, our obligation to continue to provide safe and reliable service in the most cost-effective manner to our customers. And,
Okay.
yeah, it's not one particular thing, it's everything kind of, a little here, a little there, a little here, a little there, and eventually I don't want to use the word, let me think of a different word. Eventually, it just becomes, it's not one thing, it's a multitude that, that makes you step back and say, whoa.
But there's nothing specific that you're pointing to, correct?
Not one specific thing,
Okay.
correct.
All right. One of the things that you brought up earlier was the suggestion that the overall aggregate number also gave you pause. Is that accurate?
Overall,
Aggregate savings versus not savings for the versus marketer versus general tariff consumer.
yes,
Okay. You've indicated you've been in charge of the director of regulatory affairs for 24 years, correct?
in some role or another, yes.
Okay. And during this time, how long has the choice program been in place?
The choice program started, the-
1999 relatively?
yes, the original application was docketed a 1999 case.
Okay.
First gas was, first month that customers received gas was, I believe, November of 2000. So how long's it been around? 20 of the 25 years so far?
Okay. And would you agree with me that Columbia has filed, I don't know the number exactly how many times to extend the program, but how many times do you think Columbia?
I don't know the number exactly. It was one of those things that I thought, oh, I want to figure that out and look it up, but I haven't, I didn't have the time.
More than 5?
How many?
More than 5 times?
Well, let me think. If we started out in 2000, I know that was a 5-year, but it only went 4 years, so 2000. And all of the duration of the extensions has varied.
Okay.
But I'm gonna say it's generally been in the 3 to 5 year range.
Okay.
So yeah, it's probably been, if we started 20, or 2000, 2005, 10, 15, yeah, it could have been 4 or 5 probably anyway.
Okay. And during those times, Columbia has been tracking numbers on savings versus non-savings the entire time, correct?
Yes.
Okay. What's the impetus now? What has changed that has caused Columbia to look at this from the perspective that this is, something's different versus things 3 years ago, 5 years ago, 9 years ago?
As I said, it's not one thing, but it's a lot of things. So gas cost is a factor, certainly, but we're looking at the overall customer impact and where we voluntarily, I'm going to say that again, sought to offer this program to our customers, and the commission has allowed that to continue repeatedly, but no one else in Kentucky has even considered, as far as I know, certainly no one else has filed an application.
Are your affiliates in Ohio wrong to offer the program?
That's a totally different regulatory jurisdiction. I don't render any opinion. They operate in a different regulatory environment, a different political environment, a different state, and what the state requires, where the state public policymakers want to go. It's a totally different environment. So, I don't know if they're right or not right, but it's just different.
As you go through, I was reviewing your testimony again, and one other thing that kind of popped up as I reviewed it.
Excuse me.
Every time you would file for an extension of the choice program, was there not some sort of internal discussion among your counterparts or colleagues about cost versus revenue versus expenses from the program?
So the cost of the program, when it was originally designed, there were significant costs at the outset, and those were all addressed in the original, probably 2 or 3 orders to cover those costs and address the recovery of those costs for IT requirements and for customer education and for there wasn't really any specific, I'm trying to think.
Let me ask it a different way. I guess where I'm going with this is, when I went back and looked, there was a significant amount of dialogue between you and the chairman relative to, there are certain aspects, for example, the 5 cent per MCF that the marketers pay, the 2 cent for account receivable discount, and then there's a 20 cent amount per bill. You agree those are the 3 revenue sources that you are receiving from the marketers?
Those are yes, those.
Okay.
Yes.
And where I'm going with this, I'm not asking you down to the penny, but I just want you, is it fair to say that Columbia is making more money than it costs to run the program?
Well, I would not agree with that statement. We don't actually track the cost as at this point, so far, for the administration of the Customer Choice Program. That when the program began, it was assumed and built on the foundation, it was built on the foundation that the cost to Columbia that were not new incremental costs. So IT, customer education, those things being new incremental cost. But the fact that people in our gas supply department were already involved in monitoring gas supply for our tariff sales customers and for large volume transportation customers, which was in existence before we had choice, that those people's activities would be, so they would maybe have another marketer or two or someone, but some of the marketers were already suppliers to our large volume customers, so through the large volume transportation programs. So those interactions were already occurring. So there were no incremental people or resources required that created additional cost. The time that might be spent by those folks was already being incurred, and there was no additional cost. They were recovered in base rates. That 20 cents billing fee and the other charges that were designed in recognition of Columbia is going to do all of the billing. It was a recognition that if the marketers had to issue a bill on their own, it would certainly cost them more than 20 cents a bill, based on the fact that back then, a stamp cost more than 20 cents, and it still does. Although now you could do paperless billing, I guess. But that's how the 20 cents came about. And the nickel and MCF was an agreement that the marketers should have some skin in the game, I guess. And so those amounts go to offset Columbia's revenue requirement. And I believe we have provided a data request with those amounts in them.
I think
I
it
don't
was,
know.
I think when I went back and looked, there was a data request that addressed the commercial, not necessarily the MCF amounts of the commercial. That's what the extent of what I could tell. But I guess my point being, you brought up, for example, the 2010 case where we had the administrative case about expansion to other LDCs.
Yes.
And I agree that there were issues, for example, I remember with Duke, in that situation where they had one center that was handling both Kentucky and Ohio if that were to happen with an expansion. I think I'm hearing you say similar things here where Columbia already had folks handling transportation, so there wasn't exactly a duplication of efforts. These folks were already doing these sort of things. So I'm curious, my question is what expenses can you point to specifically? What does Columbia incur from an expense standpoint if they're already doing these things anyway?
Well, what expenses do we incur today or as,
Today's fine.
yeah, so, well, technically the cost of being here, certainly our outside counsel, we would not be incurring those if we weren't here. I can't point to the specific cost because at this point, we don't track those costs. There are, there are call center costs, but we don't track those to say how many are, we know of calls that come in regarding choice. We do track the number, but we don't track the cost. So I can't tell you what the specific costs are because we don't track them. I think I might have missed part of your question though.
Oh, no, that's okay.
Okay.
One thing, it spurred my memory, we were talking earlier about the start, stop, and move. We were talking about that, and I think there was some confusion, and I just kind of want to see if you'd agree with this. From talking to my clients, I understand that when you move, you get a a new account number, and that's needed to enroll, and until you get that, you can't switch, which could take up to a month or longer even. Do you agree with that?
When you move the
In other words, for them to sign up for Constellation, IGS, Zoom, any of them, they have to get a new account number that's needed to enroll, and until you get that, you can't switch. So they have to be on Columbia's service for basically a month before they can do that.
I don't know. I don't know. When the program was designed, it was, the intent was that the marketer service would transfer with the customer as long as they were moving within Columbia's service area and remaining a Columbia customer. But if that is not taking place, I'm not gonna say it's not, things have.
And Mr. Chairman, to the extent that the commission wants that information, I'd just make a suggestion for a post-hearing data request, obviously, so we're not asking.
You're asking me
I
to.
mean, can we ask for the post-hearing? I don't,
Yeah,
yeah.
yeah,
okay,
if
fine.
you ask a question today of a witness and they're unable to provide it, especially if it's documentary evidence, or if the witness has no firsthand knowledge, you're certainly
That's fine.
able to ask them.
I don't
If we
have
could,
any
if you could update that.
Yeah,
in
and
the
so
post-hearing data
let's talk about
request.
that just for a second. So we'll go through the hearing today, and then any questions that you ask that, you know, that either the witness doesn't have firsthand knowledge of and can't answer, or it's a document that you would like, we'll talk at the end of the hearing.
Okay.
And everybody will reduce their post-hearing data request to writing, and we'll set a procedural schedule by a time for all of those to be sought and responded to.
Thank you. And I don't want to beat it at horse, but basically, one of the things you just brought up before was that you could not commit to the fact that the revenue from the program exceeds the cost expenses. Is that what you're saying?
We don't track the cost of the program. The revenues are not significant to Columbia. I don't know if they exceed the cost or not.
And are
But
you
it's
saying,
not-
are you saying that you all have never internalized the numbers in the last 20 years?
To look at the cost,
Or the revenue?
no. I'm not, yes, that's what I'm saying.
Okay.
Yeah, we don't know what the costs are. We can provide the revenues. We know what they are, but we don't know what the costs are.
Okay. I think we're good, John.
Ms. Howell?
It's gonna be me.
Go ahead.
Cooper, it's good to see you again.
You do.
Hope you had a good lunch. Just on, following up on Mr. Malone's last question, the revenues that are received from the three buckets of, the three sources of revenue for the choice program, where do they go? Do they go into the revenue requirement?
Yes, they
So
go to
let's-
offset the revenue requirement.
Okay, so, and would it be safe to say, based on some, admittedly, based on back-of-the-napkin lawyer math, that we're looking at revenues potentially in the $750,000 range, give or take $250,000 a year? Like it's somewhere between 500 and $1 million a year? If you add, maybe,
I don't know what the number is.
okay. But those revenues are tracked, it's just, we don't know, when they go into the revenue requirement and the costs of the program, whatever they might be, or whatever they are, we don't know. That's accurate?
We don't track the cost specific to customer choice.
Okay. I wanted to shift gears a little bit and ask you about the Columbia supply rate, which is the GCA.
Okay.
right? Is that synonymous with what people in the industry refer to as the price to compare? If a customer was comparing the Columbia rate that they would be paying if they remained with Columbia versus what they might be paying were they to sign a supplier contract, would it be safe to say that on the website, that's comparing the GCA rate versus the supplier rate?
Yes,
Okay. And the GCA rate typically changes every quarter, every 3 months?
Yes.
And the GCA rates are designed to ensure that Columbia recovers its costs of purchasing its supply on the wholesale market?
It cover, yes, and over time that the cost collected are the actual cost that are paid by Columbia on behalf of its customers.
It's just trued up over time, right? So if
Trues up
there's an
over
under
time.
collection, we fix that. If there's an over collection, we fix that, and we just go forward the next 3 months, right?
Yes.
So Columbia's always made whole, correct?
Eventually, there are over recoveries and under recoveries, and the idea is eventually it nets to zero.
And in procuring that supply to serve firm sales customers, Columbia has some sort of hedging strategy that is approved by the commission?
We used to, the commission told us that we could no longer hedge financially. There are, we have storage, which is a physical hedge, but financial hedging, we are not allowed to do anymore.
Okay, and is there any portion of that GCA rate that is dependent upon Columbia purchasing gas on the spot market? Or daily market?
I am not the procurement expert, but Columbia's purchases are not planned to be spot market purchases.
But some of them are on the shorter term markets, which can expose customers to market volatility. Would you agree with that?
You're getting a little bit deeper than I know, than I can speak to, because I'm not the expert. There is diversity in that commodity forecast on which the gas cost adjustment is based on our forecasted purchases. And then, as you said, adjustments to true up to the actual cost incurred so that there is no profit. It's purely what we actually have to pay for gas.
Okay, but in the diversity portfolios, some of the purchases you're making are shorter term versus longer term.
Your Honor, I'm gonna have to object. She said she's not the expert here in the procurement, so she doesn't know the specifics of those.
I wasn't,
He didn't ask a very specific question. She said she's not the expert. If she doesn't know the answer, then that is the answer.
okay, I was trying to ask it from a higher level, but I'll move on. So if the GCA is set for 3 months at a time, would it be safe to say that a customer that wants a rate for longer than 3 months would have to get that from a supplier on the retail market? A guaranteed fixed rate on the, let me start that over. Would it be safe to say that a customer that wants a guaranteed fixed price for longer than 3 months would have to obtain that from a supplier on the retail market?
Sitting here today, that is true. However, that is not always the correct answer. There are, in that 2010 commission report to the Legislative Research Commission, even spoke about it could be within the LDC or local distribution company's purview to offer alternatives by tariff under the commission's review that could be fixed rate types of contracts or some other type of variable rate contract.
Okay, but does,
But Columbia does not offer that.
okay, so
today.
in Columbia service territory today, if a customer wanted a fixed supply rate for longer than 3 months, they would have to go to suppliers on the retail market to get that.
If they're less than 25,000 MCF a year
Sure.
consumption,
Sure.
then yes.
Okay.
They could use budget billing to flatten it out, but to get an absolute fixed rate per MCF, your statement is correct.
And today, if they wanted to get a product, and I think Mr. Malone may have asked this question, that was a carbon offset product or some sort of green gas product, they would have to go to the market for that too, because Columbia doesn't currently offer that, correct?
That's correct.
Okay, and if they wanted a product that, say, had other bells and whistles to it, whether it be rewards and dinners and you know, airline miles and things like that. Columbia doesn't offer that, right?
Only through the choice program. If a choice
Right.
marketer offered that, then that is available to them.
Okay,
But-
but not directly from Columbia.
Yeah,
Right,
not,
okay.
not directly from us. And what those are, we would not have any knowledge of because that's not a regulated service.
Okay, and I think from a high level, where I'm going is that, would you agree with me that price competition is one form of competition? Some customers are concerned about price and price only, right?
Well, the survey results that we have done from the 2 surveys, if you were asking me personally, I would say yes. But survey results don't say or can be construed to say differently. So I would say it depends on price, but not everybody's me, but.
Right, some
in-
customers just want the cheapest milk they can find in the grocery store, and other customers want the organic milk and they're willing to pay for it, right?
That's true, but we want the milk to be safe and to be there reliably when the customer wants whatever kind of milk they want. And of course, milk is not a monopoly or a regulated entity, so bless you.
Sure,
So-
no, and my point is that some customers only care about price, but other customers may care about a guaranteed longer-term fixed rate. And they may be willing to pay for that. Would you agree with that?
Yes, and that was one of the benefits that Columbia spoke of when we proposed offering the choice program. Those things are also addressed in the commission's report to the LRC. But at some
Right,
point,
yep.
the cost of doing that for the one person that wants to buy organic milk from California, I mean, do you have to take up freezer space or refrigerator space in the cooler at the grocery store for that supply of that one person's preference? Limited resources ultimately may say, sorry, we're not offering that organic milk from California any longer.
Okay, so let me redirect your attention back to the survey that we keep bouncing back to
Okay.
today and at the last hearing. Do you have a copy in front of you?
I do now, yes.
Okay, could you turn to page 8, please?
Can you hear me okay?
I can.
How do I-
So sorry, let me remove that.
And this is the survey that was
It's on the bottom right, it's page 8, but then
2021.
on the top right, it says page 10 of 26.
Okay, yes, I have it.
Okay, so you see the question there in the middle, what is the greatest benefit you receive from participating in the customer choice program? And 56.3% said getting a fixed rate that's the same each month. Right?
Yes, that's what it shows.
And like you said, the only way they can get that beyond 3 months is to go with a supplier, right?
That's true, but I'd also say that, unfortunately, and let me look and see where I can point you to in here. Survey. Somewhere.
Are you looking for something in particular? Maybe I can help you?
What I was looking for was, I thought it was maybe in the profile of the respondents where customers self-identify as to whether they're a choice participant or not. And I started to say unfortunately, and that is because customers are not 100% accurate in their self-identification as to whether they're a choice customer or not. Even though if they're a choice customer, it's
Yeah,
on their
we're
bill.
gonna talk about that in a minute.
Okay,
'cause
all right,
have
I don't
some
know where that
questions
is,
about
but
too.
that
But then
was,
if you look at page 9 of
Okay.
the survey, which is page 11 of 26, you see the question that says, if you have not saved money, then the person is asked, why do you continue to participate in the choice program? And
Yes, I see that.
40.5% said, I like having a long-term fixed price, right?
yes,
Okay, and then if you
Those
go to page
15
10,
respondents, yes, I see that.
in the middle of page 10 of the survey, the customer is asked, how satisfied are you with your participation in the choice program? And either very satisfied or somewhat satisfied, 57.8%, right?
Doing a little math, 57 point, yes, that is correct. So of these customers who self-identified as being participants, that is, your math is good, I agree with it.
Okay, and then I want to end on page 12 with something that you cited at the hearing last September?
September.
And that's on page 12, in, what is 2.4, all residential respondents? How important is it to you to have the ability to choose from whom you buy your gas supply, whether you save money or not? And 58.7% said it was somewhat or very important, right?
58.7 of the residential total customer base, yes. And I
And I
believe
think
that is down from the previous survey when I believe it was more like 75%. So,
Right, and I think the 58.7% was in the discussion in the last hearing when you started talking about how the right to choose was the American way. And
Yes.
we should all have that ability to choose whether we take that opportunity or not, right?
Mhm.
Okay.
yes, I believe it was. And
So-
as all along, these survey results can be interpreted different ways. You can view it two ways.
Right, and I guess what I'm wondering, and we've talked a lot about this already today, is that Columbia seems to have interpreted the survey one way until about 2 months ago, and then now it interprets it a different way. And I have some questions about that, and I'd like to go through quickly, because I know we talked a lot about this, the timeline, because I want to make sure I have it all, because I think there might be some things that need to be inserted into the timeline from the last year or two. So if I am following everything correctly, in September of 2021, Columbia made the filing that led to this case and asked that the choice program be extended by 3 years to March of 2025, right?
That sounds right.
And so if we did
2021
that,
case.
and that's, we've gone full circle, right? Because that's Columbia's position today.
Yes,
And if we did that, Columbia would have to make a filing in September of 2024? Is that right?
Columbia's plan today would be to make a filing in March of 2024.
Okay, so a year ahead of time.
Yes,
Okay. I was going by the timeline for this case, but if you're saying,
Yes.
so it's now,
to allow the commission more time.
okay. So then Mr. Christ filed testimony recommending that the commission extend the timeline or the program by 5 years to 2027. And in your rebuttal testimony, you said that was okay with the company, 2027, right?
Was my rebuttal testimony part of the? I'm trying to recall if that was,
Your rebuttal was filed on April 29th, 2022.
Tab 34 of your binder's the same as mine.
And I'm looking specifically at page 5, lines 2 and 3, where you say Columbia would be willing to extend the choice program until March 31st, 2027, as suggested by Mr. Christ.
hold on, okay, this is coming to me, hold on. Please. So my statement is, as long and until both electricity and natural gas are widely available across Kentucky from non-regulated suppliers, Columbia's program should not be extended indefinitely, but remain an option created under the rules of the Commission's order in Administrative Case Number 367. In most recent history, the extensions authorized by the Commission have been for periods of 3 years, but Columbia would be willing to extend the choice program until March 31, 2027, as suggested by Mr. Christ. And that would mean it was, going back to the original timing, a 5-year rather than 3-year extension.
Right. Okay, thank you.
Uh-huh.
And then we get to the settlement where the settling parties, which included Columbia, agreed to extend the choice program through March of 2030, right? Which would be a 7-year extension.
Sorry, I just want to check the dates. I think that's right, but I just want to make sure that they're not, as they're rolling around in my head. You said March 31, 2030.
Yes.
Yes, that was a part of the stipulation that has now been gone by the wayside.
And actually, would that be an 8-year extension? In March?
Well, it was, let's see, 2025 was a 3-year extension, 2027 was a 5-year extension, and 3 more years would make 8, yes.
Okay, and then shortly after the settlement was filed, we have the hearing in September of 2022. And you were asked a lot of questions. Well, the settlement did not speak at all to the Columbia costs of the program, right? It didn't ask that Columbia track costs. It didn't It's simply, the main bulk of it was establishing a working group and extending the program through 2030, right?
I am
It did not
reviewing
require
the
Columbia to
base,
track
what,
its cost of the program.
I'm
can-
sorry,
I can shorten it. The settlement did not require Columbia to track its costs of the choice program, correct?
I'm looking here at my testimony. I don't see that addressed, in my testimony as a primary element of the stipulation.
And I believe part of your testimony in support of the settlement was that each individual element of the settlement benefited customers, correct?
Can you tell me where I
I
said that?
think it's on page 3.
Page 3?
So your testimony in support of the
Okay.
settlement.
On page 3, lines 8 and 9. Starts on line 7, I'm sorry.
Yes, I see that now, yes.
Right, and you see where on line 8,
Mhm.
you say, well, line 7, you start with, not only is the stipulation as a package fair, just, and reasonable, but each individual component provides benefits to Columbia's customers, right?
Yes, that is my statement.
Okay, and then I think your testimony earlier this morning was that after the hearing was when Columbia began its holistic review of the choice program to decide whether it should be continued or not. Is that accurate?
When the order came out modifying the settlement, then Columbia was faced with the question of, do we accept the modifications to the settlement and the changes that are required for the customer choice program to continue? And looking back and looking ahead at this voluntary program that is even from today, we can say it's taking a fair amount of time. We looked, as I said, not at just one factor, at the plethora of factors that are out there, where the program stands in relation to the other activity in the state, the impact on customers, and what's ahead in the future. And nobody can see the future perfectly. I'm not saying that I can, certainly, but it was at that point in time, looking at the big picture, that Columbia did decide that it's a voluntary program, and as the commission said early on, when they modified some provisions to the original program to the 1999 program, once the commission made those modifications, the commission, and that was on rehearing, I believe, in the original case. Commission said it's a voluntary program, and so Columbia can accept the modifications or abandon the program. And
You had sorry, I didn't mean to cut you off. Go ahead. I thought you were done.
that's okay, I'll
Okay.
stop.
You had a discussion this morning, and you were asked, when did Columbia begin its holistic review of the choice program? And I thought and I'm only asking, when did this begin? I appreciate all the narrative, but when did it begin? Because I thought you said this morning after the hearing, which would have been late September of 2022, and in your answer you just gave, I think you said after the order was entered, which would have been, I think, March of 2023.
So, as I've said, the holistic review, there, maybe wasn't the best description, but whether to continue the choice program and ask to continue it in the 4 or 5 or ever how many iterations there have been. Columbia has been lukewarm about that each time, primarily because of,
Each time you came in to seek an extension of the program?
Yes.
You were lukewarm about it?
yes, because as you can, the survey results can be interpreted on both sides. The savings number continues to grow in a negative way, but as you point out, there are benefits to some customers. A fixed offer, some perceive as a benefit. And as the commission's report to the LRC said, that benefits are not defined. They're in the eyes of the beholder and the perceptions and opinion of the individual.
Right,
You look like you have a question that you want to ask me.
what is a holistic review then? Can you please explain what that means? Is there a process for a holistic review, or is there other memos?
No,
Are
it's
there
just when you
studies?
look at where we looked at where we are, the commission issued this order that denied our motion to terminate on a planned, not on day one. We were asking to file, or stated our intention that we would come in and file an application with the plans to wind down the program, and that motion was denied. And that made us step back and say, look at where we've been, look at where we've come from, what's in the future. We've never been, we've been lukewarm about this in the past. It's just now, it's time. We're ready to try something else. This has been out there, nobody else is doing it. Deregulation is, maybe not the, spicy subject in Kentucky that, would be a more favorable environment.
Okay, so the holistic review then, in the timeline that we're on, we've made it to the hearing at the end of September of 2022. So I thought the holistic review started after that, but I was apparently wrong. It hadn't started yet. And so then, am I right about that? Hadn't started as in October
You're
of
making
2022.
your interpretation and my use of that phrase imply a much more formal, some kind of much more formal process.
That's why I asked.
That
What
it's
is
not.
it? Yeah, okay. All right, so then we get to November, early November of 2022, and the settling parties filed an addendum to the settlement. Do you recall that?
I believe after the hearing, there was direction from the commission that, yes, there was an addendum filed.
And the addendum,
I'm sorry, I just want to clarify for the record. Was there a commission order giving direction as it relates to the answer that you gave?
About the
Addendum.
addendum? Was there a commission order?
Mm-hmm.
There was not a commission order issued in paper, but my recollection is there was something said about it at the hearing. But I haven't gone back and reviewed the hearing
Okay.
video.
Well, the record will, the hearing is the official record. Do you remember when you were asked certain questions, or the witnesses were asked certain questions to provide detail on what was filed, that there was maybe an appreciation by you and other witnesses that the presentation hadn't been as detailed as you all intended it to? I'm just curious what your memory of it was.
I'm trying to pull that out of,
That's fine. I just want to
Sorry.
be very clear about what the commission did and didn't order.
there was not an order issued. I don't think there was an order issued, which
Sorry, Mr. Green.
somebody will, yeah, I don't think there was an order issued, and I know the commission only speaks through its orders.
The purpose of the addendum was to provide additional clarity and process regarding the proposed working group. Is that accurate?
Maybe if I could look at what was filed, that would help me remember.
Tab 64.
64, sorry. Okay, yeah, so, yes, the addendum was submitted, November 7th, between the parties who were, at the hearing and part of this case. And what I remember is there was some discussion at the table there and at the close of the hearing, and the consensus was that the parties would work something out and present as an addendum, which is reduced here to paper.
Okay, and then on page 1 of the addendum, it clarifies that the parties agree that the intent of the stipulation was to extend the current choice program until March 31st, 2030, as described therein, right?
Yes, to
So as
extend the
of-
current choice program until March 31, 2030, yes.
So as of November 7, 2022, the company was on board with extending the program through 2030,
Yes.
despite
as part of
whatever
the-
lukewarmness might have been going on behind the scenes.
Yes.
Okay. And then, just to throw another kink into this, do you recall that Columbia in December of 2022 filed a proposed new tariff for the Green Path service?
Yes.
And would you agree with me that the Green Path service is a type of green gas product, right? That suppliers are also offering similar type products in the market today in Kentucky?
I don't know if suppliers are offering similar type products, but that is certainly possible. It absolutely, I can tell you, had no bearing at all. The filing of that Green Path rider, totally separate and independent from anything about customer choice.
And so if a customer if the Green Path rider, the GPS I'll call it, goes into effect in the service territory, and there's another case dealing with
Yes.
that, but
That's correct.
if it goes into effect, customers would choose to take Green Path service from Columbia, correct?
Yes, and that is a regulated service that is like the gas cost adjustment. There is no profit in there for Columbia Gas of Kentucky.
Right, but it would be a
Same thing.
customer choice above and
It would be.
beyond the normal product they can get today.
Voluntary. It's a
right?
voluntary offering,
Right.
if
Okay.
we're allowed to offer it.
So as of December 2022, the Columbia GPS were to go into effect in the future, customers would, Columbia would essentially be competing with suppliers offering a green type product, correct?
If Columbia offered that service, it's possible, yes.
Okay. And then, in March of 2023, would you agree with me that that's when the commission's order came out that requires Columbia to track the costs of the choice program?
That was when the commission issued its order modifying the settlement.
And then I think your testimony now is that shortly thereafter is when the holistic review of the program began and Columbia decided it wanted to terminate the choice program.
Again, the holistic review, you make sound like a very that maybe I use the word, so, to me, that doesn't mean a extended formal.
Well, help me out then, because is it just two people passing in the hallway at the corporate office that say, hey, let's cancel this? Or is it a formal meeting where you guys look at studies and look at filings and look at statistics? Or, I mean, is it a series of meetings within the company? I'm having, I don't mean to poo-poo the process. I just don't know what it is.
So it is a series of internal meetings, ongoing discussions about the elements of the choice program, and Columbia was fully expecting that the settlement would be accepted and had agreed in good faith with the parties to the terms of the settlement. And again, something that we've been lukewarm to many times in offering this extension, and knowing the information can be viewed, the numbers are close, it can go, you can look at it two ways. As I've said, I'll quit saying that because I feel like I'm just repeating myself too much.
So if the
But-
company, sorry, go ahead.
Well, at that point, when the modifications came out, and meetings then, of course, are held internally, so this has come out, we need to discuss it. And at that point, that's when the decision was made to withdraw from the settlement. So holistic evaluation, that, my interpretation of that not meaning the same probably as what I'm hearing others may think that means. It is a series of continuing conversations. We're looking at the information each time we come up on the program's expiration. And as marketers come in and out, we hear customers' opinions and the activity. I mean, we monitor those things on an ongoing basis. And all of these things, not one particular thing, but in the end, all of these things add up to, now we have an order that puts us at another decision point, and this time, our decision was different from what it had been in the past.
I'd like to ask you some questions about the customer's awareness of the choice program.
Okay?
And some of this goes back to the bill presentation that you did today. The survey, as you mentioned earlier, indicates that some customers may not be aware. I think 14% said they don't know if they're in the program.
That may have, yeah,
That's on
some of that
page 7.
information I was trying to find, looking at this quickly, and
On page 7,
Some percentage.
51.5% say they're not even aware of the choice program. And then on page 13, there's an overwhelming majority of customers that don't know that there's a comparison tool on your website. So when you look at those survey results, which you've leaned on today, wouldn't you want to do more as a company to better educate customers about the choice program, rather than just terminate it?
I don't think that's Columbia's responsibility. I think that's the responsibility of the marketers.
would you agree with me there's a difference between customer education and supplier marketing for a product?
How would you define those two?
If customer education is educating customers about their ability to choose, and that there's a choice program, and here's how to do it, versus supplier marketing, which is, here's a 12-month product for X price. Here's the termination fee if you terminate early, here's your savings. You also get this other stuff with your purchase, airline miles or cash back. Do you see the difference?
So when the program began, there were dollars that were assigned for customer education to cover the cost of creating the content and providing that customer education. That was one of the original aspects of the program. And that the content that was created is still largely what's used today.
Even though, okay, so that's great, but you have survey results where customers don't know about the product, they don't know about your website, they don't know about the comparison tool, they don't even know that they're in the choice program. And Columbia for years has basically done nothing to address that. Is that accurate?
No, we have provided more, as our website has changed, and as recently as November last year, we put information out there on the website. We have added the information to the bills. That was not always.
So can I ask you, I don't mean to cut you off, but the changes that were made since the last hearing, you put the banner slider on the homepage, right?
Mhm.
Okay, and then the second change I heard this morning was on the bill itself. In one of the bullet points, you added the website link to the choice page. Is that right?
In one of the,
I don't remember if it was the choice or non-choice. I think it was the non-choice, maybe. You added a link, in one of the bullet points it explained you can choose whatever,
Oh,
and then
on
you
the
added a
customer
link to
bill?
the website. On the
Like-
bill itself, yes.
that's always been on, well, not always probably, because we haven't always, that was not added recently. That was
Okay.
a
All right, then I
previous
misunderstood.
addition.
Okay, so are there any other changes other than the slider ad on the homepage that the company's made since September of '22?
The little carousel on the webpage. That's,
I think we're saying the same thing.
oh,
I'm
okay.
calling it a slider, you're calling it a carousel. But I
Oh,
think we're saying the
okay.
same thing.
Sorry, that's what the IT people called it.
Yeah, okay. And then,
Um,
is that, at the hearing in September of '22, the chairman asked you a lot of questions about putting a conspicuous link to the choice page on the home page, and then there was a follow-up data request. Do you recall that?
Can we look at that?
So in the post-hearing request for information number 12, do you have that?
Tab 61, I think.
Which one?
61, is it our responses?
Yes.
Got it.
61.
No, thanks, Mike.
Yeah, there you
I have a lot of stuff over
We
here.
got it for you. I get it.
go. There you go.
Thank you.
Yeah. Good. Got
The commissioners want, I got it in front of you. Would you like a copy? The data request?
Yeah, thanks.
it. You guys mind?
Okay, yes, now I see this. Okay, this is a post-hearing data request for the cost and timeline required to publish information about the existence of the choice program and a link to further information on the program on its website homepage in a prominent and consistent location.
And the answer
So that-
is no more than $170, and you can do it in one full business day, right?
That is correct.
Is that what the carousel is?
Yes. Uh-huh.
Okay, so $170 you were able to put a carousel on, about choice on the homepage.
Yes.
And on the bill itself, well, first, before we get there, in your presentation this morning, if a customer's on the website and they go to their dashboard, and I believe you said the dashboard page was the same for choice and non-choice customers, right?
The I think you only have the dashboard, which there was a commission data request about that. I think the dashboard is what pops up if you are enrolled in paperless billing. If you are not enrolled in paperless billing and you just go to log into your account, then what pops up is that pay my bill.
Okay, either way, whether I'm paper or paperless,
Okay.
can I, and choice or non-choice, can I pay my bill on the Columbia website?
Yes,
Okay. And when I go do that, I'm gonna get on some landing page that says pay now, I think the button said, pay my
Yep.
bill or whatever. I don't have to punch on my bill in order to pay my bill, right?
that is correct. You do not.
Okay.
You don't have to view the bill. You can just see what amount you owe to pay.
And when I'm looking at what is the amount I owe, and I haven't opened up my bill, there's nothing on there to indicate that I'm a choice customer, or who my supplier might be, right?
I would need to go back and look at that, because I don't have personal experience to say absolutely, and, I don't
thought
know.
that
I know we're gonna be asked to provide those screenshots so we can look at that and see.
I thought that landing page was the same regardless of what type of, whether you were choice or non-choice, that's all.
The bill and that, when you view, the bill is the same.
I'm
The
not talking about
land-
the bill, I'm talking about the landing page on the website before I open up the bill. It just says you owe this amount, and I can pay it. I don't have to open up my bill.
True, but on that choice customer bill, it looked like there were some other, but I don't know if that was because I think it was because it was a paperless, they don't get a paper bill. Their bill image is the same as a paper bill, but maybe that landing page, I don't know.
Okay, that's fine.
I
Does
don't know.
Columbia track how many customers or click onto their bill, their actual bill?
I don't know. I don't.
And on the bill itself, you would agree with me that for a choice customer, the supplier's name is listed on the second page as a line item on the bill, right? I believe it was in bold.
The supplier's name is listed as a line item in at least 2 places on the customer bill.
On the second
Maybe
page,
3.
right?
Yeah, it's on the second page of the bill.
And you're aware that one of Zoom Energy's recommendations in this case is that Columbia be required to put the supplier's logo on the front page of the bill?
I remember they wanted to put a logo on the bill. I don't remember the specific location.
Okay, and would you agree with me that Columbia's affiliate in Pennsylvania puts the supplier logos on its bills?
I don't know.
I want to switch gears on you and go back to something that happened in the last hearing. You were asked at the last hearing, what information does Columbia request when a customer enrolls in Columbia service, like a new customer? And I think your answer was name, address, telephone number. Do you recall that?
I'm
Or do you-
trying.
Do you know that? Keep it this way.
I know we have to have name, address, telephone number. We probably asked for an email. I've had
I'm
service
looking-
at my house for 30 years.
And Your Honor, if I may approach.
You may.
I'm looking at post-hearing data request number 4.
Is this a document already in the record?
It is a discovery request, yes, sir.
And would you like to mark it and include it as part of the record for convenience and citation, or just reference it during the hearing?
I think I would like to mark it.
How would you like to mark it?
It would be Zoom Energy Exhibit 1.
Okay.
Are we
So
starting
mark-
over from the last hearing, or? Are we-
That, all, brand new,
Okay.
Zoom Energy Exhibit 1. All right, please proceed.
So you got a chance to review this answer, even though you sponsored this answer, correct?
Yes, I did. This information was provided to me and I sponsored it. So there is what we collect and maintain in our customer account files.
Okay, and just a couple of quick questions about this. The number 2, the social security number truncated, does that mean like the last 4 digits of the social security number, or?
That's my understanding, yes.
Okay, and I noticed on here, and the service address is not on here. So assuming if the mailing address was different from the service address, you would have both addresses then? Would that be accurate?
Yes, you're right. That is an omission. Yeah, there should be a service address as well, a premise address, as well as a mailing address, which may or may not be the same.
Okay, and when you say premise address, is that the same as the service address?
Yeah, it's where the meter's located.
Okay, got it.
Yep.
Thank you.
Mhm.
Your Honor, I'd ask this to be entered into evidence. This is Zoom Exhibit 1.
Ms. Honaker?
No objection.
All right, we'll enter this as Zoom Energy Hearing Exhibit 1.
I will say that I know from why we couldn't set up a dummy account, that the premise address is what establishes the customer account. So that may be why that's not listed here as, I mean, I believe it should have been listed as something on here, but that is required to actually establish an account.
And then the next question I have for you is about I call it seamless moves, but I think it's been called start, move, stop, or start, stop, something, start, stop, move.
And I would call it transfer of billing.
Okay.
Yeah.
Let me just ask you a hypothetical, because my takeaway from your discussion with Mr. Malone is that you may not be 100% certain how it works. So if I want to try to walk through it, and if it doesn't work, then just let me know.
I probably don't know because.
Okay, so let's do it this way. Let's suppose on May 2nd, a customer calls Columbia and says, I'm moving across the street, still in the Columbia service territory. So Columbia, and the move is effective May 3rd, right? So Columbia will disconnect the customer and then establish new service at the new location with a new account number. Is that how it works?
I would call that transfer, well, no, that's not, yes, I guess that is, if they're moving physical addresses, then yes, the service is discontinued at the location from which the customer is moving, and service is established at the address the customer is moving to.
Okay, and if that customer had a 12-month contract with a supplier, and they were right in the middle of that contract would be terminated, and when the new service begins at the new location, the customer would be a Columbia Gas of Kentucky customer, right?
This is the part I don't know, because I thought that those, if the customer moved within our service area, originally, the expectation was that the service from the supplier would not be interrupted. It would transfer with the customer. That seems to be in question now, though. So that's why I don't know exactly how it works today.
Okay. All right. Okay, I'll accept that.
Can I just ask a clarifying question, Ms. Cooper? If the service is tied to the premise address, does the account number change when the customer moves addresses?
We're on public record right now, right? Slightly. The account number doesn't change, the check digit changes. So it's a sequence number. So the customer's account number, their account number doesn't change, but in the whole string of numbers that show in the top right-hand corner of the bill, like on those bills that we looked at in the confidential section, I don't know how much to say about this.
Well, so let me keep it very general here. Does the information, so you identify a customer, okay, you, on the 15th, you get this information from the marketer, here's our new group of customers. Is the way they identify those customers to you tied to that check number that changes when someone moves?
I don't know for sure today. Could I ask my lawyer something? It's about I don't know the privacy rules about how much I can say in the open.
The only thing you can't say is their account, Ms. Honaker will object if she disagrees with me. I'm pretty sure the only thing you can't say is what their account number was, what their address was, or what their name was. Otherwise, or that check number was, but otherwise, as a general matter, nothing else is personally identifiable information. If that's what you're concerned about.
Yeah, so,
Especially if it's applicable to all bills, what you're about to say is generally applicable to all the bills that you enter, all the customers that you have. But let's just say this, it's almost 2:30, we've been going for an hour and a half. Mr. Green, do you have a couple more questions?
Just a
or-
couple more. and I'm
So, yeah,
done.
so let's just take a short recess and then we'll come back and that'll give you an opportunity to talk to
Okay,
Ms. Honaker
thank you,
about it. So
thank you.
We'll take our predetermined, I guess, or at least with us, I didn't tell you. We'll take a 15-minute break, and, yeah, we'll come back at 2:40. Back on the record in case number 2021-00386. Mr. Green, you still had more questions, you said?
I'm winding down. Yes,
Please
sir.
proceed.
Ms. Cooper, just to follow up real fast on the exchange you just had with the chairman about the account numbers when someone moves. Let me see if I understand this. So there's a long string of numbers on a customer's bill that is the account number and maybe some other.
So
personal
if
data?
I may, I have some clarification on that I can provide now. The account number is a 15-digit number. When a customer, an individual that's a customer, the first 12 digits are assigned as that customer account number. As a customer may move to a different service location or premise, we would call it, within Columbia's service area, the last 4 digits will change of that 15-digit number.
And so I've got to have the 15-digit number of the new location in order to effectuate a switch to a supplier, right?
That's what I'm uncertain about, because as it was originally designed, that customer, when it transfers in Columbia's customer information system, and there is a change in premise or service location that is, not like a year apart or something, it wouldn't pick it up, but within a short time period, it was intended that the service from the whatever marketer, if the marketer enrolled that customer and it was in their file for the 15th of the month, and sometime between the 15th of the month and the next 15th of the month, that service transferred, the supplier's billing rate associated with that customer would automatically transfer without the marketer having to do anything, but the customer was responsible to inform the marketer of that change and could, if they wanted to, unenroll, then they would have that option. But how it's actually working seems to be in question, and that part is what I don't fully understand.
Okay. There is a
Does
data.
that make sense?
It does. I think
Okay.
what you're saying is what was the intent may not be what is actually happening in operations today.
Today, yeah.
Right, okay.
Today, is what I don't know.
Okay, and there was a data request, but it doesn't expand on everything we've talked about today, so we may ask for another one at the end of the hearing. So let me move to the next topic, and that's, I want to go back to the website and the price comparison tool.
Okay.
We called it the Ziploc bag slider or whatever.
Well, yeah,
Yeah.
the calculator, that's.
Yeah,
that's
that was a
yeah.
good way to
That's what it
describe
looked like to me,
it.
I know.
So, but that price comparison, just to clarify, it only is a price comparison, right? There's nothing on there to indicate whether the price you're comparing, the supplier price, sorry, let me start there. There's nothing on there to indicate that the supplier's price is a green product or a 12-month rate or anything else. It's just strictly one price versus another price, right?
So it is a price that the customer utilizing the tool types in.
Okay. All right, let me end with this, because I've been curious about this for several days now. It is now, for all intents and purposes, August of 2023. And there are suppliers on the market today offering 24-month fixed-rate products. Are you familiar with how a typical supplier might hedge that long-term fixed-price contract?
No, I don't. I don't know anything about
Fair
that.
enough, that's okay, I just wanted to explore that. But if, you indicated earlier that Columbia would make a filing in March of '24. So we're sitting here in August of '23. What advice do you have for suppliers that are offering long-term products that go beyond when Columbia would terminate the program?
So it is not my role to give advice to marketers on the offers that you make, as long as they are within the guidelines that our tariff sets out as the marketer code of conduct, and that requires that those terms be clear, concise, and easily understood, and that they contain a regulatory out such that if the program ever terminates, then there is no obligation on behalf of the supplier or the customer as far as any other kind of legal proceedings. They all have to have a regulatory out.
But do you understand the financial and regulatory uncertainty that these types of filings and position changes from Columbia put on the market that wants to come here and compete?
We have an active group of marketers that continue to come and go today. So do I understand those things? I hear the concern that you're expressing, but my job is to create the rules and propose to the commission what Columbia determines is in the best interest of its customers and its shareholders. And this program has nothing to do with shareholders. It is purely about customers, and therefore, as I said, it's something we've been lukewarm on because the results can be interpreted two ways, probably more.
Thank you, Your Honor. I have no further questions.
Ms. Frederick?
Yes, Your Honor, thank you. Ms. Cooper, nice to see you again.
Thank you as well.
You've answered already a lot of the questions that I have, but I do have some.
Okay.
If or when the choice program were to be terminated, what costs would Columbia incur in the short term, in order to wind the program down?
I would anticipate that there would be, the cost would be associated primarily with outreach and customer communications, supplier communications, those types of informational cost. The processes to return customers to tariff sales exist today. I'm trying to think what other types of costs there might.
Has Columbia, Kentucky performed any type of calculations of the cost to wind the program down?
No.
Okay. Will there be, or do you expect there to be any short-term costs, like changing the billing system or making alterations to the website?
The changes to the billing system would require those messages and some of the content that we looked at earlier today would need to be removed. But let's see, what else would have to happen? Because we already bill tariff sales customers, I don't expect there would be significant cost or other IT changes that are required because those things are already in place.
If we were to ask in a post-hearing data request for a detailed estimate of any type of winding down costs, would Columbia be able to answer that in a post-hearing data request?
So my hesitation is the timing associated with that, because winding down the program and the elements that may be included in winding down the program to provide likely and some other sort of, not going to call it customer choice by Columbia's trademarked or registered choice program, but as the term was used in the 2010 case that was the report of the PSC's investigation of retail marketing, and it used the term customer choice, I believe, in there too, for non-residential customers. So my hesitation is that has to be figured out in order to estimate or calculate the total cost of winding down. And I just don't know what that, I don't have that answer today.
Okay. Terminating the program would eventually cause the current choice volumes to become sales volumes for Columbia, is that correct?
Yes.
Okay. And Columbia,
Well, let me say.
sorry,
All else being equal, but it is Columbia's expectation that for customers that are less than 25,000 MCF, non-residential, that there would be another alternative available for them.
understood,
Okay.
understood. So for those commercial customers, there would be other alternatives, but the volumes involved with residential sales would need to be absorbed by Columbia.
Yes.
Okay. And Columbia is the supplier of last resort, whether the project is up and running or whether the project is ending. Columbia still must stand ready to provide that commodity. Is that correct?
Yes, that is correct.
Does Columbia have sufficient pipeline capacity and gas purchase contracts in place to serve all the customers, including the choice customers, that would then revert to being Columbia retail customers?
Yes. The
Currently-
pipeline,
Currently in place?
so we don't have the commodity in place. That would have to be procured, but the demand, the pipeline capacity is in place. Today, that capacity is assigned to the marketers for them to use as they procure their supply for the customers that they serve. That capacity would revert back to Columbia. It is assigned on, but Columbia has firm recall for that, so it automatically comes back. It's the same capacity.
Understood, but as far as the commodity goes, how long do you expect that it would take to get purchasing agreements in place to cover the commodity cost?
So, as I mentioned before, I'm not the procurement expert, but I will say it is certainly something that Columbia can do and has done in the past when we have had marketers fail to deliver the commodity that they were required to deliver, which has happened. And then Columbia had to step in and procure that supply to be able to serve the customers. Sometimes that's happened on a short-term basis. In some cases, we've had marketers who just stopped delivering and nobody in the room, but then they just kind of disappeared. And so and they didn't announce their intention not to deliver. So we are ready and capable, and the gas supply procurement people are able to go out and procure supply.
Okay. I have a few questions that involve the relationship between the Columbia Choice Program and its potential termination and performance-based rates. Are there any components of the performance-based rates that are based on contracts that already provide pipeline capacity or backup gas for all customers?
Are there any, would you? say that
Components
again.
of
Let me
the
think through
PBR.
Let me hear the whole thing again,
Yeah,
please.
any components of the PBR based contracts that already provide pipeline capacity?
The pipeline capacity is a part of the transportation cost index piece of the PBR, the performance-based rate-making mechanism.
Would greater volumes and capacity reservations increase the savings under the PBR?
No, I mean, it wouldn't make any difference at all, and because that capacity is already used for the customers that are served by choice. And if they come back to tariff sales, we need that capacity to be able to provide the tariff sales.
Would an increase in total sales volume increase Columbia's portion of the savings, all else being equal?
No, it would have no impact.
This may need to be a post-hearing data request, but could you, if asked, provide the amount of incremental PBR sharing that Columbia would have realized over the last 5 years if the choice volumes had been Columbia commodity sales volumes?
I don't know the answer to that question. So I don't know if that's something we could provide or not.
Okay.
But certainly you're welcome to ask. I will say that until the commission put the choice volumes and the PBR, those are two totally separate programs to Columbia, and we have not, they're not part of the consideration of, one is not a consideration towards the other. And so when the questions came, it was like, well, those are not even connected. So I don't know the answer to your question. I don't think it would make any difference, but I don't know the answer.
Okay. From Columbia's perspective, explain the ways in which Columbia customers would be better off as a Columbia commodity sales customer than as a choice program participant.
So, again, I'll go back to my statement that it's the perception of the customer. In Columbia's purview, the $74 million that's out there that we continue to report annually on the savings, and that is not becoming, reverse that. It has become a larger negative number each month, and that trend is not reversing. And for that, not to say that certain customers may not be saving on an individual basis, some might. It's a point-in-time snapshot unique to that individual customer that we don't know. But for that number to be out there and it to be under Columbia's program, it is not something that Columbia as you can maybe imagine, not something that we would really like to publicize, I'll say.
Okay, that $74 million number that appeared in the 2023 annual choice report that was filed on May 30th here at the commission, I have a question, just to clarify. Is that 74 million since 1999 or since 2005? Because I know there was a phase one of a choice program that kind of started and then it ended maybe even a little earlier, and then the 2005 program, I think, started in April of 2005. And I wasn't clear if that $74 million dated back to 99 or 2005.
It actually starts, I believe, the first gas under the program that started in, the program was approved in 1999. The first gas flowed in November of 2000, so it's from November of 2000.
Great,
Back
thank
to
you.
that beginning.
Thank you for clearing that up.
Mhm.
Do you believe that current choice customers that have fixed price contracts will experience greater bill volatility due to the inability to fix their gas costs with Columbia?
I don't really know. So, if they've got a fixed price, will they experience greater volatility? Well, depends on how you look at it. If it's fixed right now, it's fixed every month. And we're just going to talk about the rate per MCF, not the total bill. But really, the total bill is, I think, what most people look at, because that's what they look at to see what they have to pay. But the volatility overall, if they locked in a really favorable rate for a period of time that turned out they were, significantly different from what Columbia's rate might be at the end when that contract expires, then yes, there might be more variability to them than a customer who had been on Columbia's tariff rate and experienced more gradual changes in rate. So I can't say absolutely one way or the other.
I understand that. Do you believe that the ability to, say, sign up on budget billing will sufficiently moderate any volatility that customers would experience?
Budget billing does provide the customer a way to moderate their annual, their monthly bills and smooth it out. That is an option that's available to customers. It's also voluntary.
Does Columbia anticipate a backlash from customers that are enrolled in the choice program if the program should terminate?
I don't expect a huge backlash, but I don't really know. I mean, you look at the survey results from what customers are experiencing. There may be some individual customers who may call and complain.
And what kind of an explanation is Columbia prepared to give to those customers if they call and they complain because they have been happy with choice?
We have not yet developed those talking points, but they would be created and provided to the contact center so that they are equipped to discuss it with our customers. That's all part of the winding down process.
Now, we've talked about this today, but I'm just going to run through this, and if your answer is the same as it has been in the past, that's fine. But the revenue implications to Columbia if or when choice is terminated. So Columbia would no longer collect 5 cents per MCF from choice volumes. That's correct, right?
Yes, that's correct.
No longer collect the 20 cents per bill, per choice customer bill.
That's correct.
And Columbia will no longer retain 2% of choice revenues.
That's correct.
Okay. And what type of impact do you expect that this will have on the revenue of Columbia, Kentucky?
So at this point, as I said before, I don't know the total revenues from those sources right now. I think that was maybe a data request, but I don't know the answer. But it's not, it is not impactful that it would cause Columbia to come in and file a rate case, which would be our only other means of recovery.
And I won't belabor the point too much, because you have said over and over again, in this hearing and in the other, that Columbia does not track the costs to administer the choice program. But do you know if there have been years when the stranded and education costs exceeded the amounts that were collected to cover them through that 5-cent charge?
That's going way back. I'm trying to remember at the time that the stranded costs were dissolved, if that was, I think there were remaining, I don't know.
Okay.
I don't know. I don't recall.
Do you know or have an estimate of how many choice accounts are uncollectible in any given year?
How many? I don't know.
Would you expect that that would be about the same percentage of uncollectible regular sales customers?
You're not gonna like me. I don't know. I don't know.
I had a question about the survey and the website. You've answered questions about the survey today, but the survey results through the years have indicated that customers don't always know if they're participating in the choice program. Did Columbia ever discuss upping its efforts on its website, moving things to more prominent locations, other than what was done, I guess, in November or December with the carousel? But more in line in the timeline with those survey results, because those were done at different points during the program. Was there ever a time when Columbia reviewed those survey results and made an action plan based on the survey results to increase customer awareness of the program?
There were plans made to increase customer awareness of whether they were a participant or not, following the first survey, which is, I think, in 2000 and something. Not, yeah, what was the first? But that's when the information was I think, and the chairman asked me about that this morning, I think that's when the message board started carrying those messages. I think that was a change after the first survey, that we were trying to put some more messages out there to inform customers. Electronic payment and paperless billing are all things that have come into play subsequent to the creation of the choice program. So those things are all newer, And I think that the website design is handled so that the Columbia websites are all somewhat consistent. I think Chairman used the word aligned maybe this morning. But I don't know, and I'm trying to think, another change that was made some years ago, I don't, and it may have been after that first survey, was that the marketers are required to send a letter annually to their customers just to inform them that they are a customer of whatever the chosen marketer is, and to have that contact with them if it is one of their customers. Those are the things that I can recall.
Okay. Thank you, Ms. Cooper. Those are all my questions.
Questions?
I just have a couple. Who made the decision at Columbia to not go forward with, continuing this program?
It was made by the executive staff in the Lexington office in consultation with our legal team.
Okay, so when they made that decision, did they have the attorneys, the IT people, all of the relevant people to make that decision?
There were not any IT people involved.
Okay. You said that Columbia doesn't track costs of this program?
Not specific to customer choice.
Okay. How would a decision be made to discontinue the program if you don't know the costs and the revenue? How does that decision get made?
So we know the revenue.
Okay.
The cost are, other than incremental IT cost, which that would be something that is known and something we could track, although, and I think there was we looked earlier today at an IT cost of $170 to make a change. So that's a minor cost. Primarily, all the IT that's in place was done when the program was created and put in place then, and we still use our customer information systems and our IT systems are largely old systems. We have a lot of IT work that needs to be done, and work is ongoing about updating those systems. But that's all an investment that's already been, the cost have been paid for and recovered from the time the program originated. So there's really not any cost. The other costs are, you could say people like our outside counsel, their internal labor dollars that we don't track, like my time isn't charged to customer choice. I just
Do you
work.
know why?
Why?
I mean, well, why isn't customer choice tracked?
My time is all tracked, like, for instance, my time.
No, I'm saying fully, why isn't this program tracked?
Because I think that the original design was, we're using existing resources that are part of our revenue requirement anyway, and it's recovered through base rates, and the base rates for choice are the same as base rates for tariff sales, and there was never any thought of being able to track anything other than incremental cost, which were IT cost and customer education cost originally.
So Columbia Gas or NiSource doesn't really look at what's successful, what's not, in order to run their business, to make a smart business decision about providing a program or continuing it? I mean, wouldn't all those factors have to go into a decision being made to discontinue the program?
Well, certainly knowing what the revenues are, we know that, but knowing what the costs are, if we don't have a choice program, I may not have a job, I don't know if I'll have a job tomorrow or not, but the personnel that are required are not likely to change based upon whether or not we have a choice program. And so those costs are, if we don't have a choice program, then the internal resources will be working on sales matters.
Were you in the room when the decision was made or the discussions were happening?
I was.
Did you present data to them?
We knew what our revenues were. We don't track the costs, so, but our thinking all along is that other than incremental cost, there aren't costs that are distinguishable from tariff sales activity.
Okay. When a customer changes, when we were talking about a move order,
Yes, ma'am. Mhm.
I'm gonna refer to it as porting, because that's how I
As what?
sort, as porting, so you're
Porting.
going from one area to another.
Okay.
If we, and this might already be in the data request, does the back office do that, or does the customer have to get involved? So is it done, when a customer moves, is it all done where they don't have to place an order, they can call in, and then your customer service reps would work with the other carrier and they could transfer that way? The customer doesn't have to do that? Do you know how that is done?
So the way that I thought it was working, which is a question here
Okay.
I've learned today. When a customer does have to call in, or now they can go on the website and do that stop, start,
Stop, start, move?
yes. They can go online and do that. And when they do, a customer calls or does that, then in the background, their service and their customer information transfers to that new premise. And that happens in the background.
Okay.
The part that you're asking about, the porting,
Well, my question was, do they do it in the back office so the customer doesn't have to be involved in that transfer, other than making the call to move?
if I'm understanding you correctly, yeah, the customer just has to call and say, I'm moving from number 10 Maple Street to Ashland, whatever the address is there, I would like my service to end at my current residence today and start at my new residence tomorrow. And that's all the customer
That's all they
has
have
to
to
do.
Okay. All right, thanks.
Did I explain that?
Yep,
Okay.
yep.
Thank you.
Gas utilities in Kentucky are, by virtue of the gas cost adjustment, we'll call it the GCA, is that okay?
Yes.
Okay. By virtue of the GCA, fuel costs or gas costs are a pass-through for the utility, is that right?
Yes.
So like when you're talking to customers or the company's giving a presentation, I often hear a gas utility say, we make no profit. It's just a pass-through of costs, right?
Right.
Okay. Another way to say that may be that you guys are economically indifferent. There's a time value of money component maybe between quarterly GCA filings, but otherwise, you're not making a profit one way or the other on the cost of fuel and the pass-through to consumers. Would you agree?
Yeah, we don't make a profit on the cost of fuel.
Okay, great. And so take me back in time, maybe when you were here at the commission in the 90s, when people were talking about this, and then maybe a little more forward about soon after you got to Columbia and Columbia decided to go through the choice program. Is any of it based on the fact that ultimately Columbia is indifferent, whether customers get their gas from a marketer or whether Columbia is the one that provides them the gas, it doesn't really affect your bottom line? Was that a consideration at all?
So what I remember about when I started at Columbia, which was before the choice program, and other I was at Columbia, other states, other Columbia affiliates, Columbia Gas is in other states, and we weren't part of NiSource then, nor did we have Columbia Gas in Massachusetts. Other states were beginning the new retail competition, and all of the other operating companies had choice programs that were designed specific to their states and their operating companies in place. And at that point, well, I don't remember exact timing. I'm thinking about how other states have deregulated, and other LDCs have exited the merchant function, which was a big topic back then, that LDCs would no longer provide the bundled service or sell gas at all. They would just be like the UPS man and deliver the gas through the pipes, and that would be all that the LDC did. And that was the environment that was the popular, I don't know, popular, but that was the new way of looking at things, and the potential deregulation. And it was really starting with electric markets, that was the driver. And then gas markets were kind of secondary, because if they're doing it for electric, then marketers wanted to do it for gas, and that was just a supplement to their business.
But you don't make money on gas.
No.
Yeah, so really no loss one way or the other, big picture. It's not a hit to your bottom line necessarily to have a choice program, right?
That's correct.
Okay, you make your money on investments, is that right?
We make our money on the delivery service that we provide.
Well, but you just, when rates are set, your net income is a function of your level of investment. Would you agree?
The rate base and the return on the rate base and recovery of our O&M expense.
You're in the
So,
investment.
where we make our money, yes.
You're in the investment business,
Right.
right? Okay, the infrastructure business.
Yes,
Okay.
that's right.
So, I guess I would be surprised if a utility came in here and said, we want to start opening up investment in our system, and we're going to let other people invest 20%. We're going to give 20% of our investments to somebody else. That would be surprising, right? Because they'd effectively be giving up 20% of rate-based growth, right?
You might find occurrences such as that in the world today.
Where somebody's giving up their investment or somebody's giving up stock of their company. Let me ask you this. Are you aware of any utility in Kentucky that is interested in giving up its effectively monopoly status to let other entities come in and invest in their infrastructure, or infrastructure in lieu of them making the investment?
No.
Okay. And that's because rate-based growth is earnings per share growth, and that's how the firm creates shareholder value. Would you agree?
Yes.
Okay, all right. So you talk about, we talked about earlier, gas utilities talk about the GCA and fuel costs being a pass-through. Okay. That indifference, just natural indifference to a pass-through of costs, it's not a Columbia-specific thing, but passing through costs has the effect of making the entity or the utility indifferent to variations because it doesn't affect the bottom line necessarily. The commission acknowledged that, would you agree, in coming up with PBRs to try to provide the utility an incentive to find savings related to the procurement of gas.
I would also say that that the utility has an incentive or an obligation to pursue a least cost, reliable purchasing strategy. So that's a foundational element of being an LDC. And also, we have an obligation to our customers that we're just not going to go out and pay an exorbitant amount for gas supply just because we can recover it as a pass-through. We have a concern for our customers, and we're very cognizant of that in all that we do, that
And that's fine.
That's where it's.
And that's fine. I'm asking specifically about the commission's stated rationale for the
Okay.
PBR
Okay.
was to provide an incentive for utilities to find savings in the procurement of gas,
An additional incentive, yes. Mhm.
right?
Yes,
And Columbia has been able to do that. Would you agree?
yes,
And Columbia has received a profit, an additional profit, a percentage of savings as a result of its PBR.
yes. Those savings have gone through to the customer first, and then a portion of that Columbia is allowed to recover.
Okay. I asked, I had a lot of questions and you had a lot of answers about this at the previous hearing in this case, right? A lot, I know, is a subjective term, but I asked you questions about the PBR at the hearing in this and
Okay.
how it relates to the choice program. Do you remember
Okay.
that? You don't have to remember the questions.
Okay.
You remember a line of questions.
Okay, yes.
Okay. Did you, after that hearing, or anyone at your direction, or anyone that you work with that you know of, go back and compare whether in the last couple of years or over some period of time, whether the volumes that had gone through to marketers would have affected the PBR?
No,
Okay, so that whole line of questioning, everything, you weren't interested at all as to the interaction between the PBR and the choice program?
because the interaction, I don't remember the questions that were asked. I'm sorry. I just don't remember. But the interaction between choice and PBR there's not viewed as an interaction from Columbia's perspective, because as I explained, the TCI component is assigned to marketers. That's the Transportation Cost Index, which is the pipeline demand capacity. And that is necessary for Columbia to provide the reliability for customers, both sales and choice. And what's assigned is not impacted, or the PBR isn't impacted by that at all.
All right, so let me just be clear about that. Let's stop at TCI because frankly, TCI savings, with the exception of a couple of high off-system sales years, TCI savings is, well, every year it's at least half
Yes.
of the savings from the PBR,
It
right?
is, yes, it
Okay.
is.
When you
The
say
base
that
piece.
they've been assigned capacity, that's capacity that you have a right to, Columbia has a right to, that you assign to marketers, that but for that assignment, you would still reserve the right. Is that right? Is that correct?
If it wasn't assigned to the choice marketers, we would either still hold the capacity if we needed it, or we would have done something else with it if it wasn't needed for tariff customers.
Okay, so TCI savings, okay, are based off of a benchmark, correct?
Yes,
Okay, when you assign the TCI capacity, you assign it at cost, is that right?
yes.
Okay, is it Columbia's cost or is it the tariffed rate?
It's Columbia's cost. The capacity that's assigned is not the capacity that is the, I'm trying to think of the, contracts that are assigned versus the, components of the TCI. And I probably need to get that clear in my head because, the capacity is assigned at Columbia's cost to the participating marketers based on the quantities needed to serve their customers each month.
Okay, let me ask it this way.
Okay?
If you did not assign that capacity, whatever percent capacity you're assigning today, it goes to zero. You keep it all, okay? Does that change the inputs in the calculation of the TCI savings?
If we don't assign the capacity, then the customers come back to us and it has, on the TCI, it has no, the TCI, it has no impact on the value that could be derived by Columbia as part of the PBR.
Yeah, I don't know that that's, I guess I'm trying to understand. You have X percent capacity at X cost, right?
Yes,
Actual cost,
yes,
actual cost. What you pay for that each year, okay, is then compared to the benchmark for the TCI savings. Is that correct?
yes,
Okay, so can we make up some numbers to make it very easy, because, okay. So say the tariff rate, that's the benchmark, right, is $10 per unit, whatever the unit is, I don't know what it would
it's
be.
actually not the full tariff rate, it's
Yeah.
a, yeah,
That's,
but,
yeah, but
we'll use it for your
the
example.
benchmark, or we'll just say the benchmark, which is a tariff rate.
Right.
Okay. And your actual cost is 5 times the unit, okay?
okay.
Under the TCI today, do you take your reservation or allotment or whatever the term may be times the 5 and then compare that to the reservation times the 10, take the difference of the two, and is that how you calculate your TCI savings?
The TCI is calculated on a contract by contract basis. If we look in the tariff, and I kind of got lost in your example, I'm sorry.
I'm just asking if you, all I'm asking is if you change the volumes or whatever the unit is, does that not change the calculation of ultimate savings?
I know this seems like a very simple question. If you change the volumes and the rate is the same, does it change does that equation change the product?
Does it increase the savings proportionate with this change in the volume? If I can make $1 an apple, if I sell $10, I still make, or sell 10 apples, I make $10. I'm asking if you no longer, under the choice program, assign capacity to the marketers and instead use that capacity, keep it yourself to serve those customers that otherwise would have been served by the marketers, does that not increase the unit by which you're comparing to the benchmark and create additional TCI savings?
The difference is the savings are derived in the TCI primarily by a contract that is for storage capacity, and storage is not assigned, pipeline capacity is assigned.
Okay.
That's why I'm sorry that I said it seemed like a simple equation, but it's not as simple as it seems on the surface. And it's because of the different nature of the contract. So it's pipeline
So you're
capacity
saying-
that's assigned.
Yeah, sorry, just to be clear, then you're saying that the TCI benchmark, maybe as approved by the commission, is still the SST tariff? The storage service transportation tariff?
That's why I need to look at the tariff, because it's getting a little deeper than what I have.
Well, I mean, I can ask this as a post-hearing data request,
Okay.
but this is what I'm trying to get to. When you
Yeah.
say it's not of, and we're not even thinking about it, my question is, would you like an opportunity to think about it? Because I asked the questions at a September hearing, and I've kind of assumed you all would have gone back and actually thought about it instead of just saying, nope, they're two separate things, we're not thinking about them in conjunction. I'd like to know, as the person who has to rule in this case, whether you all are actually economically indifferent to a GCA or marketers or not. And if
Okay.
you're not thinking about it, that's a problem.
Okay, so I don't have a study or anything that's prepared, but we did go back and talk to gas procurement and the gas supply people to find out, you know, are we really truly indifferent? And the answer from them was yes. They explained it better than I can, so a post-hearing data request, I'll say, I don't know, and
So you all did go back and have a discussion about it.
we had a discussion.
Okay, so the effect then, let me ask you this way. Getting rid of the choice program would reduce the utilities revenues by $750,000, correct?
I don't know the amount, but by some amount,
Assuming though,
yes.
that was the amount that was thrown out, assuming
Yes.
that's correct, that would be the amount,
It
right?
would be by some
Okay,
amount.
and there would be no, as you explained earlier, really no incremental cost savings from reducing it in terms of the utilities cost of service, right?
That's my understanding. I
Okay,
don't believe there.
and from the conversations you had with the gas procurement folks, there is no additional revenue gained from either the utility or for the benefit of the customers through the cost of service, from running volumes through the utility as opposed to assigning them to marketers.
Agree.
So I want to talk about the $74 million for a second. You discussed, all right, first off, when you said you had storage earlier, that's just pipeline storage, right?
Yes,
Okay. You have no actual physical storage, would you agree?
correct.
Okay. So the $74 million, the cumulative amount since the year 2000, we do agree that's over the last 22 years, right?
Yes, that's
Okay.
correct.
And over that time period, you effectively did not hedge your gas costs through the GCA, is that right?
There was a period of time when, and I want to say it was, there was a commission proceeding that looked into hedging, financial hedging, because physical hedging, meaning storage, for us, that's pipeline contractual storage. Other LDCs in Kentucky have physical storage assets, but we do not. So physical hedging has occurred throughout the entire period. There was a period of time, and I want to say, I don't remember, sometime in the 2000s, that the commission had an had a proceeding, I'm thinking it was probably administrative proceeding, although I can't recall. And, told the LDCs at that point that we were permitted to engage in financial hedges. And so Columbia and the other 4 big LDCs, whose are the ones that seemingly are grouped together in these things most of the time. We were engaged in financial hedging for a period of time. Then, as the volatility of natural gas prices declined, the commission came back and said the benefits of financial hedging are no longer required. The volatility has decreased, and we are no longer allowed to financially have those financial hedging programs.
Well, and the reason I ask, do you know what, just roughly, any given year, what percentage of your residential, or we'll call them small volume customers' volumes go through buy from gas, from the utility versus a marketer? Do marketers have like 10% of volume, 15% of volume of small volume customers?
That is a statistic that's included in each annual report.
Okay. I don't have any of them from me. Do you just roughly, is it 5% or is it like 20%?
I want to say it's something in the teens,
Okay.
maybe.
Okay. Do you know, so the counterfactual of $74 million is what people paid to marketers for their gas versus what they would have paid to the utility for gas. Do you know what it would have cost to financially hedge the volume of gas that marketers have served since the small volume program went into effect? I think that's the question. Do you know what it would have cost to hedge that volume of gas?
I do not.
Okay. Is that the appropriate counterfactual?
Counterfactual.
Earlier, you've thrown out maybe, I don't know, 6 or 7 times at least, the $74 million savings being, if not the primary, one of the important considerations that you all made in saying that you want out of the choice program now. But effectively, $74 million is the cost that customers paid to have certainty, or not certainty, to have hedged the cost of their gas, right?
It's what they paid for, and that's how the commission told us to calculate the comparison.
I'm not saying you did it wrong.
So-
I'm saying that we talk about what the offerings are under the choice program, right? There's either green attributes, or there are donations to charities, or there are rewards points, whatever. But the primary offering that I've seen over the last 6 or 7 years is a fixed price. Would you agree?
Well, quite honestly, I think there have been more variable price offers than fixed price, but some of both.
Okay. But
Definitely.
I guess my question is, based on the volumes that have run through the program in the last 20 years, do you know what it would have cost, or can you all run on a per MCF basis, just at any random time, what the cost to hedge on an MCF basis is, and see whether that is even close to $74 million?
I don't know. I don't know, and I don't even know if we could run that sort of analysis, but happy to respond to that in a post-hearing data request if you'd like, and find out if it is possible, then we'll have them run the analysis.
When you all engaged in financial hedging, were those costs privatized by the company? Were those incurred by the utility exclusively, or were they socialized amongst the entire customer base, or the applicable customer base? Let me ask you this differently. Did you pass on the cost of financial hedging to customers?
That's exactly what I'm sitting here trying to remember. And yes, I believe it did go through the GCA.
The GCA, and I know you may disagree with the term, but I'm just going to keep using the term economically indifferent. It's a pass-through,
Okay.
the GCA. The pass-through of the GCA makes the utility economically indifferent to weather?
No.
No, how not? Why not?
So, we do have a weather normalization adjustment that applies to small volume customers, residential customers, and it somewhat mitigates the effects of weather, but we are not financially indifferent to the effects of weather.
Yeah, I want to be clear. My question here is specific to the cost through the GCA.
The cost through the GCA, so all of the costs that we incur for the gas to supply customers is ultimately designed to be recovered at cost through the GCA. And it's,
Regardless of weather, temperature, the volume of customer usage, or the price of gas, right? Price of the
Correct.
commodity.
correct,
Okay.
yes.
So I asked earlier about the term headroom. I said that it was a term that industry used. Do you remember what you said back?
That's not a term that I use.
Yeah, I think you said it's not a term we use, but that's fine.
Okay.
If you meant it specific to yourself, that's fine.
I don't even think we use it. yeah.
Ms. Frederick, can you mind us? I've got a document here, and it's going to be weird for me to basically introduce it, but those three are for Ms. Cooper, Ms. Honaker, and Candace, please, Ms. Sakurai. So this is a document, we'll just call this PSE 1. And then here is, here's one for everybody else. Thank you. So I'll give you a chance to look at this document. It's a 60-something, I think, page document, printed front and back. And it's a investor presentation made by NiSource in November 7, 2022. As you're scanning that, I'll just ask you real quick. NiSource is the parent company of Columbia Gas, which is the parent company of Columbia, Kentucky, right?
Yes.
So everybody else in the room, except for you and Ms. Honaker and myself, have the full version of the presentation. Everybody else has a couple of selected pages.
Oh, okay.
Okay. So I'm going to ask you to go to the first selected page. Oh, I just want to make sure you confirm that this is, NiSource is your ultimate parent company, right?
Yes.
Your Honor, can I ask where this was it presented to the commission in a case
Nope,
or
just
something?
World Wide
or-
Web.
Okay,
Yep, publicly, it's just on the NiSource website.
okay.
Yep, from the company's website. So on page 39 of the document, let me know when you get there. They're marked, I know it's very hard to see because it's white on orange.
Yes. Or yellow. Page 39?
39. Let me know when you're there.
I think I'm there.
Okay. And this is, the top is operational excellence, driving efficiency.
Yes.
Okay. Do you see at the bottom, or at the top, excuse me, to the right, it says flat annual O&M 2022 through 2027?
Yes.
O&M is short for operations and maintenance,
Yes.
and usually operations and maintenance expense, right? Okay. Do you see the first bullet point? It says supports average annual customer rate increases of less than 3% annually?
I see that, yes.
Will you let me know what the second bullet point says?
Provides bill headroom for customer and reliability investments.
Do you know what that could possibly be referring to?
Provides bill headroom for customer and reliability investments.
Let me withdraw the question and ask it this way. You are an expert on rate cases and your utility regulation, at least as it relates to Columbia Gas, right?
Well, thank you.
I don't,
I've been doing it for a while.
I'm basically doing a dauber here, right here, but you have been doing it for a while. I
Yes,
tried,
for
last time I got in
Kentucky.
trouble for having basically asked that question, so I tried to just get you to just You are an expert.
Okay.
Okay, so, but if you can reduce or hold constant O and M, okay, then just by definition, you can increase, as a utility, you can increase your capital investment without it showing up on customers' bills or reducing the impact on customers' bills. Would you agree?
Yeah, you can mitigate,
Okay, and if you can, I hear it sometimes like there's a ratio, an internal ratio sometimes that utilities use where for every dollar of O and M they can save, they can actually make a certain number of dollars of capital investment without ever impacting customer bill because of effectively the amortization or depreciation of capital costs, right?
Yes.
Okay, and that's something you've experienced or heard of or are aware of, right?
Yes, yes.
Okay, so would you agree that this page seems to be talking about that? That if they can, if NiSource as a company can reduce or mitigate O and M increases, then there would be, quote, bill headroom for customer and reliability investments, capital investments.
Yes, I
Okay.
believe those would be capital investments, that's what it says.
Would you agree that the mega rule that you were discussing earlier, investments required by the mega rule would be reliability or safety investments?
Yes,
Okay. Then, 2 pages later, on page 41,
I don't know the magnitude of those, I just hear it's dollars.
That's
but
okay.
I don't know the total. Oh, okay, page 41, you said?
yep. And it's a page entitled, or the top of it is Capital Investment Driving Robust Rate-Based Growth. Let me know when you're there.
Okay, page 41.
Okay, do you see the subtitle to it? That starts off cost management / efficiencies?
Yes,
Do you mind to read that?
well, there's that word again. Cost management / efficiencies to create headroom to drive sustainable investments to grow rate base from 2021 to 2027.
Okay, and at the bottom, it shows that the compound annual growth rate, or it just says here, annual growth rate, for rate base across all of NiSource's jurisdictions is somewhere between 8 and 10%. Is that right?
Yes, that's for NiSource
Okay.
overall.
And at the bottom, it shows that that's balanced across jurisdictions.
It says rate-based growth balanced across jurisdictions, generation investments, drive business mix of gas approximately 65% and electric approximately 35%.
Okay.
Generation investments.
All right, so earlier we were discussing utilities make money by making investments, right?
Yes,
So this is talking about the pace at which NiSource, as a holding company, intends on making investments across its operating jurisdictions. Would you agree?
NiSource overall, yes.
Okay. Then we go to the next page, which, it's not the next page for you, I apologize. It's the next page for everyone else in the room except for you and Ms. Honaker. It's page 54 is the next page for us. And this is the Columbia Gas of Kentucky page. And just let me know when you're there.
Okay, 54, yes,
And it's the Columbia Gas of Kentucky page?
yes.
Okay. What's the rate base growth from 2016 actuals through 2021 actuals at the bottom of that page?
It says 12.2% CAGR.
So that's somewhere between 50 and 20% higher than what the company expects, what NiSource expects on a going forward basis company-wide. Would you agree?
Well, I'll have to go back.
It was
over.
8 to 10.
It was 8 to 10. And that's 8 to 10% going forward, I think it said. Oh, wait, what was that? What page was that on, please?
41.
41. Yeah, so there's not a percentage on here that shows,
Yeah, my question was, the
2016
historical
to
growth
21.
rate of Columbia's, rate base is somewhere between 50 and 20% higher than NiSource's forecasted rate base growth rate.
well, that's Columbia's, Kentucky's historical versus NiSource's forecasted
That's right.
that you're comparing. Okay,
So basically, 8 to 12 is a 50% difference, and 10 to 12 is a 20% difference. Would you agree?
that was, oh, okay. Well, yeah, but you're comparing historical
rate
to
base
the
growth with
forecasted.
Yep.
Okay, or projected, yeah, and I don't, maybe it's somewhere else in here, I don't see, that it's, nor have, done a calculation of the actual 2006, how the Kentucky compares to the NiSource 2016 to 21, but.
Yeah, I don't either.
Okay.
I'm just asking the question, would you agree that that's the math comparison?
Yes,
Comparing
I agree
the
with your math.
historic compound annual growth rate of Kentucky compared to what NiSource is expecting on a forecasted basis, system-wide?
I'll agree with your math. I'm just looking at the same actual, historical for some of the other operating companies.
And every slide is a little different for those. Sometimes
Yes.
they include the same information, sometimes they include different information.
Oh, okay. Well, I was just looking at that little graph, and it seems to be on every page, and
Okay,
Columbia, Kentucky is not the lowest, but not the highest either. Okay, sorry, I was just looking at these pages. I've
that's okay.
not seen this presentation. Okay.
Do you know what, let's get this way. Do you know what Columbia of Kentucky's net income was in the calendar year ending December 31, 2022?
No, off the top of my head.
Would you agree that it would be included in the company's annual report filed with the commission?
Yes.
Okay. And there's a whole page in that shows, okay.
Yes.
So I'm looking at it here, and I'm not asking you
Okay.
to tell me, but it's $24.3 million.
Okay.
Okay, last time the commission looked at these choice programs or whether to expand choice was that 2010 investigation, right?
The last time, the 2010 investigation was the report for the Legislative Research Commission. I think that Columbia's last authorization prior to our request in 2021 was maybe 2000,
Happens every day
Was
at 4.
oh, okay, sorry, 2017 or something like that.
Yeah, my
Mr.
question,
Malone, we were discussing how many there were. I
my
don't,
question is broader than Columbia.
Okay.
A big investigation of choice generally.
yes, I believe that LRC report was the last,
And that's the 2010-146 in the matter of an investigation of natural gas retail competition programs.
yes,
Okay.
that sounds right.
Do you know what your all's net income was then?
No,
Okay, about $10 million, does that sound about right?
I don't know.
Okay, but that would also be in the annual report
It
filed
would
with
be
the
in the-
commission
yes,
and
that's correct.
under oath and affidavit by whoever the person
Yes.
submits the annual report. Okay,
Yes.
great. All right, so you all have grown rate base at a double-digit rate between 2016 and 2021. Your net income, and the record will speak for itself, has grown from something less than $10 million. It was like 8.6, I think, in 2009, when the last time the commission looked holistically at choice programs across the state, to the most recent year of $24 million. When you filed to extend this case, I think the most recent annual report in 2022 said that customers, the counterfactual you did at the request of the commission, that customers had paid something like 67, 68, high 60 million dollars more under the marketers than they would have if they got their gas from Columbia, right?
I don't remember the number, but whatever the report said,
Okay,
yes.
whatever the
It
report
was
said.
something less than 74.
But then, after sometime late last year, sometime earlier this year, all of a sudden, there's a concern about the cost resulting from the mega rule, and we've got to get rid of the program. Is that your testimony?
No, it's not just one thing. It is looking back at all of the position of where choice has been. We're the sole provider in Kentucky, and looking at what may be out there on the horizon. It's not just one thing.
Yeah, but
It's
let me narrow my question, then, Ms.
Okay.
Cooper. Your concern around customer cost, okay, focuses exclusively on this program, right? When you stated it earlier, you said you were concerned about this cost, knowing in your mind that you all have to also comply with this mega rule. That was your testimony earlier, correct?
My testimony was the cost to customers of, the gas cost to customers and the lack of savings is a concern of, one of the concerns of this program.
Okay.
Looking ahead, it's not just cost of the mega rule, but overall inflation and other investments that may be required or mandatory moving ahead, and not just one thing.
Yeah, so-
I can't hang it on the mega rule by itself or anything else by
I
itself.
get that, but that was the primary thing that you mentioned. What I want to get clear is that this is a concern. You mentioned inflation, I think, earlier as well. This is a concern around the end-use customer's bill. Is that right?
Yes,
Is that what you recommend the commission look at in determining whether rates are fair, just, or reasonable? Is the impact of a proposal on just the bill?
no, because the commission has a dual responsibility as the balance between customers and utility shareholders. So it's not just one or the other, it's to provide a balance between the needs of the customer and the needs of the utility and its shareholders, and to find what's fair, just, and reasonable. Which those two are more than likely competing interests. So, finding a balance and a fair, just, and reasonable outcome to rates is, in my view, that's the commission's job.
Okay. That's a fine perspective to have. Where do you all fall in on this one? What is your interest in whether this program continues or doesn't continue?
Columbia's interest is to have the program continue as we originally proposed through March 31, 2025. Our intent is between now and sometime by March 31, 2024, file with the commission a proposal to wind down this program and provide other opportunities for non-residential customers to have supply options other than tariff cell service.
I get that that's your proposal, but how does your position and your proposal impact the customer one way, or impact the company one way or the other?
How does it impact the company one way or the other?
The company. You said earlier, right, that we're supposed to be balancing this is your position, balancing impact of issues between the utility and its customers. Your basis, it sounded like to me, your testimony for getting rid of the program or making the subsequent filing that you intend to make is because of the impact of the program on the customer. And I'm asking, what's the interest of the utility, of the impact of the utility? What do you gain to benefit? What do you gain not to benefit? What's the detriment to the utility in getting rid of this program?
The benefit to the utility of getting rid of the program. I guess I don't really, it's not that Columbia is doing it as a benefit to itself, other than to try to address that I don't know that there is a
Are you indifferent?
benefit to
me.
Columbia. Yeah, we're basically,
Different.
that's why we have been,
Using your term lukewarm?
yes.
Okay. Does that carry through to the questions that you've gotten and the answers that you've provided on the education that's provided and how you all have carried out the program?
Does the indifference, if you will, or the lukewarm?
Yeah, I mean, either word, whatever you, the fact that you don't make money one way or the other, whether you do it through the GCA, whether you do it through, let the marketers do it, does that indifference, I mean, is it not just reasonable to assume that the indifference economically to the utility, it plays some role in how you all treat it? That if there was let me ask you this way. You all aren't indifferent to the level at which you invest, right?
Correct.
Okay, no utility
We
is.
are a for-profit entity.
That's right,
Yeah.
that's right, okay.
We have a
It-
responsibility to our shareholders.
If you were
Yes.
indifferent, I'm sometimes I surprise myself how smart I am for just like 1 second. Have you ever heard of the term operating ratio?
Yes,
Okay, so a utility we can set rates based off of rate base as a rate of return on rate base, right? And that effectively sets a utility's profits based off of how much they invest, and if they invest more, all else equal, they make more, right?
yes,
Okay, but you can also set legally a revenue requirement based off an operating ratio, right?
yes.
And that
I don't know, well, this is calling on my old days.
You keep using those terms, Ms. Cooper. Not me.
I know,
I just wanted to
okay.
be clear on the record. I'm not. You really got on to me last time. It's not you. It's not that long since you left here. But you're aware of the use of the operating ratio to set rates, right?
I believe that was used for, I want to say, rural electric co-ops.
Tier is ordinarily used for rural electric co-ops, but
Okay.
operating ratio sets the revenue requirement based off of a utility's operating expenses. Do
Okay.
you remember that?
Yes, I'm trying to
Okay.
remember, yes.
Maybe small
Who it was
gas
used
or
for.
small water utilities?
Maybe it was, okay, maybe that was it.
Okay.
Okay.
And so if you set a utility's profits based off of their operating expenses as opposed to rate base, all else equal, the utility will make more money the higher their operating expenses are, right?
If you establish their, yes, yeah,
Yeah. And if they aren't making any money based off what they invest, then whether they invest $0 1 year or $100 million next year, if their profit and their return is off of operating expenses, they're economically indifferent to the level in which they invest if it's a pass through effectively.
in theory, but there's also a responsibility to provide safe and reliable service, and you have to make investments to do that.
That's fine. So, you all, the commission, no, not you all, the commission with the PBR said, hey, you guys are economic indifferent to the gas costs, we're gonna give you an incentive to try to find more savings than you might otherwise. We agreed on that earlier, right?
Yes.
Okay, but you guys, there is no incentive necessarily for if the program, the choice program is successful or the choice program is not successful, whether customers make money or don't make money. We agreed a second ago, you agreed with me, Columbia Gas is indifferent.
On a financial basis, yes.
Okay.
Except
And does it not make sense to you that that would be a recipe for a program not to work? That it depends on a party that's economically indifferent to success?
Well, we might be financially indifferent, but customers are not financially indifferent.
I agree with
And
that.
we have an obligation and also it's just the right thing to do to look out for our customers. And granted, some of our customers may have saved, some of them may like getting airline points and fuzzy teddy bears or whatever they get, I don't know. But the question becomes, is it worth what's involved to provide a benefit for a few at that are declining? And where do you stop that and say, let's think of another way?
Would you agree that program design and program implementation for any program that the utility runs are two distinct items? That both of them need to be successful for the program to be successful?
Yes.
Okay.
We've learned a little bit about that, I think.
What's that?
We've learned a little bit about that, I think.
Okay. So, are you aware that in the 2012 investigation that we talked about, that the commission did, ultimately resulted in a report sent to the LRC, that Columbia provided information that for the first 5 years of its choice program, between 2000 and 2005, customers received approximately $11 million in savings. Choice customers received approximately $11 million in savings in aggregate.
There were savings, I don't remember the exact number, but yes.
And
It's in one of those reports.
Just
Yep.
talking about I
Yeah.
had the December 28th order. I don't know who here was at the commission on December 28th entering that order, but good for them.
What year was that?
What's that?
What year was that?
December 28th, 2010.
Okay.
All right, so the first 5 years, there was approximately $11 million in savings. 11.4 is what the commission's order says. In the second 5 years of the programs, customers cumulatively paid $17.3 million more. No, I'm sorry, 17.3 since the program was put in, 11.4 in savings in the first 5 years. So I think maybe that 17.3 is really eroded, and then, but
Okay.
the order will speak for itself. I want to ask that there was a change to the program in 2005, right?
Yes.
Is there a program design issue that we have here where in the first 5 years of the program, it was wildly successful, and then when the program was changed, it's now resulting in, I don't know, either 74 or 74 plus $11.4 million in cost to customers?
I think the program as it's currently designed and the 2010 LRC report will speak to the program design. The change that happened when the program was initially offered, we had a number of marketers who were offering a guaranteed savings off of Columbia's gas cost, and that was the offer that they made to customers. So that was, of course, very appealing. And those offers dried up. Of course, market volatility comes into play. one of the interveners asked me, did I know how marketers hedge or do their gas supply? And I do not know, but the early offers, there were a number of them that were a guaranteed discount of some percentage off of Columbia's gas cost. That's how customers saved. Certainly, all the customers that were on that sort of a rate saved. Others on fixed or variable rates may have saved too, but then the volatility, the price of natural gas shot up. I believe that was in 2001 when it really shot up to maybe, I don't know if it's still an all-time high or not, but it was up about $20 on the NYMEX prices. And some marketers survived, some did not. So it's a variety, a number of reasons why the early years produced savings. Originally, prior to 2004, marketers, we did not assign pipeline capacity to marketers. They were allowed to purchase capacity and utilize their own capacity then to serve customers. One of the requirements of the program was that capacity that they were allowed to purchase, but it had to have primary receipt point deliverability, meaning it was firm capacity. It could not be interrupted, and since Columbia did not have the pipeline capacity to be able to supply a customer, because that was now the responsibility of the marketer. The requirement was that once a year we were to audit and verify that those contracts had primary receipt point deliverability. Of course, if you do not have primary receipt point deliverability, you can buy capacity on the secondary market, which is of course widely available when it's not cold, or now with electric generation really hot. That you can buy capacity at much less than the FERC authorized rates for pipeline capacity. When we did that first audit, not one single marketer had primary receipt point deliverability for any of their supply, which meant that when it got cold and it was a peak day, Columbia was not going to be able to serve customers, and customers would not have reliable supply. And that's why, one of the primary reasons why we had to change the program, because we couldn't have risk customers not getting supply.
Yeah, I'm gonna ask as a post-hearing data request, for, a list of all the program changes, prior to that 2005 date, whenever the initial audit occurred,
Okay,
for that reason.
okay.
And then lastly, and I already had this question, but you mentioned it, there was a post-hearing data request, and I forget which one, but it doesn't really matter if you just know the answer. Do you all have generators on your system?
Columbia of Kentucky. We have combustion turbines, but a lot of combustion turbines, but some combustion turbines. I don't know the number, but no, we don't have generating stations.
Well, so you gave a response, number 8 in the post-hearing data request from October 4, 2022 about off-system cells, and you said, as an example, an electric generator seeks to procure gas supply from the marketplace. And then you go on to give an example. I just want to make sure, is this an example applicable that you provided here to Columbia Gas Kentucky, or a fictional example?
Can I see what we're talking about?
Sure.
What was it? The
Post-hearing data request number 8.
Okay, just bear with me a minute here while I figure out where that is in this book.
61, behind 61.
I think I want to talk, but I think I need to look before I speak. did you say 61?
And it's post-hearing data request number 8.
Number 8, thank you, Mr. Chairman. Okay. So this is talking about a electric generator that's not on Columbia's system. It's an off-system sale, meaning they're not on Columbia's distribution system.
Okay. This example is not somebody who is quote-unquote behind the meter and being served off your system.
Correct.
But you have combustion is the Bluegrass station on the Columbia system? Let me
I
ask it
think
this
they're
way. If you have combustion turbines on your system, this is the question I want to ask. If you have combustion turbines on your system, are they a transportation customer?
They may be a I don't know, but if you are a transportation customer and you need firm reliability, then we also sell standby service, which means you have firm deliverability.
Well, that's that question as opposed to your data request. All right. Thank you, Ms. Cooper. I think those are all the questions I have. If I have questions, additional questions about start-stop service, they're just gonna have to be post-hearing, is that right?
Okay, yes,
Is that right? Okay.
yes, sir.
Oh, you may not know this, but I want to ask it so that I can ask as a post-hearing. When a customer's contract expires with a marketer, do they revert to your rate or do they revert to, per the contract, some other rate from that marketer?
It depends on what the agreement is between the customer and their marketer. So either could occur.
Ms. Honaker, do you have an objection to that presentation that you have an entire copy of being part of the hearing record?
No.
Okay. All right, we'll include that as PSC Exhibit 1. Do you have any redirect, Ms. Cooper?
I have a couple about the, you were handed this today, right? And I think
Yes.
you made a comment on the stand that you hadn't seen this presentation, is that correct?
That's correct.
So is it safe to say that you were not a party to creating this presentation?
Yeah, that's correct. Yeah, I was not.
Okay. And so you would still say that you don't use the term headroom, is that correct?
I see it in here now, so apparently, some in our company do, but, that's not a term that I use.
Okay. And then I want to gonna go way back through my notes to get to this one. You were asked, I think very early on, maybe one of the first questions that Mr. Malone asked was about why you kept using the word voluntary.
Yes.
Can you kind of elaborate on that a little bit, on why you use the word voluntary?
So the choice program is voluntary to our customers. They don't have to participate. It's voluntary. It's also voluntary to Columbia that we offer the program. The commission made that clear in, I believe it was administrative case number 346, where they said that LDCs in Kentucky may offer a retail choice program, and laid out the structure, which Columbia undertook in submitting its application in the 1999, or it's just called 99-165 case that initiated our customer choice program. In that 99-165 case, the initial order, when it came out, Columbia sought rehearing on a couple of 3 matters. And they had to do, one of them was, I recall, something about actual regulation of marketers. Another issue was, I can't remember, there were two or three issues. It was limited rehearing, that Columbia sought, rehearing. One of them was whether, I want to say, Columbia was acting as an agent, because legally that made a difference. When the commission issued its order on rehearing, it was not all favorable to the request that Columbia of Kentucky had made on rehearing, and the commission in that order, and I won't get the exact words, but the order's out there, it said that the program is voluntary to Columbia of Kentucky, and Columbia can either accept these modifications or abandon the program, something like that.
And then I'm gonna go back, I think it was Mr. Green that was asking you questions about the December 2022 Green Path Rider tariff that got filed.
Yes.
Do you know when Columbia actually filed the notice of intent that it planned on filing that Green Path Rider program?
Oh, if I could remember the case number, I would know. It's something.
It's 2022-00049 is the case number for that.
Okay, so it was filed early, the notice was filed early in 2022, but it was some months later before the application was actually filed.
All right, nothing further.
Is there anything else that you have, Ms. Frederick?
All right, thank you very much, Ms. Hooper.
Thank you.
All right. You have any other witnesses?
No, we have no other witnesses.
Is there anything else that from the company? Anything else from the applicant?
I don't think so, no.
Okay, great. Thank you, Ms. Honaker. I would ask Ms. Cooper, just in case that you stick around for the remainder of the hearing in case you need to be recalled.
Okay.
Thank you. All right, given the, what's up? Yeah. Given the nature of, we're gonna switch gears here for a second with intervener presentation. Let's go ahead and take a very short recess. I know we're the ones that keep coming in a little late, and that's on me. We'll take a recess until 4:45, and then we'll come back and see how much we can get done. We'll be in recess until 4:45. back on the record in case number 2021-00386. Before we took our break, just to confirm, Ms. Honaker, the company doesn't have anything further, is that right?
No, the company's complete.
Okay, great. Next, we'll move to, I guess we'll start with you, Mr. Malone. Would you like to call your witness?
Actually, we discussed, and from an expedience standpoint, what we think would be Mr. Travis. I'm not going to mispronounce your last name, sir.
Let me just say it this way. Whichever one of you all would like to call your next witness, you may do so.
In that case, Zoom Energy calls Travis Kavula. Mr. Chairman, while he's taking the stand, his testimony was entered in the last case, the last hearing. Do I need to re-enter it again? Or will we do-
No, and just to be completely frank, and it's not really binding on the commission in any way, but once you file it and you file your oath and affidavit in Kentucky for the last few decades, whether you adopt it at the hearing or not, you file testimony, it's part of the record. We're gonna make a decision on whether we have a hearing or not.
Okay,
So,
then I will save us all the time.
So data request and testimony, once it's filed and you've served on all the parties and there's an oath and affidavit, then that ship has sailed. But, so the answer is no. All right, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please have a seat. State your name and business address for the record.
My name is Travis Kavula. The last name is spelled Kavulla, and my business address is 1825 K Street Northwest, Suite 1203, Washington, D.C. 20006.
Thank you. Counsel, you may ask.
Mr. Kavula, were you in the hearing room all day today? Heard all the testimony?
I was.
So let me ask, got about 6 or 7 different topics we can go through pretty quickly. You're familiar with the settlement that we had a hearing on last September and the working group structure specifically that the settlement addressed?
I am.
Okay. In your opinion, would it be fruitful or helpful for the commission to direct the parties to have a working group now as contemplated in the stipulation or similar to what was contemplated in the stipulation?
I certainly wouldn't advise the commission to do it identically as contemplated in the settlement, and that's for the simple reason that the settlement seemed to fall apart due to issues that were explored earlier, particularly the lack of interest in pursuing genuinely market enhancements to the retail market through the working group. I thought the commission gave some pretty light direction around the formation of the working group to try to bolster its processes and make it a productive forum. I'm not sure, given the same structure, if that would be the case now. So I don't doubt that there might need to be a working group to undertake some of the implementation around market enhancements that the commission might direct, but I think it would be wiser for the commission to issue binding guidance on what, if any, market enhancements should be adopted, and then make that decision now, and to the degree a working group is necessary, leave implementation to the working group, rather than having the working group as a forum to discuss the wisdom of the market enhancements
And
per
if the
se.
commission were to do that, I assume you would recommend that the commission also not just direct the working group to implement this particular enhancement, but do it by a certain time period or report by a certain time period.
That's correct.
And now I'm going to lean on your years as a former regulator, or years as a regulator. There's been testimony about that the revenues from the choice program are incorporated into the company's revenue requirement. Did you hear that today?
I did.
And so what in your opinion would happen if the company were to eliminate the choice program?
If the revenues are foregone because the choice program is terminated, and meanwhile there are no costs to be avoided because all of the costs are embedded, in the next rate case, Columbia consumers could expect their rates to increase to recover the costs that are otherwise being offset by whatever amount of revenue is raised through the choice program. So it would be a rate increase ultimately.
Okay. And the next topic is, I'd like to get your thoughts on the financial and regulatory risk that is being created by proceedings like this one, right? And where Columbia is consistently changing its mind as to how long to extend the program for or to terminate the program. And when the extensions only come 3 years, and then there was also testimony that they would be filing to terminate the program, and that filing would be made in March of 2024. Can you comment on how that is perceived in the marketing community and how a supplier might react to that type of uncertainty?
I can. So Zoom and the other retailers or marketers, as we've been calling them today, are presently involved in trying to sell products to Columbia customers. And some of those products are 12 months, 24 months, some of them have even longer terms. Now, if our retail pricing team were to have asked my team in regulatory affairs at around this time last year about whether we could expect what had been labeled a pilot program to persist, I would have given an answer that we were reasonably certain that the program would last longer than 2 years. Now, we are still offering 2-year contract terms, but I could not give that same assurance to my retail pricing team. And I think the way our business model is conducted is quite a bit different than the way Columbia prices its gas. Despite having a label that we're not regulated, typically a retailer, when it makes a fixed price retail offer to a customer and signs up a customer, it turns around and buys all of the gas, financially or physically, that it thinks it will need to fulfill that contract. There's quantity risk associated with the purchase when we turn around and try to lock in our costs to serve that retail contract. But the long and the short of it is we try to supply that contract fully based on the expectation of volumes that we have in terms of serving that customer. So when we're facing a situation where the contract may, through operation of law, be terminated short of its stated term, you create a significant risk of stranded costs associated with the gas purchases that we make in trying to fulfill the terms of those retail contracts. So that I think is the financial risk at play here, and that uncertainty, I worry, is going to cause more marketers either to not offer such products, which are really the main source of value, in my opinion, to this retail market, aside from other value-added services that are part of these offers, or it will cause those retailers to increase the price of those longer-dated products in order to incorporate a risk premium associated with the regulatory risk that this program terminates. Because I can't reasonably tell my team that this program will still be here for the final portion of the contract if one were signed today for a 2-year term.
So Ms. Cooper suggested that perhaps suppliers might consider including a regulatory out clause in their contracts. That might be a 2-year contract with a regulatory out, so if the law changes, the supplier can just terminate the contract. In your opinion, does that address the financial risk involved?
It does not. Under the retail tariff that Columbia Gas has approved, there's a code of conduct, and the Commission's way of regulating our industry is through its regulation of Columbia and the imposition of a code of conduct on the marketers. That code of conduct requires that marketers include a regulatory out provision in any retail contract. In other words, the retail contract is superseded if the Commission makes a contrary decision and terminates the program. However, that is not the deal we make in the wholesale gas markets. We're trying to buy gas at the wholesale level in order to furnish supply and to lock in our costs of goods sold to the retail contracts we expect to service. And those, there is no provision in any wholesale gas contract that allows the retail rate making and tariff design decisions of the Kentucky Commission to overrule those terms.
So can I just just clarify, Mr. Green, who are the counterparties of those agreements?
They could be financial players, they could be physical marketers of gas, the oil and gas production companies. There's a wide variety of both physical and financial players.
So you mentioned a 2-year contract where the marketer has hedged the gas. They've bought forward gas. After a year and a half, if the program's terminated and there's a regulatory out clause, you still have 6 months of gas that you've paid for.
That's right. We'll have to find a way to liquidate that position, which we had held with an expectation of serving retail customers into the open market, possibly at a loss, possibly at a gain, but in any case, we bought the gas in order to symmetrically face our retail price exposure. And again, a very different business model than that of Columbia, which has a much greater exposure to the wholesale gas market and which passes along that volatility in its quarterly updated tracker.
And moving to the next topic, there was been a lot of discussion on the stop, start, move, seamless move issue. Do you have an understanding of, as a marketer, how that process works?
I do, and I hope I can clarify this once and for all while I'm up here on the stand. So when a customer calls Columbia and seeks to move that customer's account from one premise to another, but within the Columbia service territory, that process is handled seamlessly as regards the distribution and delivery of gas. However, a new account number is assigned, and in the process of creating a new account number, the supplier, if they do business with a choice marketer, is automatically dropped. So when I'm a customer who moves from point A to point B in the Columbia service territory, unless the customer proactively thinks to call me, that we will find out only a month afterwards that we no longer have a customer. And then we'll try to reach out to the customer, say what happened. Maybe we'll learn that the customer has moved, but in any case, it's up to the customer to go through the entire enrollment process again with us as a marketer. I assume we would be willing to, on our side, to restart the retail contract. But in any case, we would then have to submit that enrollment back to Columbia. And if it were submitted before the 15th day of the calendar month, that customer would be stuck on Columbia default commodity service for at least one billing cycle. If we submitted it after the 15th of the month, they would be stuck on Columbia commodity service for at least 2 months. So this is why in my testimony I advise seamless moves, and it actually sounds like we agree in principle with how it should work, but that is not, it is not seamless on the commodity side right now. And so one of the proposals that I make in my testimony is that while Columbia is doing the business on the back end associated with switching over that customer for delivery service, it should take care to also coordinate with the retailer and switch over the contract so we don't have this gap. And I will say, even a customer who is particularly alert to this situation, who thinks to call both the utility and their marketer, even if they do that, they'll still be defaulted under the status quo back onto Columbia commodity service for at least one billing cycle because of this calendar gap. So that appears, that data request that's answered by Columbia appears as exhibit TK13 in my revised direct testimony. And to the extent that that doesn't provide all the information, what I said here is an accurate representation as far as we on the marketing side understand the situation.
Okay, thank you. And next, I'd like to ask about your proposal for, to allow for enroll with your wallet. Do you have with you what was entered earlier today as Zoom Exhibit 1, which is the list of data points collected by Columbia when a customer enrolls or customer starts service with Columbia?
I do.
And in your testimony for enroll with your wallet, I believe essentially what you say is that Columbia shouldn't demand the account number to enroll. There may be other data points that they can rely on to make the enrollment easier. The types of data points that customers actually know and don't have to look to their bill, that they can sign up, at a mall or somewhere other than their home, right? Are there any data points like that that are helpful on this Zoom Exhibit 1? Well,
there are. So, natural gas is a low visibility, easily misunderstood marketplace by consumers. And when a customer is asked to furnish their account number, a 15-digit number in order to buy a marketer's service, I think they're understandably, if not confused, then at least they don't readily possess the information frequently, except at their home, which often then leads to marketing practices that we prefer to avoid, like telemarketing or door-to-door sales. So an improvement that I propose in my testimony is to allow a customer to, for example, give their name and their date of birth in order to validate that they are who they say they are, or give their name, their date of birth, and the last 4 digits of their social security number in order to validate who they are. and then have the marketer be able to furnish that information to the utility as a valid enrollment signature, essentially, rather than absolutely needing to have the 15-digit account number, which again is not readily known to the customer. We think that would, in general, improve the overall shopping experience, make it less complex, lead to less, false signals, essentially. I mean, frankly, I'm always reading off big numbers to people on the phone, and I'm getting it wrong or they're getting it wrong, and that will just lead to a bad customer experience because that customer will ultimately not be enrolled. So that's one seemingly pretty straightforward way that this market experience could be improved for retail customers.
And now, Mr. Cavula, you have before you two tables, and I've already passed them out to everybody. I'd like to start with the first one, with the one that has more blue on it than the other one, put it that way. And I'd like to ask that this document be marked as, for identification, as Zoom Exhibit 2.
So March?
And we'll go ahead and mark the other one while we're here as Zoom Exhibit 3. If that's okay.
All right.
Mr. Cavula, the Zoom Exhibit 2, was this prepared by you or someone under your supervision?
Yes.
And could you please tell the commission what it is?
So this is the one with more blue, you're saying?
Yes.
The blue rose. Yes, okay. So these are the products that are currently being offered by Zoom in the Columbia Choice program to customers. And you can see their which customer class they apply to in the column that says class. You can see the term of the product ranging from shorter term variable rates to 24-month fixed rate contracts under the column that says term. And then you can see the price offer we are making to customers under the column that says rate. And then the column to the right of that, price to beat, is Columbia's gas cost adjustment, the GCA, which is the price that will be substituted for on the customer's bill if they choose to shop with us instead. And then you have a comparison of our rate offer versus the Columbia gas rate in the column after that. Finally, the column that reads incentives are other amenities that we offer customers who enroll with these products, some of which include airline miles or cash back or charitable contributions made in the name of the customer to a charity focused on animal welfare for this particular brand.
And you may recall my question to Ms. Cooper earlier today that the price comparison tool on the Columbia website wouldn't show any of the incentives on the far right column, right?
No.
Okay. And the rate, the second column from the right, the rate versus it says PTB, I guess that's the price to beat?
That's right.
That's and the price to beat is the GCA price that we've talked about today, right?
That's right.
Okay. And so what this shows then is that all but one of the current products on the market from Zoom are priced lower than the GCA. Is that right?
That's correct. You can lock in a rate that's lower, sometimes substantially lower than the currently prevailing utility gas cost, and for a term that varies from 2 months to 24 months. Obviously, the GCA on the part of the utility will vary. It could go down, it could go up, depending on what the wholesale market is doing. Again, the utility is more exposed to the wholesale market than our retail customers are in this business model. But the value to this is that consumers have the ability to essentially lock in a rate to buy insurance that their gas costs will not vary on a rate basis over a certain course of time, and to shift the risk associated with the cost of supplying that back onto us to manage, because we have no, unlike the utility, we have no ability to come in and surcharge people after the fact through a GCA-like tracker if our costs do somehow rise. For example, if the customer has an especially cold winter, uses a lot more gas than we expected them to, we have no ability to gain more revenue other than the fixed rate we offer that customer under these plans.
Okay, and then the next document, exhibit, what's been marked as exhibit number 3?
Yes, I
In
see
your
that.
revised testimony, you describe a 12-month product that went essentially from the summer of '21 through the summer of '22. Do you recall that?
I do.
And so, turning then to exhibit 3, what are we looking at here?
You're looking at an update of the table that exists on page 9 of my testimony. So whereas Zoom exhibit number 2 that we just talked about are the offers that we currently have on the market that are forward-looking, and we don't know how the utility GCA is going to change. We don't know whether or not the insurance product that you're buying from us, if you sign up for one of these rates, is going to pay out or not, if you will. So this is a look back to see how one of our products performed relative to the utility GCA over the previous 12 months. And the table updated figure TK3 in my testimony at page 3 is just the same thing, except it goes from September 2021 to August 2022. And as you can see, for each of the products we've selected here, which is our pretty straightforward 12-month fixed rate product for both residential and commercial customers, a person who bought this insurance product essentially from us, the insurance paid out. They actually would have experienced savings relative to taking service from the utility over this period. In the case of residential customers, those savings are about $95 for a typical residential customer. And for an average commercial customer, the savings would have been about $320. That's slightly down from the table I presented in page 9. And it's worth noting that table in page 9, encompassed a period where prices began to spike after the Russian invasion of Ukraine, and gas prices started skyrocketing. So in the first table on page 9 of my testimony, I believe I said page 3, it's actually page 9, you see some savings that amount to $154 per residential customer and $474 for the typical commercial customer. A similarly situated customer who decided to enroll on one of our 12-month products in July of 2022, so roughly at the end of the period represented on page 9, because this proceeding has gone on for a while, we have all this data, would have persisted in experiencing savings over that same time period.
Okay, and Your Honor, I'd ask that the documents marked as exhibits 2 and 3 be entered into the record as exhibits 2 and 3.
Ms. Honaker?
And with the first one that's marked number 2, when we look at the commission's websites, these do not coincide with what's listed on the commission's website for what they're currently offering, so we have no way to verify that, to see if this is what their current offers are
Your Honor,
at this time.
May I ask the witness that very question? Because we noticed that the other day, and we have an answer to that if asked. So,
I was just gonna tell you, Ms. Honaker, you can take that up on cross-examination, but,
Okay.
yeah. I mean,
That
we
would be
draw-
my objection to the entering of this into evidence, is we have no way to know whether or not this is actually correct, accurate data. We don't know if the calculations for the CKY commodity charges are the correct and actual data. So, I don't know, they just did like a calculation, so we don't have what that was going into that calculation, if that makes sense.
That'll be fine.
So-
So, just for a second, I'll take your objection without ruling on it for just a minute and give Mr. Green an opportunity to ask an additional question if you'd like to lay more foundation for the
sure, I will
exhibit.
do that. Mr. Kavula, if I could direct your attention to exhibit 2, please. The point has been raised that the pricing, the rate column, I presume, on this exhibit may be different from the rates that are currently listed on the commission's website. Do you know why that might be?
Well, I'll first say, Mr. Green, that I did, through the course of today, look at the Zoom Energy website, and these are the offers on the website that currently exist. And as was testified to earlier, the commission's website is updated once monthly, I think, to show various rate data of the marketers. It's not we would prefer it to be a fully dynamic website where retailers are under an obligation to furnish information to update that website to create a more dynamic shopping experience. But as has been testified to, there's only an occasion once every month where Columbia transmits that information to the commission posts it on their website.
So what is your understanding of the process of how the commission's website gets updated?
Based on the testimony today, Columbia looks at the various marketers' websites. It pulls that data, I assume manually, and then it sends an email or some kind of correspondence to the commission informing them that these are the marketers' rates as of that moment in time.
Okay. And the rates, I think you just said this, but the rates that are on here for the Zoom products are consistent with the descriptions on the Zoom website, correct?
That is certainly my understanding. I could pull up my phone and probably look at it right now, but I looked at the rates earlier, and these look consistent with those rates.
Ms. Honaker, would you like to readdress your objection?
No, we would just say that we've not been able to verify that information or the information on the exhibit number 3, so.
Okay, all right, I'm going to overrule the objection. Don't know that we've ever required prior provision of the exhibits, and it stands for what it is. If you'd like to conduct cross-examination, you're certainly
And
more than able to do so. Mr.
Your Honor,
Green?
just some guidance. At the last hearing, Mr. Gula updated his testimony, and the commission required a motion after the hearing. It just occurred to me to ask whether we would need to do that again for these two documents.
No, these are just hearing exhibits, right? Yes.
Yes. Okay. And then the last area to discuss, Mr. Kavula, is, did you hear Ms. Cooper talk about a program years ago, or at least suppliers years ago, that had committed to offering a specific discount off of the price to compare for their own products?
I did hear that testimony.
And can you talk about your standard offer program proposal and whether you believe that's similar to what Ms. Cooper was talking about?
Yes, I mean, here is another place where we propose a market enhancement that is actually aligned to one of the things that I heard Ms. Cooper say, and which I think the commission should explore. And that's a way of getting more customers into the market for shopping by offering a guaranteed savings off of the then prevailing gas cost adjustment that's tariffed by Columbia. And how it would work would be Columbia would be under instructions to have, at certain points, customer service representatives. If, for example, a customer called in asking about alternatives to gas supply or wanting to save money, the customer service representative would be scripted to ask the customer whether they were interested in enrolling in a third-party product that would save them a fixed percentage of money by rate off of the Columbia rate, a standard offer program, it's called, in the state of Pennsylvania. And if the customer said yes, they would then be referred to one of the marketers enrolled in this program to go through an enrollment. It would not be a guarantee of savings over, a 24-month period necessarily, but it would at least give the customer an option to save money off of the prevailing quarterly GCA. So, in other words, it would seek to replicate a feature of the market that has gone by the wayside, and would also put the utility in a position of actually having another tool where it could promote the shopping experience for customers who do actually care primarily about both budget certainty and savings combined. So that's one of the market enhancements I had proposed in my direct testimony.
So Ms. Cooper indicated that that type of savings guarantee worked well in this service territory. And you mentioned in your testimony that on the electric side, Pennsylvania has done a similar program. In your opinion, what have the effects been for customers who have taken advantage of the standard offer program in Pennsylvania?
Well, those customers have benefited, and you see increases and decreases, usually driven by how much rates are fluctuating at the regulated utility level in terms of enrollment. But the program has had a number of retailers or marketers participating in it throughout its existence, including some of our companies. It removes some of the transaction costs that otherwise, plague a low salience, low visibility marketplace like this.
Thank you, Your Honor. That's all the questions I have. The witness is available for cross.
Mr. Malone, you just want to remind me here, your expert actually adopted Mr. Kavula's testimony previously, right?
He did.
All right, I hope you don't have any offense, but we're gonna not allow you to conduct cross-examination on what is
breaking my
now
heart.
explicitly a friendly witness. Ms. Honaker, do you have any questions for
Any
Mr. Kavula?
questions?
Ms. Rutter?
Yes, a few. First, Mr. Chairman, as a preliminary matter, we have discussed the Columbia Gas Choice Report for 2023 a lot today, but I don't see it anywhere in the record. So I've got some hard copies I will make available, and I would move that this be made an exhibit, staff's hearing exhibit 1.
Okay. Mark and introduce.
Mark and introduce.
Ms. Honaker?
No objection.
Mark this and include it
Chair,
as
if you need a
staff
speech
hearing
bubble.
exhibit 1.
Do you have a copy of this if not here?
I will take one from you, because I have it on my phone, but it would be much more efficient.
Do electronic copy I'll use.
You give it, you want to, you have it.
I got it on my email for you.
Okay, Mr. Kavula, and if I murdered your name, I'm really sorry.
You got it right.
Just in reference to that report, we talked a lot today about the $74 million number of negative savings, calculated since 2000 to now, involved in this program. And what do you believe is the value of the choice program to Columbia customers, considering the fact that participating customers as a whole have not saved money?
Yeah, so I do regard its primary value as affording price and budget certainty. And you can think of it again as a type of insurance product. And to compare it to, actual insurance products, I suppose you could think of a property insurer. A property insurer will typically take in revenues and premiums paid by customers that are larger, hopefully just slightly larger, than the amount it pays out in claims over the long term. If it didn't, it wouldn't be in business and it wouldn't have any insurance product to offer. It's in a sense a similar thing here. The value of locking in a price to your gas supply, a notoriously volatile commodity, especially over the last 2 years, as some of these other exhibits have demonstrated, that has a value. It's sometimes difficult to quantify. The cost of it certainly shows up here in the form of the $74 million figure. And I guess in order to take a perspective on the cost of that hedging, if you will, you would need to compare the $74 million to the total amount of revenue billed for all commodity sales over the past 23 years, I guess, which is not a figure I have, but which is a figure that will almost certainly be in the billions of dollars for Columbia Gas of Kentucky. So you'd want to compare those two figures in order to really gain an understanding of the cost of this type of insurance program, And then, obviously, value is subjective. You know, people will value that price certainty at different levels than others. And again, sometimes the insurance will pay out and sometimes it won't. I mean, I make a claim in Zoom Exhibit 3 that a customer who bought one of our products at a particular time, and we didn't choose those times randomly, they were tied to like the date when I had to file my testimony and the date of the last hearing, those insurance products happened to pay out. So people signed up, they got both the value of price certainty and they got the benefit of lower price gas. But I make no warranty that our costs over a 24-month contract will necessarily be cheaper than what a customer would have to pay from now until July 2025 for natural gas if they took it from the utility. The difference is with the utility, they're signing up for a greater measure of wholesale price volatility, that because the utility has a pass-through tracker, it's pushing down onto customers, which is, again, not the business model that we have.
I just want to make sure that your microphone is green.
My microphone is green.
Okay, all right.
I would also say, sorry, I know I went on at length there, but the hope too is that you will get product differentiation in the form of other amenities that can be added to these programs. And, you know, across our company, in aggregate, our retail customers have contributed a lot of money to charitable causes that are an add-on to our retail products. We are seeing the introduction of environmental attributes associated with natural gas in this and other markets. That's a nascent product for now. And so that's another source of value addition. One of the proposals I make, and this is something where we would have some work to do actually, but one of the proposals I make for a market enhancement in my direct testimony is a requirement that every marketer serving customers in Columbia offers at least one green gas product to customers as a condition of doing business in the Choice program. So in other words, trying to use the Choice program to drive innovation and product differentiation, in addition to offering the core value of price certainty that I've spoken about at length.
Okay, something else that's covered in the 2023 Choice report is the number of customers that participated in the program over the past year. And this report seems to show that 2023 saw lower participation with residential and commercial customers than any previous year. Have you or Zoom seen your own number of customers that are participating in this program drop?
Mr. Cavilla, before you respond, we are having a problem with the microphone. It's not picking up on the,
Oh, it's blinking.
It's flashing.
now hit it.
Now hit it?
Yeah, the finger. Is it solid?
It's solid now,
Okay.
and it appears to be working.
Then that means it's working.
Okay, I'm going to repeat my question. Has Zoom seen a decrease in customers for Zoom that are participating in Choice?
I do not know. My impression is that our own customer count has remained relatively steady from when I first presented testimony in this case to today. And
Over the course of years that Zoom has been a marketer in this program, have your customer counts remained steady, or have they dropped, or have they risen?
we're one of the newer marketers in the program, actually, and I think ours have risen slightly. So any drop-off has to come, I think, from marketers who are exiting or existing marketers who see a lower customer count. And one of the reasons I present the market enhancements for your consideration is to try to, increase the visibility of shopping and get more customers, even if they don't elect to purchase a program, a price or a rate plan from a marketer, to at least get the option in front of them to try to increase the visibility of shopping. And it is candidly unfortunate that more customers did not, lock in a rate for the 2 annual intervals that we've been talking about, because those happen to be time periods where if they had bought insurance, the insurance would have paid, given everything that has happened with the natural gas markets over the previous couple of years.
How many years has Zoom been a marketer in the Columbia Choice program?
Let me give you that in a post-hearing provide, just so I don't get the wrong year, if that's
Okay.
okay.
Has it been
Several.
at least 5 years?
I believe it's been about, I believe so. I'll also say that NRG acquired Zoom.
I'm sorry, sir, I can't hear you.
Oh, I'm sorry. So Zoom's parent company, NRG, the corporate parent, acquired Zoom some years ago, and as a consequence before that, I'm not sure which markets Zoom had necessarily established itself in which particular years, but I can provide that for sure after the hearing.
Do you know how much Zoom has spent over the past 2 years marketing or educating customers about their offers in this choice program?
I don't have a dollar figure for you on how much we've spent. We do digital marketing, word-of-mouth marketing for Zoom. We don't do, in Kentucky, direct mail, to my knowledge, and we don't do telephone marketing or door-to-door.
Is
for
this a
Zoom
figure
marketing.
that could be provided if it were to be asked in a post-hearing data request?
So under, I assume, kept confidential, but I think we could provide that information. I may be signing up my team to do something they don't want to do, but I get the sense that Ms. Cooper gets a lot of that, so it's only fair for me to agree to that as well, I feel.
Were there plans for Zoom to increase its education efforts as a result of the commission's approval of the settlement agreement that was previously submitted in this case?
I know we identify Kentucky as a growth market, and we've been, our company in general has been reluctant to make investments in programs that are pilot programs, because you make the investment, you gain customers, only to see those customer relationships evaporate, because someone who has no upside or downside from the existence of the program suddenly discovers themselves to feel lukewarm about it. So we prefer some sense of consistency in the markets that we operate. That's one of the reasons why I propose not just an extension of the pilot, but simply making it permanent, so that we can actually have some comfort in making investments in a market like this.
If the provisions as outlined in the settlement were going to go into effect, so in a make-believe world, what efforts would Zoom be prepared to make to increase participation in the program?
In fairness, I have not talked to, because of the regulatory litigation that's ongoing, I just haven't been in a position to talk to our retail operations team about what kind of investments they would be willing to make. And so I don't know that I can make any hard and fast commitments to you, other than to say that my company as a whole has been making investments in natural gas retail sales lately in a big way. We're, one of the largest retail marketers of natural gas in the country. We're one of the largest shippers of gas on the interstate pipeline system. We're interested in basically every market that we can serve, of both transportation customers and these small volume customers. And we're interested. I'll put it this way: we would not have expended the resources we already have on this proceeding, resources which probably exceed, given our customer count, the annual margin of our entire operations in Kentucky, if we weren't committed to seeing this program take hold in a more meaningful and permanent way.
Mr. Chairman, I have no further questions for this witness.
Question?
Yeah.
I just have a couple of questions, Mr. Bula. Under the contracts that you're aware of that Zoom offers, I asked Ms. Cooper a similar question. Under the contracts that you're aware of that Zoom offers, at the expiration of the contract, does the customer revert to being a commodity customer of Columbia, or revert to some other contractual agreement with Zoom?
Under our typical contract terms, they would continue to be customers of Zoom, but they would be served on a month-to-month price unless they call us and obtain a new fixed-rate term offer.
Okay. So that leads me to ask my follow-up question. Hey, Zoom Energy Exhibit number 2. Your ordinary month-to-month price is the only price that does not currently, pursuant to the rates you have on your website, beat the quote price to beat of Columbia. Why is that?
I assume that's because of the forward monthly price of gas, though I would have assumed candidly that it would have been lower than what I'm seeing it on this page. But typically, we serve our month-to-month customers based more on the kind of market price that you would expect from a regulated utility. So part of my part of my testimony is to adopt a regulation that would require marketers to issue a notice to all customers a certain number of days before the expiration of their term contract with a new price term in order to allow them greater visibility into re-enrolling on one of these term products. Because after all, I have said, and I strongly believe that one of the primary values of this market is to have people lock in a price. They should have as many opportunities to do that as possible, both whether they're shopping away from the utility or whether they're renewing service with a marketer.
So if I was on a 12-month fixed and the contract expired, I would be defaulted to the second row, but the first row of information here.
I'm not exactly sure if that would be the rate you would pay. That is, it's stated as an introductory price, though it is not one that I would select out of the ones that are listed here. It could be a different market price reference.
But in terms of product, the differences between the first 2 products listed on this, is the only difference the airline model?
That appears, and a slightly longer term for the second product.
I guess I don't know how to answer this very directly. How is it that the second product provides a greater benefit and is cheaper than the first product?
You have stumped me on that one, Chairman Chandler. I will say that, the first one might be a product of a pricing formula anomaly of some kind. It's an unattractive rate compared to the alternatives, and we would typically rely on customers to not make that selection.
So can I just ask for, and I'll pick one here, for the Sherlock 12, we're gonna ask as a post-hearing data request for a draft, like the ordinary contract that you would enter into, that highlights what the default will be once the contract expires.
Yep, we can absolutely provide that.
And if it identifies a specific plan that's the default, to provide in the post-hearing data request, what that current plan, what the parameters of that current plan would be. So if it defaults to the Simple Flex intro, month-to-month, 2 months introductory, blah, 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 just state what that current rate is. We'll ask that as a written post-hearing data request.
Definitely, thank you.
So today, when the contract is about to expire, I was asking Ms. Cooper earlier, what does the utility send? The utility doesn't have insight into whether the contract's 4 months, 6 months, 12 months. So understandably, they're not sending anything ahead of the month that it expires. What does Zoom send ahead of the expiration of the contract?
So there is a provision in the existing code of conduct within the Columbia tariff that requires marketers, to the extent they renew customers onto term contracts that are, I think, 6 months or longer, that they have to send a written notice including the term and price information to the customer no later than 60 days before the expiration of the contract and no longer than 90 days before the expiration of the contract. We propose an additional market enhancement, a requirement on marketers. In my testimony, that would, if you look at page 21 of my testimony, I recommend requiring suppliers with customers on fixed-term contracts that automatically renew to month or for a fixed term of longer than 1 month, to provide at least one notice to customers no less than 60 days before the contract is set to expire. Because the current code of conduct has not anticipated that particular situation, and adopting this market enhancement would ensure that basically every customer who's facing a marketer's contract expiration would receive a clear notice, including the renewal terms, so they don't have to go back, to your point, and look up the document they had earlier signed.
Okay, so, I heard effectively, and you weren't there, and I guess anybody in this room is here, so you just have to take my, I'll tell you what the statement was, and then I'll just ask the question, assuming that's the same. So recently, how do I say that? I've heard it recently asserted that hedging versus unhedging. Okay, so even, just say a utility, an LDC, hedging versus unhedging, versus not hedging. That hedging will always be more expensive in the long run. Do you agree with that?
Over time, in general, that is likely to be the case for the same reason that I gave about the insurance industry. You are acknowledging and accepting you are acknowledging a risk, and you're assigning that risk to another party in exchange for compensation. And sometimes that risk will come to bear, and that other party will end up experiencing losses. But on average, over time, insurance has a value and a cost, net of exposure to what you could call the spot market.
Okay. Have you ever heard of game theory?
I have.
Okay. So I'm not going to get into the weeds of game theory, but let's just assume that everybody in the marketplace is rational, and that once a situation occurs, they learn from the situation, and then they act differently or rationally based off that experience going forward. Okay, just assume that. You have a Winter Storm Uri type event where LDCs in the Midwest have $1 billion plus bills that customers, that they ran up in order to procure on the open market unhedged gas, or gas in which they were unhedged to buy. That's a general statement, but that's kind of the situation, right?
That's right.
So, that utility had to pay those bills. That utility is being approved to pass that through to customers. Maybe there's a way to defer some carrying charges on it, but that bill is going to be paid by many of those LDC customers as a result of the regulatory construct in those states, right? Okay. Had that utility been hedged, somebody else would have effectively paid that bill. Is that right?
That's right.
Okay. So then the argument would be, to the question I asked you, is, well, then that just means that the insurance premium is going to go up the next year because somebody who's willing to take on that foreseeable risk now says, well, the premium on that risk is much, much higher because I didn't know that was a risk back then. I do now. You're going to now pay more for a hedge. Is that scenario form the basis of your response where you agree that in the long term hedges are always going to cost more?
To some extent. I will say, with specific reference to Winter Storm Uri, I have not personally observed that risk and its possibility that it recurs well priced into the wholesale gas markets to the degree that I would expect that it might have been. But in general, I think the thinking holds that as new risks reveal themselves, people will adjust the risk premia that are built into the purchase or sale of forward financial or physical contracts for the stuff that hedges against that risk.
Yeah.
And to your point, I think it also makes a difference about the business model of the people buying and selling the hedges. mean, if the purchaser of a hedge is a pass-through entity, a regulated utility, they will take a different view, quite possibly, of the usefulness or value of that hedge to its portfolio. One of the reasons many state commissions, apparently including Kentucky, including the one I served on in Montana, discontinued the use of utility financial hedging is that it seemed that utilities were pretty bad at it. They didn't have as sophisticated gas trading desks as the people they were operating across from. They didn't have as sophisticated gas trading desks as other marketers whose purchase of a hedge did matter ultimately to their financial performance. And so rather than allowing them to be dumb buyers, for a lack of a better word, commissions started to say, just expose yourself to the wholesale market because we just don't see you making especially good decisions on your purchase of insurance on behalf of your customers. So that's left us in the position we have today where these insurance-like products are provided by competitive retailers who do bear marginal financial exposure around their business-making decisions and who don't have recourse to a captive base of customers for whatever hedges we might sign. In other words, we sign a financial hedge, it needs to align with the attractiveness of a retail price offer because we don't have a right to any of these customers except by the contracts that they may choose to sign with us. All of which is to say that kind of properly incentivized buyer behavior in choosing to select these insurance products is, or select those hedges on the wholesale market, is a bulwark against some of the tendency that you were postulating, which is a run-up on the price of insurance.
Yeah. The reason I ask this is, I think the thing that's missing from assuming, if you assume that the hedge then goes up, or the cost to hedge against the previous volatility or the previous volatility continuing into the future, is that, I guess for lack of a better term, regulatory or government intervention to fix the problems that effectively caused the volatility to begin with. On that front, assuming you actually fix the problems that caused the hedge, or that caused the volatility or the extreme pricing, you may not necessarily have that same risk going forward and therefore wouldn't necessarily need to pay a premium for a previous risk that may no longer exist. Would you agree?
I would agree with the theory,
Okay,
and hope springs eternal, right? But I suspect that both you and I agree that some of the underlying problems with the wholesale gas market and the security of supply have not been remedied.
Yeah, I guess what I'm trying to, okay, so assuming that it was correct, that the actual problem is fixed, do you really end up paying more for the hedge? Because then the hedge wouldn't necessarily go up in anticipation that something that previously happened will happen again, that it's a new or different expected risk.
That's right.
Okay.
I mean, there are. I mean, it deserves to be said that there are every day, every year, commodity hedges that do pay out. Right. It is not. It is not. You know, and there are insurers, if you want to extend that concept to, you know, do not perform well in the market any given year, or may even go out of business if they're not very good at the insurance business.
I want to ask a couple of questions. I asked Ms. Cooper about friction. There's not much written about customer adoption of unique rate designs in the gas industry like there is in the electric industry. There's a lot written about the adoption of new rate designs in the electric industry. One of the things that's done often in the electric industry, and he's now retired, but Mr. Faruqi from the Brattle Group wrote a lot about making it easier, not doing opt-in rates, but instead just putting people on default rates and then letting them leave if they want, that there's far more people. Are you aware generally of the literature about customer adoption of these types of unique rate designs?
I am, and I was debating on a listserv with Dr. Faruqi some of these concepts just over the last couple days, so he's not fully retired apparently.
So the reason I ask though is because at least at the previous hearing, and certainly to their credit, Columbia has done a number of things since the hearing, the previous hearing in this case, to reduce the time or the number of clicks it would take, for instance, on their website to find the link. Okay, but that for every step, is it your experience that for every step it takes for a customer to sign up, for every additional step it takes to sign up for this program, it makes it less likely they ultimately follow through being a choice customer?
I strongly agree with that. I mean, and I appreciate the addition of an image to the carousel, but you know, it's still pretty subterranean on the Columbia website. You know, you have to go through. It's not visible in the first instance, and you have to go through, by my count, 3 clicks to get there.
Yeah, and so like, I guess theoretically, increasing the number, reducing friction would possibly increase enrollment. Great, if that's the theory, right? We all the time talk about in the utility industry, especially at the retail level, if we can increase the volumetric sale of whatever the commodity is, that, you know, using cost of service and rate making, the more we can sell, as long as it's appropriately priced, it will ultimately contribute towards fixed expenses and reduce costs for all other customers or the remaining system. Is looking at your business model or having an appreciation for the other marketers, is increasing enrollment in this program actually going to reduce your expenses?
It will not necessarily reduce my expenses, but it will contribute more revenue per expense unit.
Okay.
I mean, put it this way, if I had, you know, 10 or 50 times the customer book that we have in Kentucky, there would be more revenue to defray the cost of my appearing here today, for example.
That's
even
what,
while, yeah.
I want to make, here's what, big picture. I want to make sure that there's actually some evidentiary basis to an assumption that if there's a greater enrollment in this program, it might actually reduce the rates that are offered.
I think that is true. And you know, I think the basis for that is that there is essentially a volume discount on the amount of costs that need to be loaded into these rate offers in order to make them marketable and viable. And you know, I'll put it this way, even kind of mentally adjusting for differences in the wholesale cost structure between markets, I tend to see retail prices in the competitive markets that are higher or less competitive in places where the program has low visibility and no enhancements versus programs where market enhancements have created an easier shopping experience and more competition between retailers in the market.
So, so that presumes though that you all are interested in charging something closer to your marginal cost.
That's right.
Okay,
That's
so
right.
that also, your incentive to do that is that it is a competitive market today. Insofar as we somehow, through this program, create a new monopoly for choice customers, we run the risk of that not necessarily being the case, right? That somebody isn't charging their marginal cost and you start running up the rates, push competitors out and running up the rates as a commodity marketer, right?
That's correct. And here you do have the reference price of the utility price to compare as well, which is a discipline. So it's not as if you lack a default provider.
That was going to be my 2 questions. First, regardless of whether the field clears and there's a remaining marketer, a customer can always switch back after the end of their contract to the utility, right?
That's right.
Okay. And then second, what is the actual, based off of, you've seen Kentucky's program here with the Columbia Choice program, you've seen other programs in other states. How are the barriers of entry or the compliance cost in Kentucky compared to those in other places in terms of, would it be fairly easy for competitors to come into Kentucky, comply with the marketer's code of conduct and the PSC requirements and actually compete in this market?
I believe so, and some of the market enhancements that I've proposed that are in effect requirements imposed on marketers are things that have been adopted in other jurisdictions that, in my view, represent best practices that every state should adopt, even though it involves imposing regulatory requirements on a business like mine.
Well, and that's why I ask it. Frankly, I'm trying to ask this in a, are the proposals that you recommend self-serving in the sense that they're easier for you to comply with given maybe your place in the market, as opposed to it would increase barriers of entry for competitors to come in and comply with the recommendations that you're making?
That's a fair question, though I don't believe the recommendations that, for example, I haven't proposed requiring a huge amount of security. It's really just to prevent, frankly, the kind of marketers that were earlier being described from taking a hold, and to promote transparency and visibility to customers as a whole. So I think those are reasonable table stakes, and I think the barrier to entry would remain relatively low even were they to be adopted. I mean, the principal barrier to entry in doing this business is that it's not easy necessarily to trade natural gas and to, understand how the market works and not commit big errors that lead you to having an uncompetitive cost structure or taking real losses in the market if you're not well hedged. Because there is no way to, I've talked a lot about hedging there, but fundamentally there is no way except spending huge amounts of money for a company to hedge themselves fully at wholesale. You always bear the marginal exposure of a very cold winter that drives your customers to use a lot of gas, and that's a considerable risk that these marketers wear in this market.
If the commission, so expanding, increasing enrollment, you said should lead to generally reduced rates for reduced offering, the cost of offerings, all else being equal. I just want to go back to, I called it friction earlier, but maybe inertia is a better term, making it easier for customers to enroll. Would that actually reduce any costs that you all incur?
I think so. I think to the extent that what I would call them are transaction costs, to the extent that a customer, the transaction costs that face a customer are often met with spending or costs on the part of the marketer to get to the customer to help them gain visibility in front of a product and to enroll them, that doing things that increase the ease of shopping removes costs from both the customer and the marketer in order to create a healthier and less expensive on average retail market environment and a more competitive one.
Mr. Green?
Just a few things. I'll pick right up on that line of questioning. The enroll with your wallet proposal, do the NRG companies, meaning Zoom and its affiliates, I believe the question was whether you have increased transaction costs or increased costs as a result of rejected enrollments, or as a result of having the customer having to rely on the account number in order to enroll? And did you say that increased the transaction costs?
I would, yes.
Yeah. And would you also agree that it just causes inconvenience to the customer?
Absolutely. I mean, if a customer tries to enroll with a marketer, expects their enrollment to go through, and then it doesn't, after one or two billing cycles end up happening, the customer is likely to say, what kind of garbage is this program? And
Right.
probably not try it again.
And is the customer in that instance, in your experience, likely to blame the supplier for the rules that are set up?
In general, yes.
And let's talk about also, you have a proposal for accelerated switching, same concept there. If a marketer is trying to enroll a customer and it's the 17th day of the month, and the customer has to wait 43 days to make that switch to get the product that they want, who are they going to be upset with?
In general, the person who sold them that product. I mean, I faced the same situation in my home in Maryland where I moved into a new premises, and it literally took 78 days or something like that from when I first enrolled with a retailer to actually beginning to receive commodity service. And that was, I guess I knew who to blame. But I can see how that would be really inconvenient. And again, it just increases the lack of visibility into what is already a very low visibility product.
Right, the term I've heard is that we live in the Amazon world, right, where you click to buy, and it just shows up at your doorstep that day or the next day. And now you have a customer that may have to wait 45 days to make the switch. And like I said before, do you think they're likely to say it's this antiquated rules that's set up, or it's the gas system, or supplier, do you really know what you're talking about? Which one do you think is going to happen?
Perhaps some combination of all of them, Mr. Green. I know you want me to answer the latter, but I mean, I'm sure they'll blame everyone and anyone for the dysfunction of that market. And it really is the job, you know, candidly, here you have a marketer who'd like these things happen fast. You have a utility that faces no upside and possibly no real downside from other than spending their time and decentering them from relationships with customers from adopting these market enhancements. And that's why we have somehow ended up here at a contested case proceeding that has not been resolved in front of all of you, because in addition to being cost of service regulators, a commission ultimately is responsible for establishing the retail market design to the extent that competition does exist. And this is not a, as far as I sit here, a highly functional retail market. And that's why my focus, rather than just on extending the program, has been to try to improve it through the enhancements I've identified.
And the last thing, there were some questions about the renewal letter for a fixed price term. And I believe your testimony was that the customer will receive a letter from Zoom. And can you go through again what's in the letter?
Yeah, the letter should include the date of contract expiry, the price term, and to the degree it's an evergreen contract, a contract length if it's not month to month. And again, such a notice is required currently for customers that are renewing to longer term products, but there is, for reasons I don't understand, in essence a gap or some kind of a loophole where customers are not notified if they're renewing onto a month-to-month product, and we're looking through our testimony to fill that gap.
Do Zoom's letters also include information, you know, here's what you're going to default to if we don't hear from you, but here are other options you can sign up for if you go to our website?
That's correct.
Okay. All right, Your Honor, I have and by the way, we're happy to, you asked for a copy of the Sherlock 12 contract. We're happy to provide a corresponding renewal letter sample, if that would be helpful.
Yeah, we'll ask that for a posting there.
Thank you.
Any additional questions for Mr. Kavula?
No.
Ms. Humphries?
No.
Question? All right, thank you very much.
Thank you.
You have another witness, Mr. Green?
I do not.
Is that it for,
Well, I should say, I
Zoom?
believe
no, that's fine, yeah. But
it's a joint, but Mr. Millen is going to take care of that.
informally at least, right? I don't know that we've received a notification or any indication that there's a formal sort of witness sharing
No.
position. I think all I saw was that Mr.
Yeah.
Christ,
Mr. Christ is here if
yeah,
anyone
and
has-
adopted, or
Yeah.
Mr. Kavula's recommendation, but no formal
Right,
engagement.
other than,
Okay.
you're right, he filed on behalf of the three companies.
Okay, thank you. All right. Mr. Malone, would you, well, I guess I do. Which one of you all are going to attend?
I'll do it.
Okay, Mr. Malone? Would you like to call Mr. Christ?
Mr. Christ, Your Honor, yes.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. Mr. Malone?
Thank you, Your Honor. Mr. Christ, if you could please state your name and business address.
My name is James Christ, spelled C-R-I-S-T. My business address is Lumen Group Incorporated, Suite 101, 4226 Yarmouth Drive, Allison Park, Pennsylvania, 15101.
And Mr. Christ, did you cause to be filed direct testimony in this proceeding, and I don't think you had any data requests, but you did have direct testimony, correct?
I did. It was statement JC1 dated March 25th, 2022.
Okay, and you've been present all day, and for simplicity's sake, I'm gonna kind of cut to the chase. You've heard Mr. Kavula, I keep screwing that up, Kavula's testimony. Is there anything you'd like to add, anything to the commissioners that you'd like to tell them about your thoughts on that?
With regard to Mr. Kavula's testimony, you mean?
Yes.
I'm generally in agreement with Mr. Kavula's testimony, and I listened to his Q&As today, and I'm in agreement with what he spoke of today.
Okay. Anything with respect to Ms. Cooper?
Sorry?
Anything with respect to Ms. Cooper? You've heard her testimony as well.
Yes. I did have some concerns with some things that I heard from Ms. Cooper.
If you could just briefly tell us.
And I made a short list as I was listening.
Okay.
There was one question, questioning about Ohio's, Columbia's program in Ohio versus Columbia's program here in Kentucky. Ms. Cooper responded and said, well, Ohio's a different regulatory jurisdiction, therefore was unable to comment on the customer's decision process. And from my experience dealing with a number of regulatory jurisdictions, our regulatory jurisdiction has less to do with how a customer makes a decision about buying something rather than the attributes of that product. So if you're considering an insurance product, if I'm on this side of the Mississippi River or Ohio River versus the other side of the Ohio River, I don't really think my decision process changes because of the jurisdiction that I'm in. So I think that the point is that customers make decisions based on product attributes that are attractive to those customers. And in the things we're talking about today, we need to make sure that we make those product attributes easy to learn from the customer, easy to understand for the customer, and then have a customer acquisition and customer implementation process that is also easy for the customer. Now, I rattled off a bunch of things there. I do want to talk about education because that's another comment that I heard from Ms. Cooper. Specifically, when asking about educated customers, she said, I don't think that's Columbia's responsibility. I would differ with that. I think that's a clear responsibility of the utility to do a number of educational topics. We clearly want a utility to educate customers on safety so that they don't go blowing up their house. We want utilities to educate customers about the risks of carbon monoxide so that they can put in a carbon monoxide detector. We want customers to educate customers, or utilities to educate customers about their own prices. Why are their prices changing? How does a price cost adjustment work? When they file a rate case, why are they doing that? And when it comes to customer choice, the utility is really the first or most primary conduit of information to a customer because all the customers in the service territory of Columbia probably recognize the name Columbia of Kentucky. They may not recognize Zoom or IGS or Constellation, but they certainly recognize Columbia. Now, in terms of implementing education, the three marketers that I've mentioned, and probably every other marketer that's involved in Kentucky, have a wealth of educational material that they could provide to Columbia, that Columbia could then modify their website, send out direct mail pieces to their customers, help their customer service reps script an explanation of certain things. So I think that I differ entirely with Ms. Cooper's statement. I think that's a primary responsibility of a utility. Let me go on my list one more time. Oh, I'm in agreement with Ms. Cooper when she said that she doesn't think that there's any real incremental costs to offering the program, that the same employees in gas supply would be doing gas supply functions for the captive customers of Columbia. There's not a significant cost, and I agree with that. The point being that there's no downside to Columbia continuing to offer the program. Those costs are already there. They won't reduce significantly. However, if they would drop the program, then the fees which Columbia currently receives from those customers or from those marketers that are engaged in the program, those would be lost. And at the next rate case, Columbia would be facing that deficit of revenue and be requesting an increase in rates from the customers to cover that loss. Let's see. I guess I'm going to sum up my review of what I heard with a comment. She said, I think it's the right thing to look out for our customers. And I agree there also. However, I don't think if I were a customer in Columbia's service territory that I would want them making decisions that restrict my ability to choose. I'm glad that they're looking out for their customer. I don't feel that their judgments on what's important to Ms. Cooper or other employees of the company necessarily are the judgments of every customer in their service territory. Customers are not homogeneous. There's a mix of customers. Different people are excited by different things. I read about the airline miles. I fly all the time. I'm kind of excited about that. I'm going to look into the Zoom product. The other thing I wanted to do today, though, is update my testimony.
I believe you had a couple of exhibits that you just wanted to pass out.
Correct.
Okay, I'll
In
go
my
ahead and do that right now.
testimony statement JC1, which again was filed on March 20, about, more than a year ago. And so I had some tables and some data in there, and I thought it was important to update those to bring it to the current place where we are now at the end of July.
Would you like to mark these, Mr. Malone?
Yes, Your Honor. I'm working this,
So Mr. Malone is handing out
IGS Constellation number 1.
a table with data on it, and he's handing out a table with a graph.
Or, Your Honor, for simplicity purposes, since he also testified on behalf of Zoom, just to keep things tied together, we could just mark it as Zoom 4.
That'd be easier. Let's just do joint interveners 1.
Okay, that works. Whatever works for you.
All right. As long as you don't have an objection to it, Mr. Malone, it may make it a little easier.
No problem at all.
Okay.
I just combined them.
Will this apply to both of these pages?
That'd be fine.
May continue with your cross-examination or foundation on this.
If you could please describe what I passed down.
Yes, so the first one called Table 1 with all the data on it, dates and prices. These are Columbia's GCA prices, which I pulled from the various filings of Columbia. And in my testimony that I wrote on March 25th, 2022, I have Table 1 and I cover prices from December 1st, 2020 up to February 1st, 2022. Then you'll see on the data table I provided, when I was in the hearing about a year ago, I then updated those prices. So you can see the 2020 prices were rather low in a relative sense, $4.25. They increased, and then when I updated my data about a year ago, September 29th, they had bumped up to $6.61, continued there, and then up to $9.22, and so in September it was $9.78, fairly high price. And so on the left-hand side, that new column is what's happened since I was here last, where they were at $9.78 and kind of stuck at that level up until March, and then they've dropped down into the mid-$7 range. Point of this table is that gas prices are volatile. They go up by a couple bucks, down by a couple bucks, volatile. We've heard a lot of theme today about consumers like price stability, and I agree with that. And I'm going to add another example in a minute on price stability. The second thing that Mr. Malone passed out is the chart of the Henry Hub spot price. Now, this was in my testimony, referenced in my testimony, Exhibit JC1. at the back. And it was to illustrate the spot price of natural gas at Henry Hub. And you can see the update, actually, if you look at the right-hand side of this chart, illustrates that the price has now mitigated somewhat, and the spot prices are relatively low. I just checked yesterday, it was $2.68. So that's low in comparison to what they've been historically. What this says to me is that, they might go up. And so if I were a consumer looking at data like this, I would think this might be a good time perhaps to lock in to one of these products I heard Mr. Cool talk about, which gives me a 12-month or 24-month fixed price offer. To that end, I'm going to tell you about my personal experience, since I talked about that in my testimony. And let's see where I had that.
While he's looking for that, I'd go ahead and move to introduce and admit that as joint conveners exhibit 1 unless there's any objection.
Ms. Honaker?
No objection.
And just to be clear, she spoke faster than I was hoping. These are just updates. These are
updates to his previous charts that he introduced last.
which he updated again last. Okay, all right, last year.
Correct.
All right. So have this introduced as joint interveners exhibit 1. I guess, Mr. Malone, do you have any questions?
I don't have any
Mr.
questions at
Chris?
this point. I know he had one more thing that he'd like to talk about, which was your personal experience, and then if there is any additional beyond that, please let me know, okay?
Okay.
All right.
Well, and again, on page 18 of my testimony, I spoke about my personal experience, and I wanted to update that also. So every time I come here, I'm going to update things. In September of 2021, I purchased a fixed price product for 36 months. That fixed price product was $2.99. And so, preparing to come here, I thought I'd see how I did compared to what I would have done had I purchased the default product from the utility. My utility in Allison Park is the Peoples Gas Company in southwestern Pennsylvania. And so keep in mind, my price is $2.99, and Peoples' price in June of 2022 was $4.56. So that's comparable to what I had talked about in my testimony, which was actually the first quarter of was in 2021, the fourth quarter of 2021. In September of 2022, it increased, again, the default price from my utility increased to $8.71. In December, it increased to $8.13. In March, it changed to $6.73. All this time, I've been paying $2.99. So we talk about the value of these fixed price products. I don't know if I had good judgment at the time or I just got lucky, but the fact is that I did save money compared to the utility, and not just trivial money. I saved several dollars per MCF. Now, June 27th, a month ago, the utility price dropped to $2.51. And I'm paying $2.99. I'm out about 50 cents. I'm not mad about that. I'm good with that. And I still have another year left on my contract. I'm just content to know that I've locked in my price and I don't have to worry about upside price risk. So I think we heard a lot about the $70-some million that people have paid more than the default price of a utility. But the fact is, as Mr. Cavula spoke, and I agree, insurance has a cost, and the insurance has a value to consumers, that they do that so that they can have price certainty and avoid perhaps tremendous price upticks, which I certainly did. And so that concludes my updating of my testimony.
Thank you. He's open for cross-examination if anyone has any questions.
I have one question. When you started testifying, you were talking about Ms. Cooper saying that it wasn't the responsibility of Columbia to educate the customers. And then you went into all these things that you think are Columbia's responsibility to educate on, and it was safety and rate cases and their prices and all those things. Are you aware that Columbia does all those things for its customers?
I didn't review in depth the education materials that Columbia does, and I would be happy to learn that they do all those things, but they are still deficient on educating customers on choice, and that's what I believe Ms. Cooper's comment was directed to. I don't know that she expected, that she was trying to make a blanket statement, but I certainly heard the statement.
But your testimony was that they should do all these other things, correct? Besides
Absolutely.
choice. And my question to you is, I mean, if Columbia does all of those things for their customers, what do the marketers do for their customers? Do they educate on safety and rate increases and all of those things?
Marketers supply gas. So they educate customers on the gas pricing and the products they have. Marketers don't run the distribution system. They're not responsible for if there's a leak in a pipeline. So if a marketer, call center, for example, gets a call from someone that says, I smell gas in my house, most CIS for marketers would be trained to say, you need to call the gas company because gas pipes are their business.
All right, nothing further.
Ms. Frederick?
No question, John.
Vice Chair?
Just have one. This would be your opinion, but as we have had all of these extreme weather events, and we move farther down the road, and they will continue to happen most likely, the choice program may be a better sell now than it was 2 years ago. Would you agree with that?
Yeah, absolutely, I would agree with that. If you think back 2 years ago, before the Ukraine-Russia thing, we were lulled in a pretty stable period of gas pricing. Russia invades Ukraine, prices go haywire, Uri happens, big storm event. There's no denying this summer we've had the most peculiar, extreme weather, and so everyone's attuned to the weather. I'm in Pittsburgh. Forest fires from Canada screwed up our air over the past month. Extreme heat in Florida, Texas, that's Phoenix, Arizona, incredible. So I think people are very focused on weather now. The number one variable that affects the consumption of a utility customer is weather, more powerful than any other variable. So I think utility customers are going to be quite attuned to what's going to happen to my utility bill because of this extreme weather, and therefore price risk mitigation products such as a fixed price product, we should have a higher customer awareness attribute these days, and I don't see this volatile weather stuff decreasing in the future, in the near future.
Thanks.
Anything else, Mr. Malone?
No, Your Honor.
And is there anything else from, thank you very much, Mr. Christ. Is there anything else from IGS Constellation?
No, Your Honor.
Other than talking about post-hearing procedure, is there anything else we need to take up? We don't, I'm gonna tell you, a real relief after the last couple of hearings that we have to be able to say this, is that we're not looking down the barrel of a statutory date. So, people don't have to do briefing and post-hearing data requests in breakneck speed. So the first is, Ms. Honaker, is the applicant interested in providing a brief in this matter?
Yes, and we would ask to not have to do simultaneous briefs, to do our brief, a response, and then a
I
reply.
think there's plenty of time for you to do so. I can't, at this point, if there is somebody else with a burden of proof on very small issues, it's frankly immaterial. So, I see no problem with allowing you to have an introductory brief and allowing the interveners to respond to your brief and providing you an opportunity to reply to it, given that this is ultimately I'll call it an application, but your filing. So we'll talk about briefs last. We have a number of post-hearing data requests. I think we have some for at least one of the interveners, as well as a number for Columbia. We could give ourselves a little time to get those out, given that we have a couple of other things. if we can get those data requests out, Ms. Honaker, by next Friday, would you be able, do you think the company would be able to respond by the 18th? So, request them by August the 4th and respond to them by August the 18th?
I think we should be able to.
Mr. Green, same goes for Zoom. Would you all be able to get your responses in 2 weeks?
We're fine.
Okay. So, the first item in the posting your procedural schedule is that we will have, data requests, sought, posting your data requests. I know there was a number, Mr. Malone, you had as well.
Just one. I think.
Okay. Mr. Green, did you have any? It's okay. It actually, don't worry. So all posterior data requests will be filed, by the end of the day on the 4th, to be responded to by the 18th. I'll say it here, but insofar as anybody needs additional time for very specific requests or very specific item requests, we ask that two things, that you timely file everything else that you do have, and that you not wait to the last minute to seek leave for additional, seek leave to file late or an enlargement of time or whatever it may be at the very last moment. So if you know a week ahead that you can't get something in the prescribed time frame, please just seek additional time as early as possible.
I have one clarification. When you say end of day, are we talking 11:59 PM or are we talking end of business day?
Oh, always end of
Okay.
day. Yeah. Yeah, we've had a couple of practitioners here in front of the commission, I won't name names, but they're well known that like to try to file things at 11:50, so we're happy, as long as the date shows up, it was that day on our website, you're good to go. All right, so, the record will effectively be closed, the evidentiary record will effectively be closed on August the 19th. Ms. Honaker, how about the end of September for you to provide your initial brief?
Is it okay with me? Is it okay?
All right, so we'll shoot for September the 29th. To the interveners, how about a response to that brief due on October the 13th? 2 weeks later.
How about 3 weeks? You've got a month right there. So like,
Yeah, but,
We're fine with that if you give us 3 weeks on the reply.
you know, how much time would you want on the reply? There's nothing I can do about it once you file it.
yeah, how about the 18th? So the response will be due on the 18th.
Okay.
Should give you 19 days for a response brief. Ms. Honaker, how about November the 3rd to reply?
I'm just looking at my schedule, sorry. How long does that give me? 2.5 weeks?
That's
Or-
right.
Yeah, that should be okay.
So the case will be submitted November the 4th. There were no amendments to testimony on the stand today, is that right? I know there were updates and hearing exhibits, but no amendment to testimony?
Correct.
Ms. Cooper, nothing? Okay.
So, Mr. Chairman, you said, so just to go back through and make sure we got. all
Yeah,
the
and we'll get
dates.
in writing
Yeah.
probably tomorrow, so.
August 4th for DRs to be done, and then responses due by the 18th.
That's right.
Okay. Record closed on the 19th. Columbia's briefs due September 29th.
September the 29th,
Okay. Joint response due October 18th.
that's right.
And then Columbia reply November 4th. Is that right?
That's November the 3rd.
November the 3rd. Okay. Yep. Gotcha.
I'll take the 4th.
Is there anything else we need to take up before we adjourn? Seeing nothing, this hearing is adjourned.